Open this public hearing of the Parliamentary Joint Committee on Human Rights. I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and pay respect to elders past and present and all of Australia's Indigenous peoples. I'm Dr Anne Webster, the Chair of the committee, and I have with me Mr Graham Perrett, the Deputy Chair, Senator Janet Rice, Senator Deb ONeill, and joining us on video conference is Ms Celia Hammond and Senator Louise Pratt. I'm not sure if they're there. Celia is, not sure about Louise. Pardon? Good morning, Senator Pratt. And on teleconference we have Senator Ben Small, Senator Andrew McLaughlin and Mr Ian Goodenough. On behalf of the committee, I welcome all here today. The committee is hearing evidence today on its inquiry into the Religious Discrimination Bill 2021, the Religious Discrimination Consequential Amendments Bill 2021 and the Human Rights Legislation Amendment Bill 2021. Together these are referred to as the Religious Discrimination Legislative Package. This is a public hearing and a Hansard transcript of the proceedings is being made. The hearing is also being broadcast via the Australian Parliament House website. Before the committee starts taking evidence, I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The committee generally prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in a private session. In order to facilitate the committee in hearing from as many witnesses as possible, the committee has resolved to only receive written opening statements. Witnesses will be asked to introduce themselves and then the committee will move straight to questions. I thank those who have already provided their opening statements to the committee. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. For those in person, I would also ask witnesses to remain behind a few minutes at the conclusion of their evidence in case the Secretariat needs to clarify any terms or references. I remind people in the hearing room to ensure that their mobile phones are switched to silent. I now welcome Professor Nicholas Aroney and Associate Professor Mark Fowler via video conference. Good morning. Can I confirm that you can both hear us?
Yes.
Raise your hand.
Raise your hand would be great. Yeah. Thank you. Lovely. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask each of you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
You're on mute, Mr. Aroney.
Sorry? You might need to ask them to do it again. Could I ask each of you to state your name, please?
Mark Fowler, I'm an adjunct associate professor at the School of Law at Notre Dame University and the School of Law at the University of New England.
Thank you. Professor Aroney, can you hear me? We can't hear you. No, Oh, go again.
Can you hear me now?
Yes, thank you.
I apologise for that. I had it on the wrong setting. My name's Professor Nicholas Aroney. I'm at the University of Queensland, but I appear in my personal capacity.
If you provided a written opening statement, would you like it to be incorporated into the Hansard record? Just raise your hand if that's suitable. Mind you, I can't see Professor ONeill now.
Yes, Professor ONeill is here, and yes, please do enter it into Hansard.
And,
I didn't provide a written statement.
okay. I now invite members of the committee to ask questions. Deputy Chair, I will hand to you first up. The way we're going to manage this is very creatively, trying to give everybody some time.
So, which one is?
Professor ONeill is not visible for whatever reason.
Okay. Well, my first question is to Professor ONeill. Hopefully you can hear me. Your submission on the second exposure draft expressed your concerns about the constitutionality of that version. Do you hold concerns about the constitutionality of the bill that has been introduced?
In answer to that question, I noticed that the bill does approach the question of its interaction with state and territory laws in an unusual way, in a way that, to my knowledge, is not common in Commonwealth laws. So it does raise some questions about how it would operate, and I think that will be an interesting question to see whether the further consideration is given to that, because I think there are some questions about its operation in relation to state and territory laws.
Could you just tease that out? Why is it particularly different in the 120 years of the Federation? Why is this piece of legislation particularly different?
Well, under section 109 of the Constitution, a state law will be invalid if it is inconsistent with a Commonwealth law. And the High Court of Australia has interpreted that provision to this effect, that there are essentially three ways in which an inconsistency can arise, where there is a conflict between duties, which creates a situation that is not possible to obey both laws, or if there is a conflict of a right and a duty, where, for example, a Commonwealth law confers a right and a state law confers an inconsistent duty with that, or thirdly, when a Commonwealth law evinces an intention to cover the field and thus displace any state law within that field. So in that context, it's normally, or has been in the past, situations where a Commonwealth law has one of those three features, and a state law has features in that context as well, that inconsistency under section 109 arises. Whereas
such as
the provision
Aborigines being able to vote?
Oh, it could be anything like a right like that, yes. Okay. Yes, it could.
And so for the non-constitutional law people listening in, so because this has specifically mentioned pieces of legislation such as the Victorian one, would that, and I'm a Queensland MP, so, you know, we've had Wayne Goss brought in religious discrimination legislation in 1991, so could you make comment on how it's going to, perhaps, how you see it might roll out?
Well, the problem is not that it refers expressly to state laws. And the Commonwealth is able to, in its legislation, evince an intention to cover the field. And I think that it's most likely that these provisions would be interpreted in that light. To my mind, the question is whether the Commonwealth has power to determine how a state law is to be interpreted, or its operation or effect. Because when you look at clauses, I think it's 11 and 12, they say that certain conduct does not contravene particular state or territory laws. And so that could be interpreted as evincing an intention to cover the field and thus displace the operation of those laws. Okay. And if it was interpreted in that way, it would be effective under section 109. But if it was interpreted so as to displace, as it were, the tenor and operation of the state law in and of itself, then that would raise a novel question for the court, in my opinion.
And Professor ONeill, just to finish off, Professor George Williams provided a submission, and Professor Williams is concerned that the bill is inconsistent with Article 18 of the ICCPR because the bill provides an elevated status to religious speech, but fails to protect speech on matters of thought or conscience. Could you comment on that? I'm not sure if you read Professor Williams' submission.
Yes, I did. I think that one of the characteristics of Commonwealth laws that implement international human rights obligations is that they have very consistently selectively chosen which dimensions of rights guaranteed under international law are to be protected. And it seems to me that this bill is an example of that, and consistent with the practice of the Commonwealth in doing so in the past. That the reason why the Commonwealth does that is that its responsibility is to ensure that human rights are adequately protected under Australian law and institutions generally. And so it legislates so as to fill gaps where it believes that, or forms the view that gaps need to be filled.
So does that make it, sorry, Chair. Does that make it a bit more complicated when New South Wales and South Australia don't have religious discrimination legislation? Is that why it's more complicated with this piece of legislation, as you stated in your submission?
Look, that's one aspect, although I'd regard that as a different sort of particular question, but nonetheless a question of the same general nature. And that is that the Commonwealth has a responsibility to ensure that the law generally adequately protects the protected rights under the international conventions under which Australia has obligations. And so Australian law generally protects freedom of speech. The common law protects freedom of speech across a wide range of activities and a lot of forms of speech. And now the Commonwealth and the states from time to time intervene and regulate those areas, and then sometimes accord rights in those areas. And they do that because in their judgment, in a particular context, a particular type of speech needs additional legislative protection in addition to that which exists across all of the jurisdictions and in the background of the common law. And so I don't think it doesn't lead to the conclusion that a law is failing to implement an international human rights obligation if it chooses a particular expression, as it were, or a particular context in which it adds additional protections.
Thanks, Professor Aroney.
Thank you, Professor Aroney. I'm going to hand to Senator Ben Small now.
Thanks, Chair, and good morning, gentlemen. Maybe Professor Fowler, if I can ask you a couple of questions. Clause 12, which the Deputy Chair was sort of touching on there, as I understand it, protects statements of religious belief against complaints brought under either state or territory anti-discrimination law. And one of the key criticisms of that clause is that it will potentially licence offensive statements. So I guess, can you outline your perspective on any international law or other precedents that relate to freedom of speech and the interaction with that provision?
Okay, thanks, Senator Small. So yes, that has been one focus, and it seems to me that the drafters of the bill anticipated this critique and built within Clause 12 quite a series of rigorous tests to be satisfied by any statement. So a statement must not harass, threaten, intimidate, vilify, or amount to the urging of a serious criminal offence, all of those being determined according to whether a reasonable person would consider that the standard had been breached. In addition, it must be made in good faith and not malicious. So there's some existing law around all of those concepts, and they do set quite stringent standards on statements that could be made. I think, unfortunately, this particular committee has looked at length into the question of Section 18C in the Racial Discrimination Act and whether international law would ground a law that would limit offensive or insulting statements. And that's been, I think, the most strident critique, that this bill would licence offensive statements. If we look to international law, and Professor Aroney has just outlined that in large part this bill relies on the external affairs, international law places a very high regard the right or the freedom of expression is the phrase that's used in Article 19 of the International Covenant on Civil and Political Rights. And that is targeted at hate speech. So it has a very high bar to be met for prohibitions to be introduced. So where critiques of the bill have asked for or have said that this would enable offensive statements, the necessary concomitant of that is that the law should not allow offensive statements. And that proposition vastly expands the scope of state power into private deliberations between individuals and indeed their public statements. So we need to look very closely as to what international law does in its protection of freedom of expression. And I've just got a quote here from the United Nations Human Rights Council, which has said the exercise of the right of freedom of opinion and expression is one of the essential foundations of a democratic society. It is enabled by a democratic environment which offers guarantees for its protection, is essential to full and effective participation in a free and democratic society, and is instrumental to the development and strengthening of effective democratic institutions. So we also have the Australian Law Reform Commission, which considered in the context of 18C whether or not it is grounded within international law, and came to the conclusion that there was quite serious doubt that 18C wasn't grounded in international law. And as I said, this committee has considered that at length. Indeed, Justice Michael Kirby has expressed the view that insulting statements in Coleman and Power, he said that insulting statements would go beyond the limitations that are permissible under the protection to freedom of expression with international law. And just to tie that, obviously we're in the context of religious speech. So just to tie that regime for protection of free speech into religious speech, the United Nations Office of the High Commissioner for Human Rights a couple of years ago promulgated something called the Rabat Plan of Action, a prohibition of advocacy of national, racial and religious hatred that constitutes incitement to discrimination on hostility or violence. And look, I cited it in my submission, but there's a great extract I'd like to read to you because it ties together nicely this concept of religious speech and limitations under the Covenant on Freedom of Expression. And that statement says, it is often purported that freedom of expression and freedom of religion or belief are in a tense relationship or even contradictory. In reality, they are mutually dependent and reinforcing. The freedom to exercise or not exercise one's religion or belief cannot exist if the freedom of expression is not respected, as free public discourse depends on respect for the diversity of convictions which people may have. Likewise, freedom of expression is essential to creating an environment in which constructive discussion about religious matters could be held. Indeed, free and critical thinking and open debate is the soundest way to probe whether religious interpretations adhere to or distort the original values that underpin religious belief. So, as I understand this particular clause, it seems to me to be a response to complaints that have been taken to state territory tribunals gravitating upon prohibitions on offensive or insulting statements. And obviously the fact that the clause doesn't provide as one of its bulwarks offensive or insulting statement has caused the concern. But as I said, the necessary concomitant of that is that the law should invade into these conversations, and that is a great expansion of state power. So I see this as an exercise really in trying to preserve the open, deliberative, discursive discussion that we've had in our nation around religious matters for many years.
So thanks very much for that, Professor Fowler, because I guess I think you've largely touched on it already, but the other key criticism of Clause 12, which is key to the operative provisions of the bill, is that it in some way preferences a religious view over any other view. So I guess I'm just looking for maybe complete clarity on whether or not you agree with those criticisms.
No, I think that we have to express a note of caution with that view. And again, I think that the drafters have anticipated this particular critique, because the words that are used in the definition of statement belief at Clause 5 says, it protects a statement of a belief who does not hold a religious belief. To receive protection, it must be that statement of a belief that the person genuinely considers to relate to the fact of not holding a belief. So an agnostic or an atheist makes a statement that they genuinely consider to relate to the fact of not holding a belief. It's quite an expansive conception. So this goes to the question of the neutrality of this protection. And in my submission, I gave an example of an atheist who makes the following statement: that secular ethics provides a sufficient basis to ground a pacifist morality, and that accordingly religion may be a sufficient condition for pacifism, but is certainly not a necessary condition. For someone who says secular ethics gives a sufficient basis for pacifism is making a statement that is relating to the fact of not holding a belief. I also extend the statement by then saying, and what if they were to say sufficient basis to ground a pacifist morality, whereas religion is at its heart an agent of violence, contrary to the principles of any true form of pacifism or morality. I gave that to illustrate perhaps a religious person may find the statement that violence is at the heart of religion and therefore cannot propose any basis for morality, may find that offensive or insulting indeed if it was said to them. But that is not what this bill would filter out. So I think, in my view, that would pass the particular test that we're given there. And indeed, I mean, in the explanatory memorandum, there's an example given, better to look to the explanatory memorandum, in which Terence at paragraph 194 says that as an atheist, he thinks that prayer and belief in God is illogical. And even though Megan, who hears it, is offended, that won't gain protection under this particular clause. But it does then go on to say, if Terence were to make repeated comments of this nature directed at Megan, knowing she's religious, it may be possible to demonstrate these comments are not being made in good faith. So at least there's been an effort to, while these are not binding, there's been an effort to give some concrete examples around what this clause would do, and it's given to us there in the explanatory memorandum.
And as much what the clause won't do. So that's very useful. Thank you.
Thank you.
In the interest of time, I'll hand back, Chair. Thanks.
Thank you, Senator Small. I'm handing to Senator Deb ONeill.
Thank you very much. Thank you for your thoughtful contributions this morning already and for your extensive submission, Mr. Fowler. Thank you very much. Could I clarify something that you said to Mr. Perrott regarding the constitutionality? Do you clearly, can you make it clear for me, do you believe Section 12 of the current version of the Religious Discrimination Bill is unconstitutional?
I think that construing it as a question of constitutionality is to misconceive the question, because the Commonwealth has power to legislate under heads of power in Section 51. And if a law can be characterised as a law with respect to any one of those subject matters, then it will be validly enacted, provided the law does not contravene any other prohibitions contained in the Constitution. So what we're talking about here is Section 109.
Yes.
That has nothing to do with those first two criteria. So a Commonwealth law will still be constitutionally valid if it is enacted in accordance with Section 51 and doesn't contravene any of the prohibitions in the Constitution. What is at question here is an entirely different issue, and that is the effectiveness of Section 11 and 12, about whether it will create an inconsistency under Section 109. That is not a question about whether the law is constitutional or not. It's a question about what effect it will have on state and territory laws. Okay. And so it's incorrect to say that this means that the law is unconstitutional.
So the concern is practicality. Now, as a person of faith, this has been much promised, and as a member of the Labor Party, I'm really keen to make sure that the whole suite of protections, including religious discrimination, is filled out. But I don't want to be sold a promise that doesn't deliver. So my next set of questions goes to the actual practicality of, can this actually be deliver what is being promised? So there was a submission from the Law Council of Australia that described the previous version of the Statement of Belief as procedurally unworkable. Are you familiar with that submission?
I'm afraid I'm not familiar with that specific provision.
Can I just read a little section? It says, first, the defence would need to be raised for determination by a separate proceeding in the State or Territory Supreme Court or the Federal Court. Second, while any defence might be resolved in such a court, the relevant court would not be able to determine the substantive complaint because it would not have jurisdiction to do so. Third, if the defence is rejected by the court or is only successful for part of the claim, it will need to return to the relevant tribunal for hearing and determination. And fourth, both parties will have to bear the additional costs and delay of such litigation, making such litigation unworkable and expensive. Do you agree with that characterisation of the process that would have to be followed if a person wanted to actually avail themselves of this much promised statement of belief defence?
I don't believe I can comment specifically on that statement without reading carefully the full submission and understanding the context in which that is stated. But what I can say in relation to the general, what is at stake here is a question about whether a state or a territory law is inconsistent with a Commonwealth law under Section 109. In those circumstances, a party to any matter that arises under a state or territory law, under which a state or territory law is in question as to whether it is inconsistent with the Commonwealth law, that party could plead that the state or territory law is in that respect inconsistent before the court. But I can't comment further on what was said in that submission because I would need to read it all carefully.
Mr. Fowler, do you have a view on that? And can I ask you an additional question that might be linked? One of the things that came out of the government's response to the Ruddock Review was Mr. Morrison essentially promising to rule out a statement of belief like Section 12. He didn't follow through on that commitment then, but now we've got one with Statement 12 in. Do you think that the government's initial instinct to work through the issue of protecting statements of belief cooperatively with state and territory governments would have been preferable, not least because it would avoid the procedural issues the Law Council and others have identified with Section 12? Because at the heart of my question is the concern that something is being proffered as a protection for people from religious discrimination to make a statement of belief, but there's no confidence. I have no confidence that the work's been done to make sure that when the rubber hits the road, people will be actually able to avail themselves of this in a practical way. Do you have a view?
Yes, I do. So I suppose the first question regards to the jurisdictional questions around. So you're quite right. So Clause 12 is proposed against state and territory law. So it would be initiated within a state or territory tribunal as part of the defence to a discrimination claim where, of course, there was a statement of belief made. And, of course, the provision, Clause 12, only relates to statements. It doesn't relate to any ancillary or other actions that would accompany that statement. So in that sense, there's quite a limited protection that's given there. But obviously, all of the relevant acts of discrimination are then canvassed by local, state or territory law. The first point to make is that there are circumstances in which a state court or tribunal can actually determine a matter of jurisdiction such as this nature pursuant to the rule in Fencott and Muller, where it is incidental to the determination of another claim. So it's not necessarily the case that in every instance this will then move into a federal court for determination. But certainly, Senator, you're quite right. There is a likelihood that certain responses, so only in respect of the statement of belief, not in respect of any other claim that's made in respect of a series of actions, that particular parcel of activities would be moved to a federal court if Fencott and Muller didn't apply. The point I think to be made here is that once a body of law is grown up around what constitutes a statement of belief, according to those various tests, and as I said earlier, there's quite a bit of law. Obviously, the drafters were bundling in existing law there. So once we have a body of law around Clause 12, the state will simply apply that law. So what we're left with then is those that are running the gauntlet first amongst these respondents that have to throw over. Well, that will then be determined according to the costs regime within the court that hears this. Now, if that was a particular problem of concern with Clause 12, that could readily be addressed either by the court and administering its own discretion around costs in these matters, or if there was felt a need that there should be clarification, because the point of, I think, is what you're harking to is, at the tribunal level, discrimination law is proposed to be a no-cost jurisdiction, so to not provide any sort of limitation on the ability for persons to make complaints. And so that is also going to apply in respect of religious believers as well. So, in short, there will be a body of law that will grow up, and quite possibly, in the first instances, we might be able to allow for particular clarifications in the federal court regime to ensure that costs don't become prohibitive for complainants until we get that body of law.
But
And
they
that's
could
not a
become.
proposal.
But cost could become quite a significant factor in this, and you've just clearly established that there is no body of law yet to ensure that this proposed legislation will work as it is being proclaimed. So it's as yet untested. It's sort of a pathway to a future, but it's not guaranteed to deliver that future.
Well, it certainly is a novel proposition that we would have a clause that says this is not discrimination where you satisfy these tests. But I think quite clearly they're trying to bundle in existing law as much as possible to give some clarity to courts interpreting this. And that clarity will come once these things move through.
I've got some questions
Now,
on notice
as
on
to
section
context-
12, but one more question on
One
section
more.
11.
One
So
more.
I'll put some questions on notice with regard to section
Yes.
12. But with regard to section 11 of the bill, which is the state override, again, a matter of incredible interest to people of faith. Section 11 of the bill could in fact be used to override state and territory laws in relation to employment decisions by religious schools if those laws are prescribed by regulation. In order to prescribe a state or territory law by regulation, the Attorney-General has to be satisfied that the law prohibits discrimination on the grounds of religious belief or activity and prevents religious schools from giving preference to persons who hold or engage a particular religious belief or activity in employment context. Now, if the Attorney-General prescribes a state or territory law by regulation, is it possible that a state or a territory parliament could then simply just circumvent section 11 by enacting a new law? So I guess this goes to the question of the true power of section 11 to give stability to people of faith and religious discrimination as it would operate in schools. Do you have a view?
Just to respond to that question now.
Professor Moroney,
I think the
Aroney, and
first-
then Mr Fowler.
I would make just one simple point, and that is that the capacity of the minister to issue a regulation is a much more flexible and fast process than the process that a state parliament would have to take in order to enact a law. So that would be the first point. So that if a state law did respond by enacting a new law or changing the name of the law or some other subterfuge like that, the minister could always respond very readily by issuing an alternative regulation. And I think in those circumstances, it makes it unlikely that a state or a territory would engage in a tit-for-tat response, because the Commonwealth would procedurally be in a superior position.
So the regulation is responsive, but it ultimately sets up a permanent pathway for conflict unless the states decide that they're going to back down. Is that it pretty much in a nutshell, Professor Aroney?
I suppose you could say that, but you could say that about Commonwealth and state interaction just across every field in which they're interacting. They're constantly readjusting their positions vis-a-vis each other. So I don't think that that's a especially novel situation, although I acknowledge that this is a particular situation that is unprecedented.
Yes, and
But
it's
it's
very
not
much.
so very
We'll have to
different
stop
from
there.
the...
Mr Fowler, give a response to that. Thanks.
Mr. Fowler, if you can, Professor Fowler, if you can give a brief response, please.
Thank you, Chair.
Yeah, look, I mean, obviously in the context of the Parliamentary Joint Committee on Human Rights, the question is, why is this being done from a human rights perspective? And that, it seems to me, the problem arises because the particular Victorian bill that's named in the consequential amendments bill allows or incurs upon religious schools and indeed religious institutions by requiring that they demonstrate that their appointments of staff, and not clergy aside, but their appointments of staff must be reasonable and proportionate in the circumstances and must demonstrate that they are in accordance with the inherent requirement of the role. If we look to international human rights law, that's a very strict standard that's not affirmed either by the European Court or by the United Nations Human Rights Committee. So the question really ultimately, Senator, is when the Commonwealth exercises this power, is it acquitting its obligations under Article 50 of the International Covenant to ensure that the covenant is complied with, including in state law? And that's the question at hand. So it seems that the attorney has made the determination there may well not be compliance with international law through this novel regime that's being proposed in Victoria.
Thank you, Professor. I'm
Thank
going
you.
to hand to Mr. Goodenough, who has a question.
Thank you, Madam Chair. In one of their submissions, the Human Rights Commission conveyed its support for religious protection and said, quote, "The Commission strongly supports the introduction of enforceable protections against religious discrimination for all people in Australia. This has been the consistent position of the Commission for more than 20 years. While there are some protections against religious discrimination at the Commonwealth, state and territory level, these protections are incomplete," end quote. Can you further explain why the current protections are not sufficient?
Okay, so if we look to... You go, Nick, first. Mr. Aroni, you go first.
Well, I'll offer a general answer to that question, and that is that New South Wales and, in a certain respect, South Australia do not provide for, make it unlawful for discrimination on the basis of religion in general terms. And so there's a gap in those jurisdictions. And so the Commonwealth, by enacting a bill of this nature that's before the committee, will be filling that gap and ensuring that Australia is complying with its international obligation to protect all Australian citizens against discrimination on the basis of religion, as is required by the International Covenant on Civil and Political Rights, Articles 2 and 26, in conformity also with Australia's obligations under Article 18, and I would add 19, and also in terms of freedom of association as well. So in general terms, that's why the Commonwealth Bill, I believe, is being proposed. And this is in accordance with the recommendations of the Ruddock panel, expert panel, of which I was a member.
Yes, and I'd add to that the fact that we have existing religious anti-discrimination protections for many years in many of the states. As Mr. Perrott said earlier, 1991 in Queensland. What we don't have, in addition to what Professor Aroni just outlined, is a protection for persons who are discriminated against on the basis of their religious belief and activity under Commonwealth law or programs. And that includes the administration of a Commonwealth law or program by the Commonwealth itself. So technically the Commonwealth can discriminate at large as it sees fit currently on the basis of someone's religious belief of activity, in respect of funding, in respect of migration, in respect of all of its powers. So this does plug a very sizable hole in existing protections within Australian law.
Thank you.
Did you have any further questions, Mr. Goodenough?
No, I don't. Thank you.
Senator Rice, just for a few
Thanks,
minutes.
Chair.
What
Yep.
we will end up doing is having some questions on notice. I'm just flagging that
Thanks.
now.
Look, my first question is to Professor Aroni. In your previous answer to the questions, you were commenting about Professor Williams' view that this bill prioritises religious speech over other forms of speech. And what I heard you say was this wasn't necessarily a problem because it was filling gaps. I just wanted you to further comment on that, because this bill in fact does more than fill gaps, as it overrides the state laws. And in particular, you know, for example, in Tasmania, where statements that are currently considered discrimination against people with disabilities, women, LGBTIQA+ people, they will be overridden. So could I just comment, yes, just get more response from you on the issue that Professor William raises of the fact that it prioritises religious speech?
With respect, I don't think it prioritises religious speech, if that is meant by it prioritises the speech of people who hold religious beliefs. But it does focus on speech which is about religion, whether it is by somebody who holds religious belief or someone who does not hold religious belief. And it appears that the reason for that is that this is a bill directed at or addressing religious discrimination. And so its subject matter is, in that sense, religion. And it's intended to protect people of religious faith and those who have no religious faith, because that freedom is a freedom of not just of religion, but of belief as well. I do take the view that freedom of speech more generally is not adequately protected under Australian law. And so a case could be made for further protections of speech generally, but that would be a different undertaking and could be contained in a more general statute addressing freedom generally, freedom of speech, freedom of association, for example. However, what I do think is that the further thing that to be noted is that Associate Professor Fowler drew attention to the Rabat plan of action, which is specifically addressed to Article 20.2 of the International Covenant, dealing with advocacy of hatred, which constitutes incitement to discrimination, hostility or violence. And one other thing that I would add to what Associate Professor Fowler said about that is that the expert group who drafted that UN document pointed out that the fundamental principle is freedom of expression, and that restrictions on freedom of expression must be, and I quote, clearly and narrowly defined. They should be the least intrusive possible, not overly broad, and proportionate, and must accord closely with the precise language of Article 20.2. And when one examines the Tasmanian law that is in question, it is arguable, and I think the case, that the Tasmanian law does not align with those guidelines that are set out in the Rabat Plan of Action. And so it's understandable why the Commonwealth might take the view that that specific law needs to be overruled in this specific respect to accord with Australia's obligation under Article 19 of the International Covenant to protect freedom of expression, in this instance specifically in relation to religion.
I would note that others have a different view and that Tasmanians have been very happy with their law for 2 decades or so. Given the issues with overriding state laws, as we were discussing before, and the fact that, at least in the initial circumstances, taking action would have to go to the federal court, and the precedent of having federal anti-discrimination legislation overriding the state legislation, wouldn't it actually be more a simpler way of proceeding to cover many of the issues concerned with this legislation for the Commonwealth to encourage New South Wales and South Australia actually to protect religious faith in their state anti-discrimination laws?
Certainly that specific proposal was something that the Ruddock expert panel recommended, that the states review their discrimination laws to ensure that they adequately protect religious freedom as well as prohibit discrimination on the basis of religion. And so as a member of that expert panel, I think that that would be very appropriate for them to do so. But as I suppose you would know, Senator, politics is a complicated field, And the Commonwealth does have an overarching responsibility to ensure that all of Australian law complies with its international obligations. So it's understandable that the Commonwealth might in this situation legislate so as to ensure that there aren't any state or territory laws that put Australia not into compliance with its international human rights obligations, as in fact the Commonwealth has done on many other occasions in our history.
Thank you. Thanks, Chair. Noting the time.
Thank you very much. Thank you for appearing before the committee and for giving your time today. There may be some questions that are sent to you on notice that we didn't have time for today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 7th of January 2022.
Chair, could I indicate one of the critical questions we might want to have for each of our witnesses? Are there any aspects of the bill that you think need to be amended, including any technical drafting concerns? Because I think that it's such a complex
Certainly.
bill that would be a good question that we just have for all of our witnesses.
Yep.
Thank you.
you.
Thank you.
I now welcome from the Australian Discrimination Law Experts Group, Robin Banks. Can I confirm that you can hear us?
Yes, I can hear you. Thank you.
I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
My name is Robin Banks. I'm a PhD candidate at the University of Tasmania and a former Anti-Discrimination Commissioner for Tasmania, and I appear as a member of the Australian Discrimination Law Experts Group with three of my colleagues.
Thank you. If you provided a written opening statement, would you like it to be incorporated into the Hansard record?
We haven't provided a written open statement. We could do if there's no opportunity to provide an opening statement, given we haven't yet submitted.
I have neglected to say that I'm Dr. Anne Webster, the chair of the committee, and I have with me Mr. Graham Parrott, the deputy chair, Senator Janet Rice, Senator Deb ONeill, on video conference, Senator Louise Pratt, Ms. Celia Hammond, and joining us by teleconference, Senator Ben Small, Senator Andrew McLaughlin, and Mr. Ian Goodenough. I'm going to start off with the first question. How has
Madam Chair, before we start, I wonder if my colleagues should introduce themselves as well.
Sure, please.
Alice?
I'm Dr. Alice Taylor. I am an assistant professor at Bond University and I'm appearing as a member of the Australian Discrimination Law Experts Group.
Christy?
Dr. Christy Clark. I'm a senior lecturer with the University of Canberra and I'm appearing as a member of the Australian Discrimination Law Experts Group. Thank you for having us.
Lynn?
And I'm Liam Elphick. I'm an associate lecturer at the Monash University and I'm appearing as a member of the Australian Discrimination Law Experts Group.
Thank you.
Thank you, Madam Chair.
How has the, I might address this to you, Robin, how has the bill changed since the exposure draft?
I think we could safely say there are some improvements to the bill with the removal of the code of conduct provisions for employers. But in many ways, the issues that we have had concerns about throughout, particularly clause 12, which was previously 42, and clause 11, which overrides of existing state and territory laws, appear to have been extended in their scope and their capacity to override existing internationally recognised human rights.
Human rights are indivisible and universal. Providing discrimination on the grounds of religious belief or activity is consistent with the tolerant, pluralistic nature of Australian society. Australians are provided with statutory protections against discrimination on the grounds of race, sex, disability and age, but not religion. Don't you believe religion, as an inherent attribute, should be afforded the same protections?
Absolutely, and I think it's the group has been consistent in saying that protections at a federal level against discrimination on the basis of religion and related characteristics is well overdue. It's found in many other anti-discrimination laws in Australia, and that is as it should be. Our concern is that this bill does two things. One is it does that work, which is an important bit of work that needs to be done, but it also imports freedoms into a discrimination law, freedoms that in our view are better placed in a proper and comprehensive Human Rights Act, where it can be dealt with in the way that international human rights law provides for the balancing and interaction of rights.
If race, sex, disability, etc. are protected in our legal framework, why have the same protections not been offered to religion?
That's, I think, a question for our political
Indeed.
masters rather than for us. I mean, we,
And
as
why
I
is it
say,
taking
here
so
in
long?
Tasmania, we've had protections against religious discrimination since the date we got protections on those other grounds, and that's the way it should be. It shouldn't be something that has been held back, and I note that most states and territories have it. There has been resistance in the past from religious organisations for the protection against religious discrimination. So New South Wales hasn't achieved it yet. And when in Tasmania we sought to extend Section 17(1), which I know we will come to incorporate protections for people of religious, on the basis of their religious belief, affiliation or activity, that was resisted by faith organisations and by the then Conservative opposition. So it's not through lack of will on our part, it's, I guess, through different progress at the federal level to what we've seen by states and territories. And we see that commonly. We see the states and territories often introducing protections, recognising the need for protections against discrimination, and the Commonwealth catching up sometime later.
Thank you. I believe, Senator Pratt, you have some questions.
Thank you, Chair, and thank you to those giving evidence today from the Discrimination Law Experts Group. In terms of the findings of anti-discrimination tribunals at state or territory levels, are you able to point to any examples in relation to statement of religious belief in and of itself without accompanying conduct that has constituted discrimination against an existing anti-discrimination law?
I certainly can. I wonder if any of my colleagues want to identify any at other level. No, I'll go ahead. So in Tasmania, because of Section 17(1), and also under the standard discrimination provisions, there were some cases 10 years ago now, around the time of election processes, where a particular person and their group, Three Wise Monkeys, distributed through Australia Post to householders material that was extremely derogatory of people in same-sex relationships, alleging that they were drug addicts, pedophiles, and many other extremely offensive assertions. It was delivered direct into people's homes by Australia Post unwittingly, and it breached the Electoral Commission rules in terms of authorised statements, but in addition, it was clearly inconsistent with the protections that people have under Tasmanian law, under the core discrimination provisions against discrimination on the basis of their status as same-sex attracted or on the basis of their sexual orientation. That complaint went to the tribunal. The tribunal held that it was a breach of the Anti-Discrimination Act, and the respondent in that case challenged that to the Supreme Court, arguing that it was a breach of his freedom of expression, that the provisions in the State Act breached his freedom of expression. The Supreme Court held that the provisions in question were suitably tailored to ensure that freedom of expression wasn't unduly interfered with, and upheld the original finding of the tribunal. So yes, it does happen. There are a number of other examples that people in Tasmania have raised and people with disability across the country have raised of similar engagement with them by people of religion that suggests that those particular people of religion consider them to be unequal, somehow broken or sinful or wrong, and that is it's less favourable treatment on the basis of disability. There's sort of no question about that. And that happens in all manner of settings, workplaces, going into shops, going about your day-to-day lives. And so, again, that would be potential. I'm not aware of cases that have raised that yet. I have dealt with cases of comments made publicly about people with disability being less worthy, and those cases being resolved through conciliation.
And I'm not sure, I'd be happy to take on notice from others examples as well. So what happens to those determinations if they were to confront tribunals with the sections in this bill overriding those state provisions?
That's an excellent question, and I think there's two possibilities, and it depends on the state or territory and the approach that Parliament has taken to anti-discrimination law. So there's currently a case before the High Court where a federal defence has been raised to a state claim of disability discrimination, not to do with religion, and that has gone to the High Court because the respondent, a developer, has alleged that there's a federal defence, and as such the state tribunal doesn't have jurisdiction. If that is upheld, then that case dies. The substantive question of whether or not there's been a breach of disability discrimination law will not be able to be determined because the federal human rights framework prevents complaints being made federally if they've already proceeded under the state or territory laws. So that's one possibility. It could be knocked out in its entirety. Fortunately, in Tasmania, the Tasmanian Parliament has enacted some changes to the tribunal legislation to enable those sorts of federal defences to be referred by the tribunal to the Magistrates Court, which is a Chapter 3 court, and therefore has jurisdiction to deal with federal defences. That will add some complexity, but it certainly is an option. We haven't yet seen whether or not that works as constitutionally and is held to be a valid approach to that issue of federal defences. I guess we're uncertain, but the bigger concern is the knocking out of complaints in their entirety.
Knocking out of complaints in their entirety.
Yeah.
Can I ask, in terms of whose complaints gets knocked out, in terms of the nature of a religious belief, because you might be protected under disability discrimination law, but you don't have, it's not your religious belief or your lack of religious belief that gives you a view about your intrinsic, human rights or dignity versus the overriding of those rights via a religious belief. We've been told, if you like, that religious beliefs and a belief that's based in not having a religious belief are on the same footing. But what's left out of that, please?
I'm not sure I haven't answered that question. I'm not sure.
No, in the context that I have a belief about people with disability that's based on not having a religious belief, and a belief about people with disability that is based on having a religious belief, or I just have a belief about people with disability that is
just a belief.
Just a belief. Or to put it, or it could be, you've got a religious belief about vaccination, you've got an atheist scientific belief about vaccination, or you've got or you have a different belief about not supporting vaccination. Like I really don't quite understand the framework of the bill and I'm hoping we might be able to shed some light.
I don't think you're alone in that, and I would say the only one of those beliefs that gets protected is the religious belief, because having an atheist belief about vaccination is not protected under the definition of statement of belief, nor is having an atheist view about disability protected, because it's not a view about religion, it's a view about disability. So the only one of those that would be protected is a religious belief. And before I turn to Liam, I would say that because it is enough for the person to make the claim that it is on the basis of their religion, it's pretty hard to test whether or not it is an atheist or a non-religious belief about disability if they assert that it is. So, yeah, Liam.
Thanks, Robin. I was going to make the same point as you, but also, Senator, you raised a question at the start of that comment regarding what the impact of that would be on these claims. And I just wanted to add to Robin's comments there. All it would take is for a respondent, so someone who has is responding to a claim of discrimination, to raise this federal defence of statement of belief, for it to throw our state and territory tribunal system into chaos. And we have to recall that our state and territory tribunals are really the engine rooms of discrimination law. The vast majority of claims go through these systems. That's largely owing to the state and territory statutory authorities having a local presence, but also these tribunals operate on a no-cost basis in the area of discrimination law. In contrast, almost all claims at the federal system do not. So there's a much higher risk for an unsuccessful party having to pay legal costs, which usually is not going to be something that victims of discrimination seek to pursue. So if that defence is simply raised, it's not a matter that we have to find that the defence actually applies for it to make it difficult for tribunals to hear the claim. It just has to be raised. And then we have that issue of having to go to a Chapter 3 court, likely the Federal Court, Supreme Court, or the Magistrates Court in certain circumstances, as Robin raised, and going through not just a very significant delay in resolving the claim in a timely basis, but also at a significant cost to all parties involved, as well as the legal system as a whole.
Thank you, that's very helpful. I just want to return to the way harmful statements are managed. So if, for example, a medical professional tells someone with HIV that AIDS is a punishment from God, does that statement constitute discrimination under existing anti-discrimination law? Would it no longer constitute discrimination if it's in its current form? I know that some of the medical overrides have come out, but I'm still also concerned about the idea that there could be circumstances under which the scientific circumstances of acquiring HIV, epidemiology, science, aren't protected as much as a statement of belief that it is a punishment of God. So there's different levels to that. And I wanted, I hope, some clarity around what that looks like in the context of this law.
I would start by saying, the key prohibition in discrimination law is against less favourable treatment. And I guess the question is saying to somebody who is seeking your medical expertise for a very devastating diagnosis, is them saying to you, well, this is a punishment from God, is that less favourable treatment? I mean, we haven't had any case law on that. It would certainly, I suspect, discourage a person from seeking the appropriate treatment and therefore disadvantage them in other ways as well. So whether it falls squarely within the prohibitions of under the classic discrimination provisions is an interesting question. I suspect it should. Whether it does is another matter. I'd leave that to my colleagues. It certainly would fall under, and because I think it does, I guess I would say 17(1) of the Tasmanian Act really articulates what less favourable can include. It can include conduct that humiliates, that intimidates, that insults, ridicules or offends. And it's not a low bar for offence. And I don't think telling somebody that their disability or being HIV positive is sinful is a minor, it's not a sort of lightweight offence. It's actually quite a serious thing to allege to a person, particularly if they're a person of faith. And, there are people of faith who have disability. There are people of faith who are HIV positive. And to be told that by somebody who is held in high esteem, because the medical profession are in Australia, would be, I think, in breach of discrimination protections at large, and definitely in breach of Section 17(1).
And what about the case in which the person making that statement might be discriminated against in a professional context? Like, we want a scientific basis for understanding the epidemiology of disease, but if you're in a workplace, could be a health-related workplace, could be or it could be a workplace in which that's relevant. What applies then if you make a statement of belief that HIV is a punishment from God versus the need for a workplace to uphold a scientific view of something like that?
I think in that case, it would more likely fall in an indirect discrimination space. So a workplace, a medical practice would have a rule saying that all our medical practitioners must treat patients based on science. And a religious person could say, well, that's not my belief. And they wouldn't be discriminated against directly on the basis of their religious belief, but the fact that they cannot follow the rule of the organisation. What happens then under law, indirect discrimination, is a consideration of whether that rule is reasonable in the circumstances. So the court would then look to why that rule is in place, so that people get the most appropriate treatment, and potentially decide that in that particular case, the person does need to follow scientific advice and not tell people that HIV is caused by God. Where it is not relevant, it may not be reasonable to have that rule on particular employees, but it will be determined by a case-by-case basis based on the kind of workplace it is, the kind of job that they're doing, and the rule in question as to whether or not it's reasonable or not.
Thank you. Senator Pratt, I'm going to have to stop you there, please. No, Senator Pratt, I'm going to have to hand over, I'm sorry, to Senator Ben Small.
I understand the answer in the context of wanting to know. I'm grateful for that explanation, but does that change in the context of this law, or does that all stay the same?
So, thanks, folks, for joining us. Look, I wanted to pick up on this same line of questioning because I'm looking for you to help me understand where you think the provisions of the bill fall short with respect to those statements of belief needing to meet certain tests. So can you articulate where, for instance, you think a medical practitioner making a statement to a HIV patient in the terms that Senator Pratt characterised, meets those relevant tests of being in good faith and being sincerely held, because I guess I have a very different perspective there. So can you explain to me where the bill's safeguards fall short?
In terms of the way statement of belief is defined, you've rightly, Senator, identified that it has to be made in good faith. It's very hard to establish something not being made in good faith. And secondly, it permits a statement as long as the person considers it themselves to be in accordance with the doctrines, etc., of the religion. That's an entirely subjective test. We don't see tests of that nature in any other area of discrimination law. The tests for harassment, the tests under Section 17(1), and the tests for discrimination in all discrimination laws in Australia are objective tests. This is an entirely subjective test because it's in the eyes of the person making the statement. And so it's sort of impossible to, I think, establish that a statement of that sort is not being made in good faith. Person believes it, they're making it in good faith.
So just to pick up on this exact point, because I guess you're characterising this in the context of someone being employed to deliver healthcare outcomes to a particular patient. And there's somehow a suggestion that telling that person that they are being punished and going to hell by God is a statement in good faith when that person is charged with responsibility for that person's healthcare. I just can't see any circumstance in which that flies.
Well, I guess this bill doesn't give you an out based on the reasonableness of you making the statement in the context. That's not part of the test. The test is you make it in good faith. Now, it may be that the court would find that it's not good faith to make that statement in that context, but there's no case law that suggests that that would be a finding of bad faith.
And that's certainly on the point that we haven't got any case law because this is new legislation.
Yeah.
What about with respect to the employer conduct rules, which would apply specifically to nurses and doctors in this, as well as the professional codes, I guess, associated with being a registered health professional and how that interplays?
Can you contradict?
I'm happy to field that, Senator. So I suppose in the old version of the bill, obviously we had the old Clause 8 that would have dealt with that issue. So it really falls back now generally to what Alice previously said, that it comes down to whether the rule is reasonable or not in the circumstances. And we've submitted in our previous submissions that that is exactly how it should be, because that is how all discrimination laws deal with those employer conduct type rules around the country. It's based on what's reasonable in the circumstances. Sometimes that will require limitations on the expression of certain harmful beliefs. Sometimes that will promote the allowance of certain beliefs in certain circumstances. The one difference with this particular bill is in the provision relating to qualifying body conduct rules. And this still short circuits the reasonableness test and effectively says that in those circumstances, limitations should not be placed on the expression of belief. Now, much like we have submitted on the previous version of the bill, that's not a provision that we support because it does drastically change the test that we have used for decades to deal with these rules in Australia. And it also interferes with work health and safety laws that employers are bound to comply with. And indeed, in certain circumstances, qualifying bodies will be bound to comply with.
Okay, that's helpful. And I'll come back to the WHS issue in a second. But the other key element here is that the bill has phraseology like the doctrine, tenets and beliefs of the religious faith concerned, or I guess the absence of that faith altogether. But I am just not aware of any religion that has a doctrine, tenet and belief that you could point to that says that disabled people are somehow this abomination in the way that's been characterised in certain examples. So can I ask?
I'm very happy to respond to that, Senator Small. Unfortunately, there is a long history of religions treating people with, believing that people with disability are one of two things: the product of sin, or a blessing from God to test the goodness of their parents. Now, neither of those are treating people with disability as equal and fully deserving of respect and dignity. I have friends with disability who have those statements made to them under the banner of religion. There are many religions that hold the view that disability is part of God's work, either to punish sin or to test goodness. Now, it may not be your belief, and it certainly wasn't the beliefs that I grew up with, but I have read widely on this, and I've seen exactly this being taught as part of religious belief. So we may not accept that it's an appropriate thing for a religion to believe and to express, but it is clearly within the scope of doctrine.
On notice, it would be great if you could give me some additional detail around that and I guess specifically concrete things to point to. While we're on disability issues, I think more broadly, disability service providers have been excluded from Clause 7 as a result of like the evolution of the bill over time and in part due to submissions we've received from your organisation. Do you think that that is a favourable outcome?
I think it's a favourable outcome, but it doesn't include all services that people with disabilities seek access to assist them with their day-to-day needs. Not all services are disability services as defined.
Could I also just add
it doesn't go far enough.
Yeah, the disability service providers are contained in clause 9 or section 9, where they are given an exception in relation to employment discrimination. So it's not the case that they're excluded entirely. They are given an exception, particularly with employment, just not for service provision.
Yes, yeah, and by design. I think I'll probably use my time again, so sorry, I'll hand it back.
Thank you, Senator Small. I'm going to the Deputy Chair.
Thank you. And I was just interested in something that Senator Small touched on in terms of talking about that employer-employee relationship in terms of what might be required, what is reasonable in the circumstances. And so would that employer-employer relationship, can a person effectively contract out of the proposed discrimination law? Maybe Mr. Elphick, or
can they contract out of it? Yeah, I suppose that's a difficult question. I think where my concern is, I suppose, and where my comment came in regard to work health and safety laws, is that certain comments that can be permissible under the statement of belief provisions, and indeed certain conduct that could be permissible under the qualifying body conduct rules, may well be covered by codes of conduct within employment. In fact, are very likely to be covered within codes of conduct within employment when you look at the purpose and legislative history behind the qualifying body conduct rule and the employer conduct rule that has now been omitted. By contrast, work health and safety laws impose a positive duty on employers to prevent harm in a range of different areas, harm generally, but also harm specifically from bullying, harassment and discrimination laws. Despite that, the statement of belief provision and parts of the qualifying body conduct rule would permit conduct that might well be prohibited by that law. What that means for employers is it really creates an unworkable situation. They have really strong work health and safety laws that Australia is rightly proud of, on the one hand, that are meant to protect workplace participants. But then we have this bill work to become law, on the other hand, protecting certain employees from certain statements of belief, but not all other employees. It would make it almost unworkable in certain situations for employers to be able to resolve that situation.
So, my receptionist, every morning she's a devout Jedi, follower of the Jedi religion, shall we say, or the Pastafarian. I'm trying to not offend too many religious people, but every morning says Jedis are great. That's the way she makes a statement of belief every morning. And I don't want her to say that to the public who are coming into my office, say. So are you saying that I couldn't contract out of this legislation? She would be able, that would be reasonable, I guess. I mean, I'm surmising here, but it's not interfering with her workplace. I mean,
I'm going to say I don't think you could have a code of conduct that prevented that statement being made, because there is nothing damaging to others of that statement. And what we're concerned about is those statements that target people because of a characteristic. Those are the statements that are potentially discriminatory under existing law that will be overridden by this. And Patrick Parkinson made a comment on radio here in Tasmania where he said, I believe that Jesus was the Son of God. I should be able to say that. Well, there is nothing wrong with saying that, and nobody could legitimately argue that discrimination law prevents that kind of statement of belief. It's
so even when you hand over the coffee, even when if you every morning at your childcare, you'd be able to say things like that, irrespective of your religion. It would not
fall foul of discrimination law. It wouldn't.
Okay,
it wouldn't,
so
discrimination law doesn't touch that.
Noosa, Satan, whatever that, the Church of Satan up in Noosa, they'd be able to, if they're an employee, they could start that when they hand over a coffee or whatever. And as an employer, I wouldn't be able to say we don't want that in this workplace.
If I could just add in there, Robin, as well, it's not just that you may not be able to sort of restrict them from saying that, it's that you could be liable in discrimination. I mean, what this bill potentially says is that could also be religious discrimination if you're trying to adversely treat them in a certain way, as opposed to other employees not making those statements. And it goes back to what the Senator's previous comments were saying, Senator Small's comments, in regard to religious doctrine. We have to remember that this bill does not say that religious doctrine has to be widespread or uniform or believed by all believers to be protected. It has to be effectively believed either just by the person themselves genuinely, Or in other parts of the bill, in section 7, you just need to find one other person who may reasonably consider that to be a belief. Now, I also believe the vast majority of those of faith do not believe the statements that we've said today, but that's not the concern. The concern is that some people would, and they are protected by the bill.
Okay, thank you.
I've got one question before I hand over to Senator McLaughlin.
Oh.
Isn't there a ruling in here or part of the bill that actually protects if a business is going to be adversely affected? So if you had, as Mr. Perrott was saying, someone who, as an employee, was saying something to every person that came in the door, and it actually turned business away, so it was impacting their business, surely that is grounds for asking your employee not to say that.
Alice?
So for the most part, no. And that argument has been raised more broadly in discrimination law in Australia and other places, and it's been rejected, mainly because what courts have been concerned about is the idea you could justify race discrimination or sex discrimination on the basis that you say, oh, my customers don't like to be served by those kinds of people. And so both in Australia and internationally, the argument that it's affecting a business's bottom line has not been accepted as a reason to discriminate. And that would be the same under this bill. So you wouldn't be able to just say, well, without something more, that somebody says, God bless, when they give you your coffee would be that you would be able to prevent someone from doing that.
Thank you.
This was previously in the bill as well, I should mention, in the second draft. It was taken out with the employer conduct body rule, which we would support the removal of that.
Thank you. Senator McLaughlin, a couple of questions, and I'm going to hand to Senator Rice, and we are going to tidy up at 10:15. Thank you.
Thank you, Chair. Do you have a view on the review clause, particularly the time, 2 years?
We haven't considered this as a group, but it certainly seems a very short time for testing how a law is operating. I'm looking at equivalent laws like the standards made under the Disability Discrimination Act. All of those had 5-year review provisions. I guess one of the things that concerns me, and I don't know about my colleagues, is that we've been having a debate about religious freedom and religious discrimination and interaction with particularly sexual orientation protections for a good 6 or 7 years now, and it just keeps coming up and coming up. We would love to see federal discrimination law protecting against religious discrimination in the same form that we see with other laws. If that were done, we wouldn't need a review provision, let alone one that was a 2-year review provision. So it feels like it's just another opportunity to have another go at extending the privilege afforded to people of religion over the equality rights of others.
So just to come back, so freedom of religion is a protected attribute. So can you just sort of unpack your view? Does this bill codify that protection? From your perspective?
Freedom of religion is a protected attribute. Freedom of religion is part of a different part of international human rights law. The freedom of belief, thought and conscience, I think in Article 18 of the ICCPR, I hope I'm right. They are quite different things. They're two different sets of rights. And Christy, maybe I should let you respond to this.
Thank you. One of the issues here is that it's a selective, it's sort of cherry picking certain aspects of Article 18 of the ICCPR. And by doing that, it's actually privileging one set of particularly the freedom to manifest in relation to religion, but it's not really providing an equal protection for the freedom to manifest one's beliefs, which is also protected under the same provision. It's also not recognising that Article 18.3 specifically says that this one can be subject to limitations, particularly to protect the fundamental rights and freedoms of others. And it's placed in an international convention which specifically sort of foregrounds the fact that all of these rights must be protected in a non-discriminatory manner and ensure equality and non-discrimination in relation to the realisation of rights. So, one, it's an unequal protection of people's rights to manifest their religion or beliefs because only some people get that protection. And in some cases, it might be that institutions get that protection over and above individuals with religious beliefs, for example, in the school or employment context. But it also means that those rights are elevated above the rights to non-discrimination and equality of other people. And that's fundamentally inconsistent with international human rights law and the way that it's supposed to be implemented. And that's really the main concern in relation to the kind of the reliance on international human rights law for this, for this bill overall.
So you're saying that you don't think it interacts fairly with Article 18?
I think it's a selective, it takes certain parts of Article 18 while ignoring others. And that's just that's not consistent with international human rights law. Things have to be done. One, a single article obviously needs to be implemented in its entirety, but also the indivisibility of human rights is widely recognised, and so you can't just elevate one and ignore the other in the context of implementing international human rights. The whole idea is that they're supposed to be balanced carefully against each other.
Thank you, Senator McLaughlin. I'll go to Senator Rice. We might have to take some questions on notice. Thank you.
Thanks, Chair. Mr Elphick, I wanted to take you to your statement you made before, how the overriding of the state and territory laws will, throw our state and territory tribunal systems into chaos. And just comment some more about the problems with the override. In particular, wondering whether you'd like to comment on the statements that were previously made by Professor O'Roney that this would all sort itself out over time, that once there was sort of federal court case law established, that then the state and territory tribunals would, basically be implementing that case law so that this wasn't a problem.
With respect, I disagree with Professor O'Roney on that point. We have to remember that victims of discrimination are not claimants who we should be forcing through extremely difficult, timely, costly processes. The main intention behind our state and territory tribunal systems, not just for discrimination law, but for many other areas of law, is for it to be low cost and to allow access to justice for those claimants in those circumstances. This won't be easily resolved. This will be a nightmare to resolve were the statement of belief provisions to pass into law. And it would require a significant overhaul of our state and territory, not just laws, but also courts and tribunals to find a workable solution. I expect that would take years. It would certainly not be something that could be resolved in the foreseeable future. Not just that, even were the High Court to rule slightly differently to what Robin raised previously, we don't have any clear answer on this. So the uncertainty that this will provide and will create for claimants and victims of discrimination is something that we don't think is acceptable or advisable. And Robin might have some comments to add to that.
I guess the further comment I wanted to make is there is no guidance, despite this being raised with the then Attorney General Christian Porter several years ago, there's no guidance on who will be required to establish that the statement of belief falls within the permitted scope, that it's good faith, that it's their belief. That's not difficult, I guess, for, that the question of who determines that is, or proves that is one thing, but then that it's not vilifying, inciting or malicious, who's got to prove that? It's a defence to a defence, I think, but, this is where the complexity of these bills is really at the heart of many of the concerns. And if we've never seen anything like this, and there is no guidance on whether it will be up to the complainant in a discrimination complaint to prove that the statement of belief was made maliciously, or will it be up to the person making the statement to prove that it wasn't? Now, proving maliciousness is extremely difficult as far as I can see from case law. You have to show that it was made with an intention to cause harm and that it was unfounded. I don't know how you prove a statement of belief is unfounded. It in and of itself is a difficult sort of conundrum, but there is no clarity of who has to prove it. And that's a huge gap in this legislation that makes it even more complex in case law terms. Alice.
Sorry, I think just to add to that, one thing to remember is that discrimination law is a highly technical area of law, but not particularly well litigated because the claimants are vulnerable and don't have the money to send this all the way through the federal court system. So the likelihood that this will come out in the wash, it will take years, if not decades, to do that. We're also not assisted by the fact that this is quite novel in a comparative setting. So there isn't good case law from other comparable jurisdictions on how such a provision would be interpreted, because they don't exist there. So courts will be essentially working with a blank sheet of paper and not being able to reach to either state law or comparative English or Canadian law to work out how to interpret these provisions.
Thank you.
So,
Senator Rice, I'll just get you to ask the question and then we'll take it on notice.
Okay,
Thank you.
I've actually got 3 questions I want to put on notice. So one is whether what this means is that those potential complainants basically in those decades would basically just have to suck it up. They're not going to take that action. That's my first question. The second is I wanted to ask about the lot of talk that there's been made about changes to the Sex Discrimination Act in parallel with this bill, and whether you feel that if those changes were made, would you be confident that LGBTIQA plus students and teachers would actually then be protected against discrimination, given that this legislation would be in place as well? And the third was I wanted some further comments about religious organisations' ability to preferentially employ people and the protection against discrimination from other people who are then being denied employment because of the preferential treatment of people of the same religion of those religious organisations.
Thank you very much. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 7th of January 2022. Thank you. We will now suspend.
Madam Chairperson, could we just confirm that it would be okay for us to send our written opening statement to the Secretariat?
Yes. Thank you.
Thank you so much.
Thank you.
And
Thank you.
Standing question?
Yes.
With aspects, of the bill that need amendment, with the offer of those amendments if possible. Thank you. On
Thank
notice.
you.
And will we send those questions on notice?
Yes.
Yes.
Thank you.
Thank you.
Thank you very much.
We will suspend until 10:25. Thank you.
online, Chair.
Oh, thank you, yes. I now welcome representatives from the Australian Christian Lobby. Welcome, Mrs. Wendy Francis. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. For the Hansard record, will you please state your full name and capacity in which you appear today?
My name is Wendy Francis and I'm the National Director for Politics for the Australian Christian Lobby.
If you provided a written opening statement, would you like it to be incorporated into the Hansard record?
Yes.
I now invite members of the committee to ask questions, and I will start with, the Deputy.
Hello, Wendy.
Fellow Queenslander.
A Queenslander.
Yeah.
Who's just figured out I can't go home, so that's why I was running in and out trying to.
Don't tell me that. I'm going home tomorrow.
An extra night in Canberra, so.
The joys of
the joy.
the day.
So, Wendy, the ACL submission calls for wording to be included in the bill to acknowledge that the bill is to give effect to the provisions of the International Covenant on Civil and Political Rights. Your submission says, and I quote, "Without this defect being remedied, there will be clear, unequal treatment of rights within federal discrimination laws. Is it the view of the ACL that no form of discrimination should be given elevated protection under federal law?"
Yes, we do. We believe that every Australian should be treated equally under law.
And so no form of discrimination should be given elevated protection?
No.
Okay. And the ACL says it supports the bill with some minor amendments. However, the last page of your submission quite clearly states that the Australian Christian Lobby cannot support the bill if changes are made to the Sex Discrimination Act. So is the Australian Christian Lobby's approval conditional on no changes being made to the Sex Discrimination Act?
Yes, it is. It is. And that's because we're talking about the Religious Discrimination Act here. And so we're not talking about the Sexual Discrimination Act.
But your submission clearly links the two together.
Whose does, sorry?
Your submission.
Yes, and that is because publicly it has been linked together. So we felt we needed to address that.
When you say publicly, you're referring to the article about the Liberal MPs saying that they'd extracted a condition off the Prime Minister.
Correct.
So your position is you cannot support this legislation if there are changes made to the Sex Discrimination Act?
That's right, because we'd have to then address those changes. We'd have to look at those changes. So we would withdraw our support until we could assess those changes to see what change that made to the overall end result.
Thanks, Chair.
Thank you. Do you believe there is a need for religious protection to be implemented in our legal framework?
Definitely. And it's not just us. This is a United Nations belief as well. So you've probably heard it a number of times, but even in the Human Rights Committee, the United Nations Rights Committee, they expressed their concern in the 2017 review of Australia about our lack of protection against discrimination on the basis of religion. And it's very clear, even in some of the more glaring, I guess, more exaggerated examples, in that in New South Wales and South Australia, for instance, there is no law saying that you can't put up a sign outside a restaurant saying no Hindus allowed, no Muslims allowed, Christians not welcome. So obviously there is a need to fix some of those more glaring examples, but there's also a number of court cases that have happened over the last 3 years particularly, where people have been discriminated on the basis of their religion. So we do see that there is an urgent need to address this, because it has been going for a long time.
So how many members does the ACL have?
So we have 230,000 supporters. There are more that would say that they are part of ACL, but we understand who is a real supporter, as just like any organisation, I guess. So we've got 230,000.
And what kind of stakeholder engagement have you had with your supporter base about this draft?
So we encouraged people to contact their members of parliament. I think over 8,000 people did that. But we find, leading up to Christmas, it's difficult in some ways to get everybody excited about this.
Religious people are a bit busy.
Exactly, the religious people are a bit busy. But we found that this is really important to our supporter base because they are the ones who are often at the coal front. They're the ones who are understanding what it is to be discriminated against on the basis of their religion.
And can you articulate any particular examples?
Sure. I mean, very recently there was a Christian young woman. Her name was Hannah, although I think that's a pseudonym because I think we're protecting her. But she was banned from a cafe because she was in there with another woman and she was praying and reading her Bible. Now, that was just quietly in the table, but the cafe, for some reason, didn't want them in there, asked them to go and told them never to come back again. Shortly after the same-sex marriage debate and vote, there was a young girl, Madeline, that is her name. She was fired from her job because on her Facebook she had put, "It's okay to vote no." So that was the saying that it was going around. She was sacked on the basis of that because it was said that that statement was homophobic and hurtful. Whilst at the time she put it up, it was still actually law to be married with one man and one woman. So there's that sort of thing. We all know about Archbishop Porteous. He became the focus of quite a prominent controversy after a discrimination complaint was made against him because he was expressing the traditional Catholic doctrines of marriage. He was had to go through the whole discrimination process. And then very recently too, we had a young woman who was subjected to an internal review and she was threatened with discipline because she was defending her religious beliefs from attack in the workplace. That was over the Israel Folau case. So she spoke up saying, well, she felt that perhaps he shouldn't have been fired and she was disciplined for that. So there are, and I could go on, at the website that has...
None of those in Queensland, obviously.
No.
Yeah.
No, that's right, because Queensland does have religious discrimination laws.
Thank you, Wayne Goss.
There's lots of things we could thank Wayne Goss for, actually. Yeah, so I could go on. There are, but there's also, it's not just Christians. We have Islamophobia. We have anti-Semitic concerns as well. So this legislation is not just about people who even believe, it's about people who don't believe. So it actually gives people the right to express their beliefs or express that they don't believe.
Thank you. Senator O'Neill?
Thank you very, very much and appreciate you being here today, Ms Francis. Could I ask, are you in support of this bill? I mean, you've had 3 iterations now and you kind of got to see it a little bit before Labor even. As it's constructed now, do you support the bill?
We do support the bill because we think that it's a good start. It is also a compromise, and I understand that politics is all about compromise. There were things that were in the previous iterations of the bill that we would have preferred were still in it. I hesitate to use the word Folau clause because I think that has all sorts of baggage with it now, but we do think that was an important clause to protect people in the workplace from making statements outside the workplace without any risk of being penalised from their employer. So there are things that are not there that we wish were there, but we do support the bill.
And you've made a number of recommendations. I'm going to ask you about those shortly, but you provided the committee with submission. Is there anything that you want to add before I get into the detail of your submission?
Look, thank you for that opportunity. I wasn't sure I'd get that, but I think having listened to the previous the hearing, the people who were there.
This morning's evidence?
Yes, just previous. I was sitting here and listening to the lawyers. I just feel concerned about some of the things that they were saying that I just don't believe are correct. So I don't know whether there's just opportunity for me to correct that a little bit. I think the fact that to say that, particularly the medical one, I was like, to say that a nurse could say to a patient with HIV that AIDS is a punishment from God, or a disability worker saying that is a punishment from God, for a start, it's a hypothetical that I just cannot personally... religious people are the people who have started hospitals, they've started education. I'm not saying that there's not bad eggs in every area of life. We have it in the police, we have it in the teachers, we have it in the clergy. I'm not saying that, but as a whole, religious people are actually the kindest people I know, but they're also, there would be, the Religious Discrimination Bill doesn't change any of the other restrictions on speech. So there's no, like, it has to be speech that incites violence, severe ridicule or contempt, laws are already there that if someone's reputation is even harmed, that, you know, that's not being changed. The only things that will be allowed are statements that are not malicious, harassing, threatening, intimidating or vilifying. There's no way that you could say something like that and not be caught under a medical, legal. They just would
Codes
not.
of professional practice, is that what you're referring to, Ms Francis?
Yes, thank you.
Okay.
I just felt really sad about that statement, and I also think that our doctors and our nurses and our midwives are the most professional and amazing people. I have medical people in my own family, and to think that they would have this underlying hateful attitude is something that would just be so aberrant to the actual person of who those people actually are. Certainly the disabled, the religious organisations that look after disabled people, it's largely religious organisations that have been set up to do that. And there's no way that this bill will change any existing protections against discrimination on the ground of disability at all. This bill is just looking at protecting religious people. This is not actually changing any of the other discrimination acts at all. So they still all exist.
And you believe those protections in the states and territories where they do exist currently pick up malicious comments of that kind?
Absolutely.
Okay. One of the suggestions you make in your submission, Ms Francis, is for the introduction of a reasonable adjustments requirement. And such a requirement would mirror the equivalent provisions in the Disability Discrimination Act of 1992, the Commonwealth Act, that is. Mm-hmm. Could you explain what such a requirement would look like and how it would operate in practice? Because there are a few submitters who've raised that particular reasonable adjustments requirement.
Okay, so if somebody was working in Woolworths, for instance, and it's a 7-day working week, but they were a Jew and they wanted to have Friday nights off, if there was an ability for their employer to actually adjust to their specific needs, then that they should be able to do that. That would be a basis that they could actually adjust to their needs.
Okay, and an example from another faith, perhaps an Islamic employee might be given a bit of time through the day to do their daily prayers. Is that another example of the reasonable adjustment that you're seeking the government to include that's been overlooked in the current draft? Yes,
we are. So, but again, it needs to be reasonable. It can't be something that is going to make it difficult for the operation to, like if there was only one staff member and that meant that staff member was going to have to leave the desk, then I don't think that's reasonable. That's not reasonable for an employer. But if there are 3 and they can do a rotation and it's easy to accommodate that, then I think that's what we were asking for.
So you keep using the term reasonable, and I suppose that's the hope that everybody has with this piece of legislation, that there can be a reasonable delivery of religious discrimination protection without unleashing unintended consequences. And to do so is going to require a very carefully crafted piece of legislation. I know that you have had consultations with the government. In fact, I think you gave evidence to the Ruddock inquiry, which I remind people is now 2018, some time ago, and
yes.
The government made a number of recommendations and responses to that, including a commitment from the then Attorney General, the Honourable Christian Porter, and also the Honourable Scott Morrison MP as the Prime Minister. He said they would be developing a religious discrimination bill to provide comprehensive protection against discrimination based on religious belief or activity. The government will work with the opposition, that's what he said, crossbench and stakeholders in a consultative process which aims to allow for bipartisan agreement on a bill which can be introduced into the Parliament with broad cross-party support. Well, that certainly wasn't achieved because there was no bipartisanship. When the bill landed just a couple of weeks ago, it was the first time that we got to see it. Nonetheless, I understand through this consultation over many years, you've advanced this view and on other matters, but particularly with regard to the reasonableness adjustment. Did you raise that with the government? What's their thinking? Why have they not taken that on board?
We did, but perhaps it's because, and I'm not a legal person, I'm not a lawyer, but perhaps it is because, as you say, there might be different views of reasonableness. But I think that's why we have discrimination councils. It's why we have the legal teams that we have, because, you know, when there is a difference in opinion about what is reasonable, then if you can't sort it out, and this happens in neighbourhood disputes, we know that if there's a difference in a view of what's reasonable, then it gets elevated to the next level, and we have processes to work that out, what is reasonable. We have it in neighbourhood disputes. If the music's too loud and they can't decide, then there's next process to go to.
So could I take you to some process concerns that I have? Because I'm very concerned about the announcement and the expectations that have been elevated, because people have been waiting for this for such a long time, that there's a lot of emotion in it, right? And so desperate to get a result that you read into the legislation perhaps sometimes what you want to see. But one of the concerns that's been raised about the statement of belief provision, and it's particularly that sections 11 and 12 that I want to go to, the Law Council of Australia actually described the process as procedurally unworkable. And we've had some evidence this morning, including experts saying that in the absence of case law, because of the novel nature of this particular piece of legislation, that it could be years, if not decades, before anything gets settled, and that the cost of doing this lawmaking to establish precedent is going to be so significant that people might not be able to avail themselves of the statement of belief, even if it should pass the Parliament, which is, you know, in question if we get back, because Mr Morrison could call an election, and in question because we've got statements from backbenchers from the Liberal Party indicating that their conditional requirement for the bill to get their support is the removal of Section 23, the Section 23.3, is that correct? So,
yeah,
what do you think? Is this workable? Can it actually happen?
It's only going to be novel until it's actually in, and then it will stop being novel, because the problem is any new legislation is going to have a teething time. Any new legislation is going to have to be worked out in the courts, and then precedents will be set. So the longer it takes to actually get this bill passed, the more, I guess, anxiety there is about the whole process and the novel process of it. Because you were talking about the Ruddock review, also in that statement, the PM and the AG said that there would be a legislative response to the Ruddock review tabled in 2019. And so, and there, well, we've had reviews and we've had things, but we really need, we're really hoping that there will be time to get this through before the election.
Because it has been a very much promised but not delivered set of announcements.
Yeah.
Thank you, Senator.
One final question, if I can.
Final one.
On notice, I'll send you the statement about the first, second, third and fourth things that have to happen before we can get to that case law. But with regard to Section 11, that's a provision to override state and territory laws. I know that there's great store being placed in this by a lot of different community groups. What is ACL's view about Section 11?
Yeah.
Are you confident that what the government is promising there can be delivered, particularly in light of, you know, articles like this one from Sarah Martin, where it describes the moderate Liberals striking a deal with the Prime Minister and Minister Cash that is at odds with what they have promised you and seems to have put into the legislation?
Yeah. the overriding of states is important because every Australian, if we're going to get a religious discrimination bill, every Australian needs to have the same protection. So if we were to go to what the states are doing, we're actually moving the federal legislation to a lowest common denominator. We have to look at what is the best practice for religious discrimination, and the federal law must be the best practice. And so if it does override any state legislation, then so be it if we are getting what we see as the best religious discrimination legislation.
Thank you. Mr. Goodenough.
Thank you, Madam Chair. Will this bill protect the freedom of religious organisations to select staff in accordance with their ethos and to preference people of their particular religion?
We're really pleased about the wording of that. Certainly for schools, we believe that there will be an ability to preference people who are of the same religion. I don't know whether I can't see Mr. Goodenough, can I?
No.
No. So I was just looking around just in case
If you
he was
can,
hovering.
we've got a problem.
Sorry, Mr. Goodenough. So we're pleased with that. I think that it should be religious organisations rather than just religious schools. I think that it's a little bit narrow. But yes, we believe that there will be the opportunity for schools to retain the right to preference people who adhere to their religion in the same way that political parties preference the employment of people who adhere to their ethos, or many other. I could go into just about every organisation has that same right. And so this would remain a right for schools, Christian schools and Islamic schools and Muslim schools, yeah.
Yes, thank you very much, Francis.
Senator Small, I believe that you'll follow on.
Yep, just coming off mute there. Thanks, Chair. I guess can I ask your view, please, on the safeguards that the bill includes around a statement of belief needing to meet certain tests, sincerely held, reasonable, in good faith, can't incite violence, can't intimidate and harass, and all those sorts of measures. You touched on it a little bit earlier, I think, with respect to the healthcare example, but I'd be really keen to understand ACL's view on those safeguards more broadly.
So I think the safeguards are fairly clear. And again, I'm not coming from a legal position, but let's say you're in a workplace and there's an atheist in your workplace. There's also a Christian in your workplace. They don't know what their religious beliefs are. And the atheist says something really perhaps offensive about God. God is illogical. Prayer is just praying, into a fairy in the sky. And the Christian in the workplace is a little bit offended by that and says to the fellow, actually, I'm a Christian and I feel a little bit offended by that. There's no way that he would be up for discrimination because that is a reasonable statement to say, not knowing. But if he were then every day to go in and go to her desk and say, God is make-believe, he's illogical, and you're praying to a fairy in the sky, then that would move into the area of being discriminatory. I think that it's easy when you break it down into normal language to actually understand, one statement, two statements, like people should be able to say whatever they like to say. And but then when that is ongoing, then we're moving into being malicious or being intimidating, and then that is where the Religious Discrimination Bill would step in.
Senator ONeill was quite right to mention that the Prime Minister made a very clear commitment to the Australian people that he would deliver them a shield against discrimination on the basis of either holding or not holding a religious belief. Do you believe that this legislation is a shield, or do you believe that it is in fact a sword to enable people to prosecute their ideas and faiths in a way that they can't currently do so?
It's definitely a shield, and there have been things removed from the bill, even from previous iterations of the bill, that people did see as being a sword. It is a shield in the same way that other discrimination acts are shields for those people. There are so many caveats on being able to claim discrimination that there is no way that you can go out and actually trap somebody, or again, even with schools, for instance, it has to be so clearly laid out. So it's not a sword to remove somebody from employment, but it is a shield to protect the school, their ethos as they employ somebody, and it has to be very clear what they're asking of the employer as they do that interview or bring them into the fold. So it is definitely a shield, and we do not see it as a sword. Thank you for the question, though.
No, because I think it's fundamentally important to the discussion of this bill that we don't misunderstand or misrepresent what it is. And I think I'm keen to understand from an ACL perspective whether you think that the current exceptions in the Sex Discrimination Act and the Age Discrimination Act are sufficient in providing protection to religious views, because the public debate around this particular legislation has at times conflated the two pieces of legislation, or three in this case.
Yeah, and it saddens me because, again, I come from a tradition that is actually one that's very loving and very kind, particularly to children and people who are in need. And, you know, we talk, there's often talk about that this will be a sword in as much as being able to expel students who identify as LGBTIQ. I am yet to find a case in Australia, so for me that is a hypothetical something as well. Expelling students on the basis of their sexuality is just not something that we do. And both of the major Christian organisations that run Christian schools, but also I've been in conversations with the Islamic Council as well, and it's just not something that happens at all. But even if we're saying, okay, well, we need to watch the Sex Discrimination Act to make sure that it's robust enough, we are doing that. And so we've got in place that this bill will pass because we've been waiting for it for such a long time. The Sex Discrimination Act that is already in place and is operating really well will then be looked at to make sure that it is robust enough. And we're saying that that's going to happen within a year. So can I just put a hypothetical out there? If all of a sudden, in a year, religious schools started expelling students from schools because they were gay, can you imagine the outcry? And can you imagine how robust we would then make the Sex Discrimination Act if that was the case? I mean, it's not as if all of a sudden the floodgates are going to open and schools are going to start expelling students who identify as a different sexuality or gender neutral. It doesn't happen. I couldn't find a case where it has happened. And if it did happen in the next 12 months while we wait for the report back from the legal committee looking at the Sex Discrimination Act, there would be huge outcry, and we would make sure that sex discrimination legislation was very robust if there was any move in that direction.
Ms Francis, that's probably the most powerful 30 seconds testimony or commentary I've heard on this particular piece of legislation, and so on that, I'll hand back to you, Chair. Thank you.
Thank you very much. Senator Rice.
Thanks, Chair, and thanks, Mrs Francis, for your evidence today. Look, I want to go back to some of the examples of behaviour that are currently covered under our anti-discrimination laws, and where there seems to be some confusion as to whether they would then be permitted if this bill passed. And in particular, starting with the patient with HIV who we were discussing earlier, who was told that AIDS was a punishment from God. And I mean, you expressed some doubt as to whether these sorts of things happen. They do. And in fact, that quote was taken from a paper that was just published this year, which was reporting on HIV, stigma and discrimination in ethnically diverse communities in South Australia, and found that HIV was a highly stigmatised condition and that it happened, basically, and that statement in particular happened.
Was it a medical professional who said it?
Yes, it was a medical professional.
And were they penalised for saying that?
I don't know whether they were at that stage, but that's the sort of statement that was, under this legislation would be considered to be, sincerely held in good faith, that would be permitted to occur. So I just want to get the Australian Christian Lobby's view as to whether you think that's appropriate.
Yeah. So the Religious Discrimination Bill will protect statements of belief which are made in good faith, not malicious, not harassing, not threatening, intimidating or vilifying. There's no way that a hypothetical question like somebody saying that would not be caught under that.
I think, but that's where the law experts differ from your view, in that basically saying that that is the view of this medical practitioner, it's said in good faith, it does not meet the criteria of being malicious, harassing, so any of those criteria.
Yeah, can I just say that not all, that would be a very divided opinion, because the law experts that we've talked to have said that there is no way that that statement would pass muster for that. So I think that if you talked to somebody like Deb ONeill or Mark Fowler or some of the John Steenhoff, their legal position would be very different to what you're saying.
So you're saying that would not be, that sort of statement would not be permitted under this legislation?
It would be abhorrent. People who go to a medical practitioner look for truth for a start, and that would not actually be a truthful statement, but they're also looking for compassion and kindness. That it would be. I would have to say it would be medical malpractice.
But we just heard evidence from the experts in discrimination law, the Australian Discrimination Law Experts Group. You were here in the room.
Yes.
They are the experts in discrimination law. We had the Tasmanian Anti-Discrimination, former Tasmanian Anti-Discrimination Commissioner as one of those experts, who said that under this legislation, statements like that, because they would be genuinely held statements of faith, statements of belief, would be legal and would be permitted.
So again, I think that there are other legal people who are in this field as well. So the Human Rights Law Alliance would say that absolutely that would not be the case. The Religious Discrimination Bill won't change any other existing restrictions on speech. So we have existing an employer's reasonable and lawful directions are to be courteous, respectful to customers and other staff, laws against speech that incite violence, severe ridicule or contempt, laws that harm a person's reputation. None of those are being changed, so those laws are already there.
No.
I don't think that any law is perfect, so I don't think that any law is going to be able to actually make everybody behave in a reasonable way. I'm not saying that we're going to, wave a magic wand and everybody's going to be reasonable and kind and loving and compassionate, but this bill does not actually change all of the other bills.
With respect, it does, because it overrides state and territory discrimination laws that currently prohibit discrimination like that.
But you're saying that it already has happened and we don't have a religious discrimination federal bill at the moment.
There have been statements like that that have been found to be discrimination under existing state and territory legislation that would not be found as discrimination under this, if this law was passed, because this law would override that state and territory law.
Respectfully, I disagree with that.
Okay.
And I think
how about
the
case in Queensland where a woman's employer wrote statements condemning her same-sex relationship in a book that she was reading? Do you think that's acceptable behaviour?
So no, I don't, but I'd have to know what the situation was. Is it outside work time or is that inside work time? I think that an employer picking up an employee's book and writing it
it was in work time.
Yep, so Queensland does have religious discrimination bills, a bill, so definitely they should be able to go, and I would encourage them to go to the Queensland.
Well, that's another example where the experts in discrimination law and the experts that you have been referring to do not have the same expertise in discrimination law as the experts in discrimination law. So that sort of activity will be legal. I mean, the third one was a taxi driver telling a person with a visual impairment that their guide dog was unclean.
So what part of religion is that? I'm just not understanding where religion
That's their
comes into
religious
that.
belief that guide dog is unclean, and just there are other religious beliefs that people with disability is a punishment from God, and that they feel that that's their right to tell people with disabilities that that's a punishment from God.
See, there would be no religious tenet that would say
Well,
that.
but it doesn't have to be that. It's a genuine statement of belief, and under this law, it doesn't. If it's a genuine statement of belief of that person, it would be protected under this legislation.
I think you're underestimating our legal system, because there's no way that somebody saying that the dog is unclean.
Islamic faith has got a problem with dogs.
Really? Okay, I didn't know that.
There might be a range of views amongst the Islamic groups as well. I think they should speak for
some
themselves
people,
on
for
dogma.
some people, that is a statement of their belief, and this legislation would protect that as a statement of belief. So does the Australian Christian Lobby accept that that's, just part of the quid pro quo of this legislation, that those sorts of statements are going to be acceptable and be able to be made?
I think the Australian Christian Lobby would encourage anybody who feels that they have been discriminated against to follow through the legal process. But if the taxi arrived and the person hopping in with a dog, that taxi would surely need to say, "I'm sorry, I'll call you another taxi." We can't cover, laws are not perfect, and we're not going to be able to cover every single thing. If you drive through a McDonald's drive-through and you order on your phone, you're actually breaking the law, but they want you to order on your phone because of COVID. So our law is not going to cover we can't expect our law to cover every single thing, but this is a reasonable bill, and it is made for reasonable people.
So what you're saying is, because the law can't be expected to cover every single thing, that the fact that those sorts of statements are going to slip through, even though you find them unacceptable, that's just sort of the quid pro quo. It's just what has to happen with this legislation?
I don't think so. I think the most vulnerable people in our society should be always protected.
But with respect, this law is not doing that.
Yeah, but with respect, that's your opinion.
No, it's the opinion of the Australian Discrimination Law Expert Group.
Point of order, Chair. The Senator is talking up repeatedly.
Sorry, Senator Small?
I was
just raising a point of order in that it'd be great if the witness was given a chance to actually respond rather than be talked over.
Yes, thank you.
Can I move on to another issue of concerns that we have with the law? And that's,
this will be the last question.
And that's a practical example of the impact of Section 7 that states that a religious body doesn't engage in discrimination under the proposed Act by engaging in good faith in conduct that a person of the same religion as the religious body could reasonably consider to be in accordance with the doctrines, tenets, beliefs and teachings of that religion, which specifically includes giving preference to persons of the same religion as the religious body. So you've already said that you feel that that's an important part of this legislation.
We do.
So it's practical application in some circumstances. You could have a soup kitchen of one faith turning away members of another faith. Would you be comfortable with that happening?
Well, I think that again, the law needs to actually be a broad enough law to be able to say you are able to have people of your own ethos come in.
So that would be acceptable then?
Well, I think if the law says that, yes, I do.
Thank you, Senator Ross.
Yeah, in the same way as a political party, in the same way as any group, in the same way as Greenpeace would be able to turn somebody away.
So a Christian soup kitchen would be able to turn away a Muslim person who was homeless and needing support?
No. You said you were bringing them into staff. You're talking about staff.
No. I'm talking about people accessing that soup kitchen.
No, they would never turn away somebody needing.
But that's what the law would allow them to do.
No, the law would allow people to preference people of their own religion to come.
That's right.
For employment purposes. Thank you, Senator Ross. We have a couple of questions on notice, and that'll be it.
Thank you very much, Chair. So one of the concerns that I have, and it's growing as the day has gone on, is the practical application of the override. And that's the intersection between the regulatory capacity that this would give the Attorney-General, but the capacity of any territory or parliament to go back and say, okay, well, the Attorney-General says this, well, we're going to change our legislation. The Attorney-General reacts, they change their legislation. The Attorney-General reacts, they change the legislation. Do you have a view, and if you could take it on notice, because I think it's going to be a longer answer than can be required, do you have a view that, as constructed, this override actually creates the potential for an almost permanent conflict between the Commonwealth and a number of states and territories, because I know that that would be very distressing for everybody to have this constant uncertainty. And my final question on notice, if you could, is given your long engagement with this legislation and its multiple, sort of iterations, do you have a set of amendments that you think the Parliament should consider to make sure that this bill does provide protection from discrimination for people of faith at the same time as it doesn't override other attributes that are protected under the ICCPR?
So I definitely take that on notice. If I can just quickly address the first thing in that it's gone.
The backwards and forwards between the state and the feds.
The problem is if the federal law, both parties, both the ALP and the coalition, take the states' rights very seriously.
We do.
And so it's very unusual for them to. So it's not as if we're going to all of a sudden be overriding the states in these issues. But if the states are not providing adequate religious discrimination laws, if they are not providing adequate religious freedom, then it is actually going against United Nations jurisprudence. And we're going, totally against what we are demanded to do as signatories of the UN. And so our federal government really has to play to the ball, and we have to actually have the best federal laws we can have. And if that tends to override the states, then so be it, because this is too important not to get it right.
And the backwards and forwards is of no concern, because that is my concern that's emerging as the day's going on. I understand what you're saying and the responsibility for international convention, but people want this to actually work, not just be an announcement. We need it to work.
Yes.
So if you could take that on notice, thank you, that would be helpful.
Thank you very much. Thank you for appearing before the committee today and for giving your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by the close of business on January the 7th, 2022. Thank you.
Thank you very much. Thank you for your time, everybody.
I now welcome representatives from the Australian National Imams Council and the Australian Federation of Islamic Councils. Welcome Mr. Bilal Rauf and Mr. Kaiser Trad, both via video conference. I just want to confirm that you can hear us.
Yes, for my part, I can hear you. Good afternoon, everyone.
I can hear you.
I'm sorry, Mr. Trad, we cannot hear you.
I think you're muted, Mr. Trad.
You may be muted.
No, I wasn't muted, but I had the volume down. Can you hear me now?
He's coming in very faintly online.
Very quietly.
Is it him or? Yeah, it's you, Mr. Trad. Can you turn your volume up if you can, or get close to the microphone?
Yeah, I'll bring the laptop closer to me. Is it better now?
Yes, thank you very much. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to both of you. Before we begin, could I ask each of you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
Yes, my name is Bilal Rauf. I appear as the spokesperson and also advisor to the Australian National Imams Council.
My name is Kaiser Trad. I'm the Chief Executive Officer of the Australian Federation of Islamic Councils, the national umbrella body representing Muslims since 1964.
Thank you. I'll kick off with the first question. Do you believe there is a need for religious protection to be implemented in our legal framework?
If I can respond to that, absolutely. I think there is a very urgent and pressing need, and in circumstances where so many other attributes relating to a person's identity are protected, acknowledged and recognised, with Australian Muslims, so often they are identifiable by what they wear. So many women, for instance, choose to wear the hijab, men grow the beard, or they attend congregational prayers. Now, that is something, if you ask them, it is absolutely inherent to their very sense of being and identity. And in that context, it's a extraordinary position that that part of their being, that identity, not only is not protected, but not acknowledged at law. And the situation is particularly dire in places like New South Wales, where again, there's no protection against discrimination based on a person's religious belief or practices. And at the Imams Council, we've at first hand heard accounts of people who otherwise don't have a voice or don't have the capacity or platform to pursue issues. And when they come to us, and I've had people come to me and I've had to try and give them practical advice, but in terms of legal advice, the response has been, well, look, unfortunately, there's not much you can do.
Can you give some specific examples?
Yes, of course. So I should say I've provided late yesterday evening a submission, and I've appended to that various case studies and examples which we've drawn from a report by the Charles Sturt University, actual accounts. But just to give you two examples, one is, for instance, of a girl, a female, who started off as a pharmacist, is a pharmacist. She, during the course of her employment, decided to wear the hijab. And this was at a place in the eastern suburbs. She was told in very clear terms that, look, around here people don't like this thing, so if you want to wear the hijab, that's a matter for you, but I won't be able to keep you on here. So that's your choice, and if you want to wear the hijab, then I'd ask that you resign. So that was one example. She ended up losing her employment because she had no choice or ability to do anything about that. And secondly, another example is a young man who wanted to take a little bit of additional time on a Friday to attend congregational prayer. He is willing to start early, work until later to make up for that. And he was told in very certain terms that, this was not a place where, they were concerned about the religious aspect, and he'd have to, he was employed to work certain hours, and that's what it was, and he could take it or leave it.
Thank you, Mr. Trad. Did you want to add anything further?
Definitely, we also feel very strongly that we need legislative protection. There's a number of cases in New South Wales that were heard before the Administrative Decisions Tribunal.
Sorry, excuse me. Can I get you to move closer to your microphone, please?
There was a number of cases that were heard in New South Wales in the Administrative Decisions Tribunal. One case I was personally involved in, which I started when I was president of the Lebanese Muslims Association. A certain shock jock, there's probably no need to name him now, a certain shock jock referred to Muslims as vermin, and we only got up because he mixed the term Lebanese and Muslim, and he used Lebanese part, but we found after a very long process, appeals going all the way to the Court of Appeal and going back and forth between the tribunal and the courts, that Muslims don't have protection. This is vilification that we face regularly. Every time a shock jock or a tabloid journalist feels like vilifying Muslims, they use religion and they get away with it. It's not a theoretical or a hypothetical, it's a real situation that we face on a regular basis, and every time it happens, there's ramifications for people whose appearance indicate that they're Muslim, predominantly Muslim women. The case of the lady who was beaten up at a cafe in Parramatta a couple of years ago, and several other cases, reports we receive regularly of Muslim women and Muslim youth getting harassed or beaten up, and all because somebody starts it by making irresponsible comments on talkback radio or through tabloid journalism.
Thank you. We don't have terribly long, so I'm going to Deputy Chair.
Thank you very much, gentlemen. And you've touched on this, but the joint submission from the Australian Muslim community on the second exposure draft states a concern that the indirect discrimination clause does not conform with the international law in terms of Article 18 of the ICCPR by failing to include necessary in the permitted limitation of manifestations of religious belief. Other submitters to this bill have also raised this as a concern. Does this remain a concern with the current version of the bill introduced to Parliament? Might go to Mr Trad first.
Definitely. New South Wales Parliament had debated introducing religious protection recently, and that debate did not give us that protection. The United States just recently outlawed Islamophobia. Australia lags behind in a consistent national law to actually stop people from attacking others on the basis of their religious belief. Now, this bill goes to give some religious protection, but it does not give the protection that we need merely for being Muslim Australians.
So the anti-vilification shield, you think for your community it would be a clause that could be included?
Definitely could be included. We have been lobbying for it for at least 25 years. I have letters going to senior politicians, and the response has always been negative. And the community has been suffering as a result. As Bilal, speaking on behalf of ANIC, mentioned, that it affects us in employment, it affects us on the streets, it affects us in the access to services, and it causes tremendous trauma for Muslims as we're being made to feel as we are lesser Australians than everybody else.
The Australian National Imams Council, Mr Roth?
Yes, look, to respond directly to your question, in the way that Clause 14 is presently couched, we don't feel that it is deficient. It does reflect the concept as it exists in various other legislation, and to that extent, and if I've understood your question correctly, the issue of reasonableness is in turn defined with reference to other considerations which we think pick up the practical tests. And so from our end, we think it's satisfactory. If I can add one more point, I think this went a little bit beyond the question, but in terms of the anti-vilification provision, one of the points we've made in our submission is this, that the bill as it's proposed, it does pick up the concept of vilify. It defines it. It also says that statements of belief are not protected if they have the effect of, inter alia, vilifying. Yeah. So it certainly provides protection in one direction. It would be just as easy to insert an additional provision which provides the same protection going the other way. So using the same concept. So it's nothing like the provision in the Racial Discrimination Act, for instance. It really is about safety. It's about ensuring that there isn't any malicious nor endangering impact of a statement, inciting hatred or contempt, etc. So we do think that there is a need for that, and that can readily be accommodated having regard to what's already in the bill. But we, coming back to your question though, we believe that the concept and the provisions related to indirect discrimination are satisfactory and correspond to really the other provisions in other related legislation.
Thank you. I'll call Ms Hammond, who is on teleconference.
Thank you very much. Thank you, gentlemen. My question, I think, is to Mr Roof. You gave two examples earlier of the young female pharmacist and the gentleman at his workplace.
Yes.
Would this bill address those two situations?
Absolutely. It would constitute direct discrimination and possibly, well, it might be that if there's some policy, for instance, which says that you cannot wear certain head coverings unless it could be shown to be necessary or have a proper basis, it would constitute indirect discrimination. So yes, it would offer a real protection in circumstances where presently there are none.
Right, thank you. How many members does the council represent?
So the council is comprised of in excess of 200 imams across the country. Each imam typically is heading a mosque or a place of prayer, and they have their respective congregations, which goes from hundreds to thousands. And so through the ANIC itself, it really is a member organisation of the imams, and it in turns engages with the imams. And so, for instance, with the COVID measurements, health measures, etc., we were able to, at ANIC, prepare materials and then disseminate that through the imams to their respective congregations. So in that sense, we've got coverage across the country, and we have the benefit of the feedback coming from the grassroots and the ground level through the imams to ANIC.
Yes, thank you. And how many of those were in support of the bill? Is it a unified or?
It's a fairly unanimous support. I've not heard anyone express objection or concern, or to the contrary, there's been a wholehearted support for this bill and the protection which it provides.
Right, okay. And finally, just more generally, and I do think that you've covered this, but just to I guess, get any greater context, do you believe that Muslim people in Australia suffer religious discrimination as a result of their beliefs?
Yes. Can I answer that at two levels?
Yes.
Firstly, yes, particularly because of the fact that Muslims, like perhaps also like Hindus and certain other minority faith adherents, are very visibly identifiable, and their faith is made very plain by their physical and external aspects. And so that really, and certainly if one looks at various reports, the Charles Sturt report and the Australian Human Rights Commission also issued a report, it makes very clear the prevalence of discrimination, whether it's in the workplace, predominantly in the workplace, and in other public services, goods and provisions, etc. So yes, it does occur. But just can I also, at a second level, particularly post what happened in Christchurch, there is a heightened anxiety. And what we've experienced and the feedback we've got is, why doesn't our religious identity matter? Why doesn't anyone express concern for that and seek to protect that and acknowledge that? There is a heightened anxiety, and I think the message that this bill implicitly sends is that your faith identity matters. We do care about it. We don't push it to one side, and while we're concerned about other attributes, your religious attribute, which is so fundamental to who you are, we don't care for. The bill sends a message that it matters, it is valued, and it is worthy of being protected.
Right.
Thank you. Thank you, Ms Hammond. I have noticed Dr Sinead has joined us. Would you like to introduce yourself and, if you've been listening to some of these questions, perhaps provide a response, because we will have to move on to the next witnesses.
Good morning. My name is Dr. Sinead. I'm the president of the Australian Federation of Islamic Council. I had some problem with my internet. I've just joined in. I will come back for later on.
I wish we had more time, and if you can ask a clarifying question on notice, please.
Okay, and look, I probably will only need a short answer. And look, thank you for your submission, which include, and for the appalling examples of Islamophobia that are being experienced by members of the Muslim community. I think everyone agrees that there needs to be protection from people of faith against discrimination. My clarifying question is, most of those would actually would be discrimination in states where religion is a protected attribute. So did all of those examples that you gave occur in New South Wales and South Australia?
A lot of them, yes.
Yes.
Not all of them, but a lot of them.
Okay, so in fact, beefing up our state and territory anti-discrimination laws could in fact be a significant way to make sure that people are protected against discrimination.
Not necessarily, because of the issues of inconsistency, different approaches, different attitudes. We've had no traction from the state government here. They've said, we're not doing anything until we see what happens at the Commonwealth, then we'll think about it. So there's no traction, there's no real interest from what we can discern. And just as Commonwealth stepped in relation to the Fair Work Act and ensuring a consistent set of laws in the employment context, it's appropriate that it occurs in a discrimination context.
Thank you. And we've got a couple of questions on notice quickly from Senator O'Neill.
And it is disappointing we haven't got as much time as I would like to ask these questions. And you know, that is the nature of the way that this is being managed by the government and the limited time we have. But I do want to ask if you can take on notice the current provisions in the Commonwealth Criminal Code make it an offence to urge violence against groups or members of groups on the basis of race or religion or nationality, national, ethnic origin or political opinion, namely sections 82A and 80.2B. But I understand that the provisions have never been used and they're often criticised as poorly drafted and basically unworkable. I really seek your response to how that might be addressed at this point, because clearly there's some integration with the matters before us. Finally, given how many people of the Islamic faith who have been so demonised for so long in this country, I'm sure that you have a view about amendments to improve this legislation. You may have consulted with the government about them or not. This hasn't been bipartisan, so we haven't been party to all of that. So if you could provide on notice what you believe amendments, whatever amendments you believe might be necessary to actually make this promised bill practical and workable. Thank you very much, Chair.
Thank you. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by January the 7th, 2022. You're now free to leave.
Thank you.
I now welcome representatives from Muslim Women Australia. Welcome to Mrs. Maha Abdo via video conference.
Thank you.
Can I confirm that you can hear us?
I can hear you. Can you hear me?
Yes, thank you. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
Sure. I'm Maha Abdo, the Executive Officer of Muslim Women Australia, based in Sydney.
If you provided a written opening statement, would you like it to be incorporated as part of the Hansard transcript?
Yes, please.
Excellent. I now invite members of the committee to ask some questions, and I'll go to the Deputy Chair first.
Thank you, Chair, and thank you for your participating in this process. In your opening statement, you say that religious discrimination and vilification, even more so, is one of the most challenging issues facing Muslim women in Australia. Could you give some examples of how Muslim women are discriminated against and vilified, and how often it is experienced by Muslim women? And I'm not sure if you heard the earlier evidence. Yes, okay. Thank you.
I did. Thank you so much. I think, you know, with the short time that we have, there's been so much documented cases, you know, with Muslim women being, you know, discriminated against. There's very direct discrimination, but I think right now there's so much going on at the moment with COVID, with services online, and all of the above. I'd like to sort of look at what in my presentation of how positive it is that we can, as people of faith, and how religion can play an amazing positive contribution to Australian society, where discrimination can be hopefully, and I pray that can be eradicated when we practice our faith and our religion in a way that is within the space of freedom of choice. That when we talk about this, you know, we have freedom, but right now religion does not have, we don't have freedom under the Religious Act. And I'm not here to talk about the Act because I'm not a lawyer, but with my lived experience of working in the field, working with Muslim women, and now, you know, in the last 10 years, working in a space with providing services to women of all background and of all gender, I think this will bring a different light and a different angle to what we're talking about, rather than focusing on a particular aspect, which we continuously are talking about. But I'd like to move from a victim mode to a space where freedom is actually lifted in a dignified way, if you allow me.
Okay. Thank you, Mrs Abdo. The current version of the bill, as introduced, does not have an anti-vilification provision. Do you still support the bill as introduced?
Look, I think Raouf and the others have submitted to it, their submission in regards to the legal aspect. I'd like to look at it from the social impact. When there is a religious freedom, when then Muslims, Christians, Buddhists, and all people of faith and no faith have legal playing field, where they're able to feel that their identity is being respected and accepted. I think this is this will be, hopefully that bill will give it that platform where we can start having that interaction at that level from a social capital perspective.
So whilst putting words in your mouth, I suppose, Mrs Abdo, so overall you would support the legislation?
Yes.
Yeah.
Yes,
okay.
yes.
Thank you. Thanks, Chair.
Mrs Abdo, thank you for coming today. Do you believe Muslim women in particular are more at risk of experiencing religious discrimination?
Well, it's not something that I believe in, but it's something that I've experienced and I've lived with over the last 40 years in my capacity is working in the community and working with Muslim women over the many years where it's out of if it's no choice of their own, but it does happen and it continuously is happening in that way. Yeah.
Because you wear your faith.
Because you wear your faith. It's an external evidence.
Yes.
So can you give some specific examples of some of the discrimination that Muslim women have experienced here in Australia?
Look, I think there's a whole report from the Islamophobia Register that has come out from the Charles Sturt University. There's so many documented reports, and especially in some of the documented ones that the ANIC and AFIC have submitted. And what we're seeing is that whilst we sometimes may take one step forward, there's always these, discriminatory responses to Muslim women because of the way the hijab and they're very visible in that way. So where discrimination is actually happening is, some examples would be very, very clearly not long ago where, one young woman wanted to access certain health services and wanted to make her own health choices and was literally being, guided in a different way. And then, being able to make your own decisions in accordance with your own faith that is not going to be harming anyone should be covered, and you should be able to do that. I think and that comes down to identity. I think for us as Muslim women and Muslims all over, it's this, because identity is not just a race and a gender issue for us. For me, it is, and for the majority of Muslim women I've spoken to, identity is very much part of the heart and the soul, is what makes you who you are as an active participant and citizen in society. So to do that, you need to feel, and you need to be feeling that there is a protection in the law, that your religious identity is not something that you continuously have to justify for and call out every, discriminatory act in that space. So we need to really, really look at some of the positive aspects of what's happening. At Muslim Women Australia, we are now providing services to women of all faith and no faith. And I think that's a great example where you see women of faith are able to do that in a non-discriminatory way, where you can actually provide and use faith as a tool for empowerment, not to in people's lives, where it brings hope back, it brings your backbone to society. And I don't mean it in any way, but bringing hope back in action. where young people feel that, you know, they're not continuously having to justify for who they are or why a young person prays 5 times a day. So, you know, I'd like to see that this bill creates a space where open dialogue can take place, where there is a amicable interaction without discrimination, with the real freedom that provides freedom for other, you know, people, I suppose.
Chair, can I support you in your line of questioning and just ask one question that I hope might be received by the witness to get on the record the evidence I think that we need. So, Mrs. Maha Abdu, I hear everything that you say about the desire to shift from a victim stance, and I particularly hear you as a woman. However, much of the way that the debate about this legislation is playing out in the public place is based on statements of victimhood, and there are lots of voices that are out there saying that. And I know that you want to avoid positioning women of Islamic faith in particular as victims, but you've spoken in very general terms about one example of a woman seeking healthcare and unable to receive the healthcare she wanted because she ran into some opposing worldview that prevented her from getting what she wanted. We actually need, for the public record today, as much as it may sadly offend you, we need real life examples of the genuine offence that is being inflicted on people of faith, and not in the CSU report. We need, sadly, your voice to be that voice today. If that's okay, Chair, I think that's what we really need. So can I impose on you in that way?
Thank you. Can I take that on notice and submit cases that we have?
I'd like you to do that, but could you give us a couple actually live today? Because you've alluded to one, but I don't understand the detail of that.
Okay. All right. So, I mean, another example that if we move away from the health one, example of accessing services, or women at school, for instance, young women at school who aspire to be, you know, professionals, who continuously have been, you know, told that you know, you don't need to go to university, you don't need to go because your faith, your religion, you know, women are submissive and you're not going to be able to work. So therefore, don't worry about your marks, don't worry about getting access to further education, right?
And then, are you saying that teachers are saying that to young people of Islamic faith?
Well, yeah, well, teachers and career advisors in areas where they're not aware of the differences between cultural and religious practices. It happens every day. We get phone calls at MWA with young women asking, can I be a lawyer? Can I be a doctor? Is that you know, against my faith? So these are things that are continuously being, you know, transmitted, I think, to the minds of young women to oppress young women more by calling it out as though it's your faith, it's your religion that oppresses you. On the contrary, Islam does not oppress you, you know. But these are this is one you know, incident, that there are others, so many in employment, for instance. I mean, you know, there was a young woman in childcare who, again, wore a head cover, but somehow the childcare changed management, and then the managers didn't like someone who was wearing a head cover because it will have an effect on young children. That's another example. There are examples of young women, you know, being at the beach or in the park, or families with Muslims and wanting to pray in the park. Then again, there's the feeling of, you know, feeling unsafe. Not because it's not something that you just imagine, but there are people who will come out and tell you cannot pray here. So exercising those rights, and for women especially, those that are, you know, practicing their faith in the holistic way of practicing that within a peaceful environment. When you are being literally, you know, told that you can't pray, you can't wear your hijab and all that, you start to question your own identity. And that creates that sort of a mental health issues as well. So, and these are things we're dealing with on a daily basis, that I'd like to present cases to the inquiry here, because I think to do it justice, and for me to really do justice to the women that I'm representing, it is important to document that and bring that to you. We've got it all documented.
Thank you, Mrs. Abdo. Thank you, Chair.
Thank you, Mrs. Abdo. And Senator, I'm going to Ms. Hammond, then to Senator Pratt, and then our time will be up, I'm sad to say.
Thank you. Thank you, Chair, and thank you, Senator O'Neill, for that line of questioning. It was a very similar line of questioning that I wanted to go down. Mrs. Abdo, I'm actually very taken by your argument in favour of freedom as opposed to victimhood, and I agree with Senator O'Neill. We need to get the instances on the public record, but your perception of this bill and perhaps other anti-discrimination bills, is it to incorporate freedom for all people to be who they are?
Yep, I think if we don't have freedom for people to do what they need to do within the framework of freedom of choice, and without oppression, without forcing people to do things beyond or without their choice and making informed decisions, then I think freedom is something that religion is not covered under that. That's how I see it now. I feel that, and rather than continuously talking about being victims, of course there are victims, and there are many attributes already protected under the banner of freedom, but religion is not protected. So my question is why is it not protected? Why can't it be like every other attribute that's happening now, and therefore we can all work around that holistic way of contributing in a society where freedom is being lifted with dignity and values that are driven by humans in an interactive, non-discriminatory way.
Yeah, it's so a number of people do have very genuine concerns about the conflicting freedoms or the conflicting, that if we give freedom for religion, is that going to impact upon somebody's gender identity, or how do you see all of those? And what's your response to that?
Look, I've worked in the field. I've worked with people of all faiths and no faiths, with gender, with all, and I think when you know who you are, and your freedom is not being impacted by other people's freedom, then you're able to work together in a way that you protect and you respect other people for their choices of who they are. And that's what I see, that from my experience and the way we work, is that you're here to respect people's choices, and but freedom of religion should not hinder us from interacting in a way where there's equality in the freedom,
Yes, and an equalness. Oh, thank you, Mrs. Abdo. One final question: how many members do you represent? Just so that we have that for the record.
We've got over 10,000 members, or over. I think we've got over 10,000, and I can confirm that. But our membership is very wide, and we're Australia-wide, but we practice within Sydney and Melbourne.
Thank you.
Especially in the space of family violence and domestic violence.
Thank you, Mrs. Abdo. Senator Pratt, we are out of time. What I'd like you to do is ask your questions on notice. Thank you.
Well, if there is time, I'm struck by your characterisation of the kinds of discrimination Muslim women currently experience. In the context of this legislation, the legislation, as I see it, will protect someone in their place of work, for example, at the pharmacy, that example that we heard, but not for the views of their career counsellors within, for example, an Islamic school. And I wanted to get, if on notice, if you like, get your views about this legislation privileges the view of the institution above the individual religious view or even a minority religious view or an equal or a woman's religious view as opposed to a man. It will privilege the views of the institution over and above that individual, the person being counselled, if you like. And I wanted to get your insight really into how we need to even that out.
So we'll just put that on notice. Is there any other questions, Senator Pratt?
No, if there's time, I would really desperately like an answer to that on now.
Mrs Abdo, if you can manage that briefly, that would be great.
Well, I think if we're talking about, an Islamic institution, then Islamic institution is driven by Islamic principles, which is human rights, comes under the banner of human rights principles, literally, and giving people enough, plenty of opportunities and choices, and to make their own informed choices. This is what we do in our organisation when people are asking for services. It's not that we refer, we have access to people that don't think like us and don't look like us. So I feel this is a great platform that we can do that. And it's not about a man's world or a woman's world. It is about a human rights world under the framework of where we work from a trauma-informed practice. And I think it's about freedom of choice, but freedom of choice has to be combined with information so that people can make their own choices. And how do we decide that? I think, again, there's about accountability, and it's about, mainly accountability to the people that you're serving as well.
I like your worldview. If you could take on notice perhaps how we can deliver that legally, that would be terrific.
Thank you.
Another question on notice.
One more question on notice, thank you.
Which was, Ms Abdo, whether you've got concerns about statements of belief actually permitting ongoing discrimination against Muslim women because they are statements of belief of other people who hold discriminatory views about Islam, and in particular about the role of women.
Thank you, Senator. And the other final question, Mrs Abdo, is if you have any amendments that you think should be considered in the bill, if you haven't already provided those, that would be appreciated as well. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 7th of January 2022. Thank you for your evidence.
Thank you. Thank you so much.
I now welcome representatives of Christian Schools Australia, the Australian Association of Christian Schools and the Australian Christian Higher Education Alliance. Welcome to Mr Mark Spencer, Ms Vanessa Cheng and Mr Nick Jensen. Also welcome to Reverend Dr Ross Clifford and Mr Mark Snedden via video conference. Can I quickly confirm that those on video conference can hear us?
Yes.
I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. For the Hansard record, will you each please state your full name and capacity in which you appear today, and we'll start with those on video conference.
Good morning, I'm Vanessa Cheng. I'm the Executive Officer of the Australian Association of Christian Schools.
Thank you.
Good morning, I'm Ross. Excuse me. I'm Ross Clifford, and I'm the principal of Moreland College and the founding chair of ACHIA.
Thank you. If you could get a little closer to your microphone, that would be fantastic. And finally, we have Mr. Mark Snedden. Mr. Snedden, can you hear us? Apparently not. Okay, Mr. Mark Spencer.
Mark Spencer, I'm the Director of Public Policy for Christian Schools Australia.
Thank you.
I'm Nick Jensen, I'm the Political Liaison for the Australian Christian Higher Education Alliance.
Thank you. If you provided a written opening statement, would you like it to be incorporated into the Hansard transcript?
We haven't provided one yet.
I don't know whether anyone has. Beautiful. I'll now invite members of the committee to ask questions. Have we got someone online who would like to do that?
I've got one, Chair.
The Deputy Chair has beaten you to the post. Thank you.
To Mr Spencer, to start with. Your submission calls for sections 7, 6b and 7, subsection 7 to be deleted. The subclauses delegate power to the Minister to determine the content of publicly available policy required of educational institutions. Could you explain why that delegation of power to the Minister is unacceptable to your schools?
Yeah, so what we've suggested there in 7.6b and subsection 7 is a similar approach to that taken in clause 11, where the requirements for the policy are actually set out in the body of the legislation rather than having some nebulous power for the Minister or a future Minister to impose requirements that we don't know about and don't see. It seems a fairly straightforward requirement.
You trust the collective of the Parliament rather than the individual Minister?
Without any aspersions on the Minister's current or future, yes.
Okay, good answer. You go far in this game. Now, the submission of Christian schools accepts that anti-discrimination or equal opportunity law inherently involves a balancing of human rights. Professor George Williams has provided a submission to the committee on this bill, and Professor Williams is concerned that the bill is inconsistent with Article 18 of the ICCPR because the bill, and I quote, provides an elevated status to religious speech but fails to protect speech on matters of thought or conscience. Could you comment on that?
Again, we'll defer to the legal experts. I know you've heard from some earlier today, but the Act deals with religious belief and activity, which also includes non-religious belief or activity, which I would have thought covered some of those other requirements of thought and conscience that you talked about.
Okay. My next question is to Vanessa Cheng. Ms Cheng, one suggestion is that Clause 14 of the bill be amended to include the word necessary in the reasonableness test to rectify its current inconsistency with international law. Is it important that this law be consistent with international law?
Short answer is yes.
You can leave it very short if you want.
Right.
Okay. Do you want to elucidate, or you're happy with that?
Our submission goes into more of the international law precedents of that, but yes, we would think the bill should be consistent with international law in the area of indirect discrimination.
The Chair loves it when we have more time to include the committee. Now, my next question is to Mr Jensen and Dr Clifford and Mr Snedden, so I'll let you, whoever wants to answer. The submission made by the Australian Christian Higher Education Alliance to the second exposure draft focus on concerns for Australian students and faith-based institutions, including examples of expulsion or disciplinary action of students from public universities for, and I quote, privately sharing their beliefs on campus or through social media. The submission gives one Australian example, but could you tell the committee how often students are expelled or disciplined for privately sharing their beliefs on campus or through social media?
In public universities?
Yeah, well, you'd mentioned as public universities.
Yeah, I mean, we've only got sporadic examples because we're mostly in the independent university sector, but there are stories in Australia and overseas where we've seen students who have been disciplined because of a sharing of their faith and even barred from their profession and
If
course.
you could just focus on Australia rather than overseas examples.
We've only got limited examples because we don't have access to student records of public universities.
So, but no one has approached you, so...
No, there is a website called Australia Watch, which has got lots of individual cases, some of which are from students. That would be our best recommendation.
Okay. And would the current bill, as introduced, allow these students to privately share their beliefs on campus or through social media? How you can privately share things through social media is slightly problematic, but...
I might defer to Mark Snedden on any addition, but in my understanding, it does appear to provide more protections for students from qualifying bodies, like universities, who may restrict them or treat them unjustly because of their religious belief.
Okay.
Thank you for the question, Mr. Perry.
Yes.
Sorry, would you like me to answer that?
Sure. Yep.
Apologise. I was not hearing the committee earlier on. So, Mark Snedden. So, in answer to your first question, at australiawatch.com.au, there are 2 documented cases of students having been discriminated against or disciplined for expressing non-inflammatory moderate views. One is the case of Andrew, a student in South Australia, who was asked by other students who he had identified as a Christian. He was asked by them, what would you do if you had a friend who was gay? And he said, well, if they're my friend, I would love them, but I don't agree with same-sex sexual conduct. That was all he said, and he was reported and suspended from his course. So there's one example. And there's another example.
So that was a South Australian case, was it?
Public university, as you're asking, yes.
Yeah, okay.
Yep, South Australian Public University.
Mr. Snedden, can I get you to lean closer to your microphone, please?
Sure, I'll do my best, okay.
And sorry, what South Australian University was that?
I don't know because I don't think that was identified, but I could provide that information for you.
So, but it's on the publicly available webpage you mentioned, was it?
australiawatch.com.au, that's right.
And it lists the university. Yeah, it's a public case.
It was a case run by the Human Rights Law Alliance, which put that, who are religious freedom lawyers. They ran the case for that student to get the suspension overturned, so they would know the university. I do not know the university, but that information could be
I beg your pardon. Yeah, okay.
And there was another case with a university student. Again, I don't know the university, but it's a public university in Australia, who was reported for emailing her lecturer, just a private email to her lecturer, about her objections to a class-wide promotion of International Day against homophobia, biphobia, intersexism and transphobia. And in that email, she explained how Christians could find some aspects of ideology, of LGBTIQ plus ideology offensive, and she was reported by her lecturer for a breach of the university code of conduct. She was threatened with discipline and told to keep her religious convictions to herself. So there's 2 documented examples which were real cases of discipline against students at public universities.
All right, thank you. Thanks, Chair.
I'm going to Senator Small.
Yep, sorry, Chair, just coming off mute there. Folks, thanks for your time this morning, and I hope to sort of cut to the chase a little bit with some of the more contentious discussion around this bill as it relates to the ability of independent schools to maintain a particular ethos. So I guess, do you believe that educational institutions should be able to preference staff that adhere and uphold the same doctrines and beliefs of the school?
Yes. Simple answer. That's
That
what
would
we're
be
about.
a tough one to start.
That's why parents choose us.
And I mean, on that point, can you elaborate a little bit as to why it is important to maintain the ethos of the school?
Well, if you don't maintain the ethos of the school, we cease to be the schools we claim to be. We are schools. Schools are an education business. Schools are a people business. It's about the staff we have who can share our faith and beliefs, model those to students, model those to the community, reflect that in all we do and all we are.
So in terms of the proposed legislation that we're discussing today, how does that impact on the ability of a religious school to teach students in accordance with its beliefs? And I guess, is it everything that you would want to see? Is it only part of what you would want to see? Or what's your assessment of this proposed bill?
I'll leave Vanessa to comment on behalf of her schools, but on behalf of our schools and in our submission, we've indicated we're supportive of the bill. It does provide the initial level of protection that we believe is essential. There are certainly room for improvement, and there is a 2-year review built into the bill, and that might be an appropriate time after having had a couple of years of it in place to then see whether it needs to be strengthened or whether it is adequate in practice.
Did you want to add anything to that, Ms. Chen?
Yes, if I could add, from our school's perspective, we take the role of and the responsibility of parents really seriously, and to ensure their education and their religious education of their children. And as this committee is looking at the human rights and the international standards on human rights, I'd like to draw attention to Article 18.4 of the International Covenant on Civil and Political Rights that protects the liberty of parents and legal guardians to ensure the religious and moral education of their children in conformity with their own convictions. We believe this bill would deliver on protecting the right of parents to choose a school that reflects their values and beliefs, their Christian values and beliefs, that they would like their children to be taught. The way the schools to be able to deliver on that protection, that international standard, so to speak, is through choosing staff that are willing to uphold the ethos and the mission and the values of the schools. That's why our schools were established. In many cases, our schools were started by parents who put money into starting a school that was, going to deliver a holistic Christian education. That Christianity was not going to be taught as a separate subject, but it was going to be imbued and embedded in all parts of the Australian curriculum and taught through that perspective. So we're really pleased to see the protections delivered through this bill, and we're really hopeful that it will be passed by the Parliament.
Just for anyone that's listening along at home, Ms. Cheng, can you just, I guess, be clear that although you're here representing an association of Christian schools, is it your understanding that the bill operates in the same way for a school predicated on any other faith?
That's right. So the bill protects any religious school. I'm representing this independent Christian schools, over 100 schools in every state and territory around Australia, but the same protections would apply to an Islamic school or another school on any other religious faith.
Senator Small.
No, thank you.
Senator Small, just hang on a second, please. Mr. Jensen has a response he'd like to give.
Could I just answer your question as well, Senator Small? Often when we talk about faith-based education, we focus on schools, but it is important to note that there are faith-based higher education aspects at play here, where really we describe ourselves as communities of faith seeking understanding. And there are issues in higher education which are different to schools and different to public universities when they're faith-based. So, like Mr. Spencer said, we can't exist without the freedom to teach the doctrines from our religions, without the freedom to employ around that ethos, without the freedom to require ongoing commitment to codes of conduct based around a religious text, and the freedom to resolve moral and ethical decisions according to those texts. These are absolutely fundamental, and we think this bill goes a long way to doing that and allowing the existence of communities of faith that do seek understanding.
Thank you. Senator O'Neill, a clarifying question?
Yeah, well, just the scale I'm interested in, because we had Ms Cheng indicate that over 100 schools. How many students do you represent there, Ms Cheng?
We have over 42,000 students enrolled in our schools.
Thank you. Mr Spencer, could you put it on the record how many families, how many schools and how many students?
We have over 87,000 students in our schools and the advanced schools, which we made the submission on behalf of, in over 250 locations around Australia.
Okay.
Sorry, you said 87,000?
87,000, yes.
And 250 schools. Mr
250
Jensen,
locations.
how many?
So we represent 8 higher education institutions, colleges and universities, about 10,000 students.
Okay, and is there anyone else who needs to put anything on the record? No. Thank you. That was just the scale. Thank you very much.
Senator Small, have you finished your questioning?
No, just a couple more briefly on this point, thanks, Chair. And your point around employment is well made, I think, for the same reason that I don't fancy my prospects getting a job with the Labor Party, and likewise for Senator O'Neill. We enjoy our work together. Can I ask the other obvious side of this, and that is with respect to students. So does this bill allow LGBTIQ students to be expelled or dismissed from the schools and higher education institutions that you run? And is that something that your members want?
So I think the Prime Minister made that very clear if you were listening to your own leader statements when he introduced the bill. And this bill doesn't deal with that issue.
I know what the Prime Minister said. I'm asking
this bill deals with religious discrimination.
Of your members for a response.
Yeah. So this bill deals with religious discrimination. That's the name of the bill. That's what it's about. It allows faith-based institutions to take actions in accordance with their beliefs and doctrines and tenets, and that's the sum total of what this bill allows.
Nobody else got anything different to add to that in witnesses?
Could I
Yes.
clarify
Certainly.
something? Thank you. Mr. Spencer's right. This bill deals only with discrimination on the basis of religious belief or religious activity. So if your question is, does this bill facilitate discrimination against a staff member or a student on the basis of their sexual orientation or sex or gender identity or relationship status, the answer is no. It only deals with discrimination on the basis of the staff member or the student's religious belief or religious activity. And that's it. All those other issues about other attributes are dealt with under the Sex Discrimination Act, which is not affected by this bill.
Thank you. Senator Small, are you
Indeed.
finished?
Yeah, thank you very much for that. I think it's important to clarify.
Thank you. Senator Pratt.
Thank you. We'll turn now to the Sex Discrimination Act, and I know there's a review from the Australian Law Reform Commission, but I know you've also thought about this issue. Can I ask if you think there's a better way of balancing the importance of non-discrimination in the attributes covered under the Sex Discrimination Act, such as sex, sexual orientation, gender identity, marital status, or pregnancy, or perhaps the use of reproductive technology on one hand, and the importance of guaranteeing the right of religious schools to act reasonably in the conduct of their affairs in a way consistent with their religious beliefs?
I think we discovered back in 2018, 2019 that that's a very complex problem, and that's why the referral was made to the Australian Law Reform Commission as an expert body to be able to give that proper and due consideration. We welcomed that at the time. We continue to welcome that and look forward to that process, which did start and then was put on hold. That's the appropriate forum to have those issues resolved, because it's not simply a case of striking out Section 38(3) of the Sex Discrimination Act. It's too clumsy an approach. But we'd certainly welcome the ALRC having that in-depth inquiry and dealing with it in the proper course of its job.
Okay, in that context, may I ask, in terms of institutions that want to uphold their values or religious values or non-religious values, what's the difference between a religious institution exercising the right to discriminate through those carve-outs and other institutions? You know, we are preventing discrimination in this bill on the basis of a religious identity or holding a belief in a way that means other institutions have to balance that out. But the Sex Discrimination Act carve-out means that religious institutions do not, even if there's dissent or debate or questioning within the religious paradigm. How do we make sure that the law treats everyone equally?
Well, I think if you look...
You must have thought about that. I know you've sent it off you've supported it going to the Australian Law Reform Commission, and you've said it's difficult, but we still need to come to grips with the fundamentals of that in the context of the debate we're having now.
And I think international law allows for that legitimate differentiation, and that's a reasonable test and approach to actually take in looking at that issue. How do we get to that legitimate differentiation? Now, we saw back in 2018, 2019, when this was extensively discussed, there was a whole range of approaches thrown up there. We haven't settled on the way forward that's actually going to be a form of words to do that. So I can't answer your question in detail because it requires more thought and really is quite separate to this current conversation.
Why is it separate to the current conversation? Is it separate just because it's a different bill, or is it not intellectually linked?
Well,
different attributes, Senator.
Yeah.
Sorry, Mark.
Yep.
Go ahead. I was just going to say it's a different attribute. This bill is about religious belief and religious activity. It's not about all of those attributes you're discussing. That's the Sex Discrimination Act. So they are conceptually separate bases for discrimination. And your questions are legitimate about what is the extent of the exception in the Sex Discrimination Act, but that is not affected by this bill.
Well, and I understand that. I guess the question is if someone has an attribute and they express and they have protection for that attribute, but they don't have protection about their belief about that attribute in a way that someone who holds a religious belief about that attribute does. Surely that brings these issues into play in the context of this legislation.
Well, not necessarily, Senator, because there's not an identity or congruence between all people who have a particular sexuality, sexual orientation and their religious beliefs. As you would know, some people who have a sexual orientation, same-sex orientation, have a religious belief, some do not. Some of the religious belief reconcile that by saying that their religious belief accommodates their sexual orientation. Others say it does not. So I need to live celibate and find intimacy in non-sexual relations.
Yes, that's right.
I mean, there's a range of... So there's not a congruence to simply say someone's same-sex attracted must have a belief, therefore will fall foul of this bill. They're just conceptually different categories. And I come back to the point again that nothing in this bill is going to change the law as it currently is or as it may be after the ALRC's review of the Sex Discrimination Act. And it's better to let the ALRC do that work on what are admittedly complex issues in relation to sex discrimination attributes under that Act after this bill passed.
Have these issues been successfully resolved in other jurisdictions? Is there a way of resolving it? Or are you ultimately going to argue for the status quo?
Talk about the Sex Discrimination Act, Senator?
Yes.
Well, I have not written a submission to the ALRC yet, so I'm not, other than seeing that the issues are very complex, I'm just making a submission about this bill. But I'll stop talking and let Mark and Vanessa and Nick have a go.
And look, conscious of time, and we were told we didn't have opening submissions because time was short. I mean, this seems to be, through you, Chair, a little bit of a divergence from what we're about today. Happy to take it on notice if we want more comprehensive responses.
That'd be great. Thank you.
Thank you. Senator Pratt, are you completed now?
Yes, thank you.
Thank you. Mr. Goodenough, I believe you have a question.
I do.
Yes, Madam Chair. That relates to the bill, and if the provisions in the bill are not implemented, what impact will this have on the way religious schools operate?
I think particularly the case in point will be religious schools in Victoria, where there has been amendments passed to the Equal Opportunity Act down there, which impose quite draconian, quite onerous requirements on faith-based schools in Victoria, and allow the government there to really reach into faith-based schools, particularly from our perspective, but also religious bodies more broadly. The legislation, the second reading speech of the amendments to the Equal Opportunity Act down there talk about affecting the employment of religious bodies themselves. So that legislation really goes to the heart, to the core of who we are as Christian schools. It would affect any tertiary bodies in Victoria and also religious bodies more broadly in Victoria.
Could I add something to that as well, Mr. Goodenough? For faith-based higher education, one of the issues that really isn't covered is around qualifying bodies for higher education. So there's a case by Trinity Western University in Canada where we saw that a law professional body refused to recognise the course and the graduates from a university because of their religious beliefs. Now, we don't have any protection if that same thing happened in Australia, so that's why we think that this fills a really important gap in higher education.
Thank you. I'm conscious of sharing the love both sides of the government, or the government and the opposition, and I'd ask Celia Hammond for a question.
Thank you. Sorry, I got the camera on. Thank you all for appearing before us. Now, my questions are going to be, I guess, a little bit more specific. The bill is designed to, it's allowing religious or faith-based organisations to employ people in accordance who support their religious views. My question to you is that in a lot of faiths, things like divorce extramarital relationships. All of these things are not supported by certain faith bodies. If you had an employee who was divorced, what would be the approach of your particular schools or your particular organisations to that?
And it depends. I love hypotheticals because you've got to delve down in the details of how you actually deal with people pastorally and caringly in an abstract situation where you don't know the context. So with those caveats on that, it would be a process of working through with that person whether they still held to the beliefs of the particular school body, whether they could model and reflect those beliefs in their practice, in their relationships, in their conduct within the school community. Now, that could be across a range of things. The fact that they were divorced may or may not, depending on the particular context and how they've responded to that, impact their employment. It really is impossible to be clear on that. You could have a range of situations where, depending on how they responded, whether they were a suitable fit for that school anymore.
Could I invite my colleague Ross Clifford to answer that as well, being on the ground, as it were?
Certainly.
Yes, that would certainly be the case for, I assume, most of us in higher education, tertiary education. With respect to divorce, we'd look at that matter on a case-by-case basis and actually see, as far as we could, what was behind that situation. I mean, if it's a divorce because the person is living a totally inconsistent lifestyle and the partner, left them because of their infidelity or whatever, that would be very different from a divorce situation where the marriage is just clearly broken down and both partners just believed they could no longer live together in that capacity.
Right, okay, so it depends on the circumstances. Would it depend on the response of the particular school community?
Yes, it certainly could. And each community might have some value statement with respect to divorce and remarriage. In my community, divorce and remarriage is something that we would consider according to the particular circumstances of that divorce and remarriage.
Okay, so just extrapolating from that, and I don't mean to be a devil's advocate here, but when we do talk about it being protecting, higher people of a particular faith, that then does also touch on the way that they live their lives, doesn't it? Because, and that goes to sexuality, it goes to gender, it goes to marital status, it goes to all of those things, doesn't it? So while this is separate from the Sex Discrimination Act, I completely understand concerns that have been raised about the interplay between these various pieces of law. And I'm sure you understand the interplay too. So in terms of actually giving you an opportunity to address some of those concerns, I guess that's what I'm opening it up for.
And what this bill will require is, when it comes to those issues in relating to employment by Christian schools, that those actions are taken in accordance with a publicly available policy, which sets out what we believe, how we're going to respond on the basis of those beliefs. Now, that's not going to... That's not the case. So that's not going to go down necessarily into the micro detail of every step of every single process, but provide a clear enough and broad enough framework to make it very clear to anyone coming to work in our schools or working in our schools what we believe on a range of topics that we want to take action on and how we'll respond in those situations. So I think that's an appropriate balance of making it very clear who we are, what we stand for, what we believe, how we'll respond. And people can choose to join that community or not.
But I think on the interplay, I think I need to be honest here. I mean, the interplay is clear, and from my perspective, we would support the bill, but we wouldn't support the bill if there was some other deal done with the Sex Discrimination Sex Discrimination Act. So I think so I'm very happy to do that compartment approach that this is about this particular bill, and I fully agree with that. But in the world of politics, our support of the bill is on the basis that this bill is considered in its own merits and dealt with on its own merits, and it's not a trade-off with respect to a Sex Discrimination Act, which would greatly impact us as a college.
Thank you. Ms Hammond, are you done?
I've got further questions, but I'll put them on notice. Thank you.
That would be great. Senator O'Neill.
Thank you very much. And I do want to get to some of the details around Section 11 and Section 12 because it really is important that we get there. But before that, I just want to put on the record that on the 13th of December in 2018, the Prime Minister announced that the government was going to bring in this Religious Discrimination Act and appoint a commissioner. That was before the 2019 election. That didn't happen. Then on the 29th of August, the Attorney-General released the reports. The government announced its intention to legislate during the final sitting weeks of 2019. That didn't happen. Then on the 25th of November 2021, the Prime Minister finally introduced the Religious Discrimination Bill that is the subject of our discussions today. And I'm wondering what's going to happen. So I really want to understand the practicality of that, of what's going to happen. And you know, as I do, that amendments could proceed. So I want to go to December the 1st and with regard to the Sex Discrimination Act, because a number of Liberal Party backbenchers announced that the Prime Minister had done a deal to repeal Section 38.3 of the Sex Discrimination Act in support for their support of the Religious Discrimination Act. But there have been suggestions recently that the Prime Minister's now backflipped on that deal, or maybe he hasn't. And given the uncertainty of the progress of this legislation, I think it's material that, you know, that come up for discussion today. It's kind of hard to keep up with where we are. What's your current understanding of the government's position on Section 38.3 of the Sex Discrimination Act? And do you have any confidence in that position?
We understand that there is no deal being made, that there were no amendments proposed to this legislative package that would remove Section 38.3 of the Sex Discrimination Act, and we will take the government on its word on that basis.
So I understand you want to do that, and we all want to take the government at its word, Mr Spencer, but there's got to be a lie somewhere in the middle of this. Either Mr Morrison has promised the moderate Liberals in his party to strike a deal to protect gay students, or he has not, and he's told you one thing, but it's a matter of public record that he's told members of his own party a different thing. Do you actually know where the truth lies in that great chasm?
And despite the joys of privilege that applies to this committee, it's not my place to call anyone a liar. We've worked in good faith with both the government and the opposition, and I do want to acknowledge that and put that on record as well. Yep. The honest and open conversations we've had with both sides of politics.
That's very good. Thank you for putting that on the record, Mr Spencer.
And do appreciate that, and we'll continue to take that until we find otherwise by someone's actions.
Thank you. So we all hope that truth will prevail. Can I just go to Section 11 of the Religious Discrimination Bill? You're representing that significant number, hundreds of thousands of students and families. In terms of its practicality, that's my main concern. There have been a number of issues raised about whether it's going to hold water. So it could be used to override the state and territory laws in relation to employment related decisions by religious schools, if those laws are prescribed by regulation. But the Attorney-General has to be satisfied that the law prohibits discrimination on the grounds of religious belief or activity, plus prevents religious schools from giving preference to persons who hold or engage particular religious beliefs or activity in an employment context. Now, if the Attorney-General prescribes a state or territory law by regulation, couldn't that state or territory parliament simply just circumvent Section 11 by enacting a new law? And you've heard this concern that I've expressed about an ever-ending cycle of conflict over an issue of fundamental identity that people of faith hold very dear in a state of permanent contest for the foreseeable future. What's your views about Section 11 and its capacity to do the job?
Again, I would defer to the wise legal minds. I might ask Mark Snedden for his comment on this. He might be a better placed than me to respond. I would be extraordinarily surprised for any government to act in such incredible bad faith to perpetuate that sort of problem, which is in no one's best interests. Despite the joys of our federated nation, if we can't have state and territory governments and the federal government actually acting in a somewhat coordinated manner to avoid that problem. I think it would be a pox on both houses, so to speak. If there was that situation occurring, there's also always the possibility of coming back and amending this bill for that very clear, very established process and problem. I think that's probably the way to deal with that than trying to put in place now a more convoluted method that just has the effect of deferring this bill.
Because the uncertainty in this space is now long-lived, and it would be really remiss of us as parliamentarians to enact legislation that leads to a continuation of uncertainty that could be so negatively impacting the entire sector, and compromise people of faith's hope that this bill will actually settle for them the full suite of their rights in line with international conventions. Do you have confidence that the government has done what it promised in response to the Ruddock report, engage with the opposition crossbench and stakeholders in a consultative process, allow for bipartisan agreement, introducing a bill with the Parliament's broad cross-party support? Have we reached that, or is this a bill that is still highly contested and contestable?
Well, we've certainly been, and a chair and other bodies I know have all been encouraging the government to work on a bipartisan approach through this. We know that
that hasn't happened, has it, Mr.
We know
Spencer?
that the two Attorneys General have had carriage of the matter on the way through as well. We understand there has been some discussion, probably not as much as we would like.
Yeah.
And we're looking forward to that discussion continuing over Christmas break through these committee processes and be able to have some a clear bipartisan support for this legislation early in the new year.
Clearly, when the legislation is not seen by the opposition until the day it lands in the Parliament, it doesn't indicate in any way that there was a bipartisan approach to what we're investigating today.
Move along from the politics and get to the bill.
Well, I hope that the bill is actually going to deliver something that's above politics, but I don't know if we're going to get there. Do you think there are better
Senator,
ways?
may I make a comment? Sorry, can I just add to that question?
Yes.
Which is
Mr. Snedden.
I think I think it's an unlikely, even a far-fetched scenario that the Victorian Parliament would seek to evade the effect of the federal override by enacting another anti-discrimination law with another name, which prohibits discrimination on the ground of religious belief or activity and prevents religious bodies doing that. I mean, all that the Attorney General needs to do is make another regulation naming that law. So that it's a pointless exercise by the Victorian Parliament, and it's also, as Mr. Spencer said, an act in bad faith. So I think that cat and mouse is a very unlikely and far-fetched scenario. So I think this provides a clarity as to the position of the federal parliament versus the Victorian Parliament.
So can I ask if you think there are better ways or and the need for amendments to ensure that religious schools can continue to preference in employment in good faith on the basis of religious belief or activity, so that, basically you can preference Christians, for example, than the approach that is now documented as the government's position in section 12? Is there a better path to that end that you seek to achieve?
12 is statements of belief.
I think you're referring to section 11, Senator.
Sorry, section 11, yeah.
Yes. Well, the alternative way would be to have a positive statement in there that as a matter of federal law, a religious educational institution has the right to preference people of the same faith in employment. But I don't know, I wasn't party to the government's deliberation. It may be that the government is trying to avoid extending such a general rule into the Sex Discrimination Act area by trying to then override or preempt the ALRC's work in relation to discrimination on the grounds of sexual orientation and the other attributes we spoke about. And the way they've tailored it here is to keep it tightly focused just on discrimination in relation to the attribute of religious belief and religious activity. I think that's why, I'm guessing, but I think that's why it's been drafted the way it is.
Mr. Snedden, as a person of faith, the frustration of this being on the table since 2018 to get to this point where we're still saying, well, the work for the ALRC needs to be done is very distressing, frankly. It's just a failure of government to actually do the necessary work to provide us with a clean bill. Given the government hasn't followed through on the series of commitments that I've put on the record here today, and its failure to engage the ALRC on doing the important work in careful negotiation with the states so that something as arbitrary as an override clause doesn't have to be brought in as a novel fix. Do you actually have confidence that the government can deliver a practical outcome that will meet the needs of Christian schools and Catholic schools and Islamic schools?
Well, we do.
Yes, I do, Senator.
Mr. Jensen, that's got to be close to the line of the day.
And if I could just echo the frustration as well for institutions that having these bills being dragged out freely for more than 3 years since the same-sex marriage vote brought religious freedom into the limelight. There's huge media campaigns against our institutions and against individuals, which has been very, very hard to go through. So we're as keen as everyone to get this through, at least get something solid through that we can improve on and review on the other side. We would be very disappointed if this became another election issue with more promises beyond that. So we'd be strongly encouraging the Parliament to do their miracle work in-house and come to a conclusion.
Rather than using people of faith as another bullet in a gun.
Sorry?
Rather than using people of faith as another bullet in a gun to fire in an election campaign.
That does sound unpleasant.
Are you finished your line of questioning now?
I've got more, but in the interest of time.
Thank you, Senator.
Thanks, Chair. And look, thank you. Look, I want to continue on with the bill giving the right of religious schools to choose to employ people whose religious beliefs will uphold the religious ethos of their organisation, and the intersection of that with the Sex Discrimination Act, which we've already been talking about. And in particular, Reverend Dr. Clifford, I want to go to you because I understand you are the principal of Morling College.
Yes, I am.
Yes, which in last year there was a teacher at the college, Ms. Karen Pack, was reported on the ABC earlier this year, who was fired after she became engaged to her same-sex partner. So my understanding of Ms. Pack, I mean, she was an ordained pastor. She had obviously gone on her own personal journey of reflection and self-discovery to align her religious beliefs and her sexuality, but you would support the right of schools and colleges to be able to fire somebody in those circumstances?
Yes, look, we're a tertiary institution, so Karen Pack was a member of my faculty in the area of counselling and chaplaincy, and a master's postgrad area where she's dealing with training and equipping people in that situation. We have a policy, and our policy, which is on our website, makes it very clear that we don't do a police state kind of inquiry or act on rumours, but when Karen Pack asked to have a meeting with me and indicated that she was marrying her partner and that she had a changed position with respect to what it meant to be in a relationship with this person, and she would be getting married, and apparently there's some information about that on her own private page on Facebook. We entered a conversation. I entered into a very strong pastoral conversation with Karen Pack, and that took place over a number of weeks. And Karen, we came to the conclusion that this is not where she could continue to exercise her gift, which is a very strong gift. And we reached, I think, as far as we could, as most graceful place for Karen to move on. And we farewelled her, welcomed her back. But I mean, I'm a Christian institution which has a position of marriage. Sexual intimacy is between a male and a female in marriage. And so if the person involved had been advising me they're leaving their marriage and going into another relationship with somebody else in a heterosexual situation, the same conversation would have taken place.
So
for us, sexual intimacy is between a marriage between a male and a female, irrespective of what intimacy that is.
So you absolutely then support the right, you think that it's appropriate that she lost her job in those circumstances?
Yes, because she was very clear, as she indicated, what the terms, what our community code is. That was very clearly out there, and she would say herself that through most of her pastoral life, that's a position she held herself.
And so even though Ms. Pack and other people like her have a personal religious belief and they have aligned and have gone on this journey, and they feel that their faith and their sexuality is compatible, you feel that the colleges or schools should be able to override their interpretation of their religious belief and basically to be able to fire them based on their sexuality.
It's not us overruling on the basis of our particular religious belief, if you like. It's the belief held by our denomination. It's the belief held by basically all evangelical colleges. So it's what we understand marriage to be. It's a fairly significant position to be in, lecturing in a theological college, which is training, equipping people for Christian ministry, and you are actually, in that context, living out a lifestyle and modelling a lifestyle that's inconsistent with the teaching.
So in terms of her religious freedom, it's basically it's freedom to conform to the school's beliefs.
Well, in the context of a school, we see the school as a learning community, a community of believers who hold a particular view.
Okay.
When someone ceases to have that view, they cease to share those beliefs of that community.
Look, I know we're running out of time. I just wanted to take you to another case that was linked in the submission from the Christian schools and the Adventist schools of cases of discrimination where there was, and I was interested in the case, there was Max, who was a Christian teacher and it seemed it was in a public school, who was sacked, but he later won a court case for refusing to use a transgendered boy's pronouns. So this is also the type of action that you would like to have protected?
In a state school? Are you asking
in a
me?
state school, yes. It wasn't there in the online link. It did not say that he was in a Christian school. He was a Christian teacher. He was sacked, it appears, from a public school because he refused to use a transgendered boy's pronouns.
I don't know the specific details of the example. Are you talking about one of the examples on the Australia Watch website we linked to?
Yes.
So we linked to that site as examples of, contemporary examples of religious discrimination, rather than looking at, you know, they're not cases that we're familiar with all of them. I'm certainly happy to take that on notice and get back to you around having looked at the case and got some more details of it.
Okay, thank you.
Thank you, Senator. Thank you for appearing before the committee today and for giving your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on January the 7th, 2022. Thank you.
Thank you.
Thank you. Thank you.
Thank you.
I now welcome representatives of the Council on the Ageing and welcome Mr. Corey Earlham. If you are there.
Yes, he is.
Oh, in person. I'm looking for video conference. Thank you.
It's such a novel thing these days,
It's
isn't it, Chair?
amazing. Thank you. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you.
Correct.
And for the Hansard record, will you please state your full name and capacity in which you appear today?
Corey Brian Earlham, Deputy Chief Executive, Council on the Ageing Australia.
If you provided a written opening statement, would you like it to be incorporated into the Hansard transcript?
I'm happy to give you one afterwards, but I've given you a submission.
Thank you. I now invite members of the committee to ask questions, and the Deputy Chair will kick us off. Thank you.
Thank you, Mr. Earlham. Nice to see you in person. Your submission raises a concern about older Australians who receive home care packages, 840984. Who will not be protected by the provisions of the bill in the same way as those in residential aged care. Can you please explain what impact the current provisions would have on recipients of home care packages and what amendments you would suggest to improve the outcome for recipients of home care packages?
Thank you, Mr. Perrott. Section 9.2b of the bill talks about religious aged care facility. In the same section later on, it talks about disability service provider. This distinction can be interpreted to refer to only residential aged care and not include home care as a deliberate intention of the bill. So that means 840 odd thousand people who receive home support and 176 odd thousand people who receive home care would not go into section 8 and 9 of the bill. They'd be covered by section 7 where there's not the same protections. So I'm not sure that was the intention to cover off aged care, but we would suggest aligning the aged care definition to be in line with the disability service provider as opposed to aged care facility as a way to address that.
Did you have a consultation in the earlier drafts or with this one?
No, we've left with this one.
Okay. The Coda's submission to the second exposure draft raised a number of concerns. In particular, Coda did not support the overriding of existing state and territory protections. The current bill also provides for the overriding of state and territory legislation, and I think you were here for the earlier discussion. Do you remain concerned about those provisions? And if so, could you explain to the committee how that provision may impact older Australians?
So let me just say that we very much support anti-discrimination legislation that includes religious belief, religious activity being included. But all protected attributes should be treated the same. There's just a couple of things in the bill where that doesn't meet that test. And one of them is section 12, where it specifically says a statement of belief does not constitute discrimination for the basis of all these acts that it lists. Some are state and territory, but also it includes the Age Discrimination Act, includes the Sex Discrimination Act, Race Discrimination Act federally. So what does that mean in practice? Best we can tell, and let me say I've been doing human rights policy for 15 years, but I'm not a lawyer, and this is one of the most complicated trace-through bills that I've seen in a while to work out exactly how it will operationally work.
But on so we should do it really quickly. So
but on a read of it, it would seem that the words that are spoken, the words that are written, the statement of belief, would not constitute discrimination in any of those acts. So yes, we have a bill here that is designed to protect religious belief or activity, and it has section 12 that overrides all the rest of the anti-discrimination legislation if it's spoken or written words. Now that doesn't treat all protected attributes, all personal attributes equally. That actually places religious belief and activity on top of everything else and says if it's looked through the prism of religious protection, religious belief or activity, that it is overriding everything else. What's also concerning in that definition is that it appears that it's not using the traditional human rights approach of making sure that it conforms with doctrines, tenets and beliefs. It kind of turns around and says just one person needs to have a genuine belief that it is related to those things. So not only does it override, the scope in which you can interpret it can be just one person of that religion, two people of that religion, not the common belief of that religion. So in practice, when we sit there and we see the Sex Discrimination Act say that religious aged care providers can't discriminate in their service delivery, the staff can turn around and say what they want, and that's not discrimination. It just doesn't seem to make sense to me.
Do you... The classic would be, I assume, well, where might the mischief occur, I guess, is how might you see that happening? And an example I'm thinking of is... 8 years ago when
we had this clause put into the Sex Discrimination Act and it was debated, the genuine belief of most residential aged care providers was that they don't discriminate. And I really believe that was true then, and it was really true today. What's different is the way that the clients go through and interact and perceive that they will be treated. Prior to 2013, if you looked at the submissions we got from people, I'm never going into residential aged care, I'll swing from the gecko tree, they're going to discriminate against me, they're a bunch of churches, I've fought them all my life, all of these things come up. But now, last 8 years, no controversy, no problem, no reported incidents. But we see people actually going into aged care knowing that they're going to be celebrated, protected and free of discrimination. They're not apprehensive going in there. So in practice, is there going to be mischief? There wasn't before, there isn't today, there's not going to be tomorrow. What there's going to be is a chilling effect of how people fear that going through, because the messages will come down saying, well, actually they can say what they want to you, whereas currently they can't.
So, in terms of, the employer says you've got to care for your clients. I mean, that's an overriding rule of aged care institutions from what I see employers telling their staff and my interactions with their staff. So there's going to be that override of any potential statement of belief, surely.
Yep.
You're not going to say that to Mr Smith because you care for Mr Smith. Would be an override.
You can say what you like under the statement of belief provision is my read of it.
Okay. The other possibility, and I haven't drilled down into this, but in Queensland they've got voluntary assisted dying laws coming in, I think.
It's not just voluntary assisted dying laws. If you go to section 15, which is in relation to professional bodies, okay?
Yeah.
The Royal Commission recommended there be a code of conduct in aged care. We kind of have one in healthcare workers. We don't know what's going to be in aged care, but I'm using healthcare code of conduct as a bit of an example, okay? So it has things like healthcare workers to provide safe services in a safe and ethical manner. The healthcare worker must provide health services in a manner that's culturally sensitive to the needs of the client. A healthcare worker must not attempt to dissuade a client from seeking or continuing medical treatment, amongst others. Here's a code of conduct, here's a series of statements. People who are not under ARPA registration need to conform to those statements. The introduction of section 15 would nullify that if somebody did something under a statement of belief or because of their religious belief. So we can see voluntary assisted dying being something that people are talked out of trying to do, which is inconsistent with that statement of trying to encourage them or not encourage them.
I imagine the Catholic or institution is going to have to deal with that in its own way. I think there's some exemptions in Queensland. I don't know the Victorian legislation, like so that but it might be a different practitioner coming in, but this is going to...
But it's just not about the organisation. It's about any organisation anywhere for the individual who has a statement of religious belief.
Okay. All right. Thanks very much, Mr. Vaughan.
Thank you. Any of the coalition? Senator Small.
Yeah, thanks very much, Chair. Mr. Earl, you mentioned of concerns to older Australians is this apprehension about being discriminated against in their aged care or like in a residential aged care setting. But wouldn't you also agree that it's important for Australians of religiosity to have access to aged care organisations who maintain that ethos in delivering aged care services?
Senator, absolutely, and that's what our submission says. But the way an environment such as residential aged care creates its culture and delivers on that is really important. And you don't want to see an individual staff member being able to not be sanctioned, not be managed, where it goes against that culture. So, for example, take a Uniting Care facility, just as an example, plucking a name. The Uniting Church has a very broad definition on sexuality as to how it's interpreted. That organisation will create its cultural norms. Some go so far as to actually run programs inviting gay and lesbian older residents to come in. That's creating an environment of acceptance that's welcoming them through there. The statement of belief provision would allow that individual staff member who doesn't agree with it to be able to go ahead and state whatever they like, not have it be discrimination, and put that employer in a difficult situation as to how to manage that.
So how would that statement of belief in the context that you've described, residential aged care, where the person is employed to, care for the person, potentially provide nursing skills and other support like that, how would that meet the safeguards of needing to be, not only sincerely held, but reasonable, not harassing, not intimidatory, not inciting? I think it is... potentially a little bit of a gloss over to suggest that there aren't safeguards in place. And then the other aspect of the same issue is, of course, that the employer conduct rules can be such that, and including from, registered nurses and that sort of body, that would, I think, go to ameliorating the sorts of situations you're describing. Do you think that they don't go far enough, or what's the issue there?
I think the issue there, Senator, is that this bill has taken a higher bar of what that test is compared to other bills. So, for example, offend, insult or humiliate is the test in the Racial Discrimination Act, the controversial Section 18C. Those words don't appear here. Instead, we create a much higher test of threaten, intimidate, harass or vilify. We then turn around and do a little legislative note that says, you know, a small, moderate kind of statement isn't vilification. So we're actually creating a very high bar for places to interpret this legislation for religious protection, much higher than the bar of discrimination in the Racial Discrimination Act and others. And CODA's position is they should be equal.
Sorry, I hate these video conferences because we end up talking over each other like that. So, sorry, the other two key elements there, in good faith and reasonable, because, I mean, how would you purport it is reasonable and in good faith for an aged care staff member to, as you would put it to me, discriminate or denigrate in any way a resident on the basis of something like sexuality?
I think I missed the first part of the question.
Senator Small, I think if Mr Erland finished his line and then went to your question, because you were both over at the top of each other, and I know you hate that. So.
That's right. All I was saying is...
Sorry. Yeah, please just maybe repeat what you just said.
Yeah, sure. So all I was saying, religious discrimination definition higher, racial discrimination bar lower, bring them into accordance, make them the same, everything much better.
Okay, thank you, because there are obviously plenty of a view that the RDA sets the bar too low and we should lift that up. But we'll save that conversation for when we've next got RDA in front of this committee.
But Senator, I think you can't do that. The point here is you have to treat all protected attributes the same.
Sorry, yeah, it's an irrelevance, frankly. But in a previous submission, I note that the Council of Ageing has raised concerns around the way that the bill defined vilification, and of course, you just mentioned it there again. The bill does include now, I guess the legislation in front of us includes that statements of belief would need to pass a test of reasonableness, thereby ensuring that there is an objective standard applied. Do you agree that that is a positive step?
I'd have to go look at it, Senator, and come back to your notice.
Yeah, that would be appreciated, thank you.
No worries.
Yeah. And finally, under clause 9, aged care facilities are able to preference staff who share the same ethos. And I mean, the Uniting example you gave is obviously a clear illustration of that. But that does not extend to offering the services to the public community at large. Do you believe that that's a fair outcome?
So as I said earlier, Senator, the problem there is that you're restricting it to residential care. So what you just said only applies to residential. The services at large does not apply to home care. That's a problem.
And so what is the change that you're actually advocating for there, in that I guess if I'm in my own home, I will choose a service provider that aligns with my ethos if I am a person of faith?
I'd encourage you to go to regional Australia.
I'm a non-believer as well.
Yeah, I'd encourage you to go to regional Australia where choice is limited in many scenarios and is often delivered by faith-based providers. So I appreciate what you're saying is often true in metro areas and you can try and choose, but that's not always the case in all parts of Australia. So all we're suggesting is align it with what you've put in there for disability, change it from facility to service provider.
Okay, thank you. That's useful feedback. And that's it from me, Chair. Thank you.
Thank you. Senator Pratt.
Thank you, Chair. I wanted to ask, please, in terms of the previous removal of exemptions from the Sex Discrimination Act as it pertains to aged care and the current context of statement of beliefs within aged care facilities. For example, we have, I guess, a sense that older people are not sexualised human beings and that therefore that's underplayed in an aged care environment, but clearly the removal of those exemptions enabled people to have a right to sexuality or a relationship. What are the implications for that right in the context of this bill? Will it still be the case that you're able to define your own relationships? Or will it be that you can no longer do that? Or will it be that you can, but you might be subject to statements of belief about your conduct?
Yeah, so it's complicated because statement of belief is both verbal and written, so it's unclear whether that written statement goes so far as to policy or not, or whether it's just about a statement. So in the practice of applying a statement to belief of religious views to the context of 37 of the Sex Discrimination Act that says if it's Commonwealth funded, can't discriminate in aged care, how those two interact is going to be ending up in court, I suspect, because verbal words we know will be able to be used as a statement of belief with protection. Whether or not it'll be interpreted to go so far as policy is something that a technical person understanding much more interaction than I would have to advise you on, Senator. I couldn't even take it on notice for you, I'm sorry.
Thank you. That's revealing in and of itself. And what about the difference between, I guess, a written policy and verbal statements from someone in an intimate care setting? You know, people can be vulnerable when they're in aged care, and you can be up very close and personal. Are there ramifications, if you like, from, you know, having that kind of discussion in a workplace versus having that kind of discussion coming from your carer while you're, for example, being showered or you know, I'm just trying to, I guess, put some depth to the context in which statements might happen.
So to be quite literal, you don't have the words offend, insult or humiliate, so I can do that to you. So I can sit there and wash you. I can sit there and wash you in your bed, humiliate you. I can sit there and feed you, insult you. I can sit there and take you out to an outing and offend you, and that's okay under Section 12.
That's very distressing.
Can I just interrupt there and say that we're talking about religious discrimination, not about general treatment, and we need to be really clear of what we're talking about. None of that behaviour is acceptable in Australian terms.
I agree, Dr Webster. However, the way that Section 12 is constructed is if one or two people believe that it links to my doctrines of faith in the way that I present that, that is acceptable. I'm not suggesting many people would. I'm not suggesting that this is going to become the norm. We're going to have an outrageous amount of cases of these. But the way the law is constructed as it's drafted sends a message that it's okay if it's on the basis of religious belief. And so in practice, you're going to have situations where employers have to deal with what you just described as not okay behaviour, but you're going to be unclear whether it's actually lawful.
Yes, but we are talking about the intent, which of course is not to intimidate, and I would put any of those things that you're talking about under that category, let alone others. So over to you, Senator Pratt.
Well, I guess the context of intimidation here is important because how do we interpret what intimidation, humiliate is going to look like in the context of vulnerable care? Is that something that's going to be, we don't have any precedents around that. The law doesn't differentiate currently in the way those provisions around intent are written about the specific vulnerability of the person who might be receiving services. Is that correct?
I think it's important to understand the test is to be read in context, the way that the court will interpret it. So threaten, intimidate, harass or vilify. I don't think you can hang your hat on whether or not the word intimidate will have a low bar interpretation by itself when you look at it in the context of the paragraph. But again, not a lawyer, very complex. Ask somebody much more experienced than I.
Okay. But threaten, harass or intimidate,
threaten, intimidate, harass or vilify.
Yeah. But statements of religious nature while being showered, really the personal dignity of the person being showered, for example, there's a whole other context as to what's an appropriate conversation to have. It's almost as if to say threaten, harass and intimidate are only partly relevant. Hence, as you've highlighted in your submission, the need for a code of conduct in aged care. So nevertheless, you are concerned that the code of conduct would be overridden by statements of belief?
I think it's more in relation to section 15 around a body being able to enforce it. I'm not sure that the code of conduct itself would be overridden by statement of belief, but in practice how an employer has to balance the different competing laws, that's where it could perhaps come in.
Okay, and how do you suggest that be resolved? Clearly, CODIS has supported protection of religion as an attribute, but in the context of where a statement of belief or section 8 and 9 override that.
So I'm yet to see a clear reason why section 12 needs to override other anti-discrimination laws.
Very good.
Thank you, Senator. Moving on to Ms Hammond.
Thank you. Thank you very much for coming in today. I just want to follow up on the previous line of questioning, because I understand the concerns, and many people who are in aged care facilities are vulnerable, and we want to protect them. For the same reason that you remember, this is also but statement of belief is also a statement of no religious belief.
Correct.
So you're expressing concerns about could just as easily be a person of faith, of whatever faith, who's in a facility, in an aged care facility, aged care home, and a carer comes up to them regularly and tells them, you know, God doesn't exist. When you die, you're just going to turn to dust. There's no, because that, and that's protected just as much as somebody with expressing another view to somebody of no faith. Is that correct?
So two things on that, Senator. One, the definition of statement of belief, Part B, section III, is that it's of a belief that the person generally considers to relate to the fact of not holding a religious belief. So it's still related to not holding a religious belief as opposed to any other statement. So just pointing that out. Let's assume, for example, you amend the bill and you remove section 12 and everything else goes through, for example. That would still constitute discrimination on the basis of religious belief or activity in that scenario that you talked about.
Why?
Why? Because you're discriminating against that person in your actions.
Sorry, who's discriminating? Sorry, now I've got confused.
So the scenario I understood from you was a person of no belief saying something inappropriate to a person of belief. Is that a fair summary?
Yeah.
Yep. So without the statement of belief clause there, you would still have other provisions in the bill that would constitute discrimination on the basis of religious belief or no belief that would cover that situation in the same way that you deal with sex, age, race, etc. in those bills.
Right. Okay. So picking up on another point, and as you say, the majority of the overwhelming majority of our carers and our aged care facilities, we all know this, they're all wonderful. The service that is being provided, the true and genuine care is there. And so what we're talking about here are protecting against those extreme situations which could arise. We have to acknowledge they could arise and we don't want them to. Isn't there scope under this bill, as I read it, that the bill, if an employee, a carer, does go and say something to somebody, whether it's a statement of no religious belief or statement, you know, saying God doesn't exist or you're going to go to hell because of whatever, that the employer could counsel them and say, you know, look at the ethos of this institution. We welcome all. We're responsible for caring for them, for looking after them, for providing we're not here to make their life more difficult or challenging. Wouldn't one set of counselling on that, then if that happened again, isn't there then grounds under employment law? And I think there's even examples given in the bill about this happening.
I'd need to take it on notice to confirm. But my understanding is that Section 12 would then give that employee a right to refute that counselling on the basis of it being the statement of belief. Like at the end of the day, people who are reasonable consenters are going to have a reasonable conversation, and that's okay. Yeah, we're going to deal with this like human beings. But you need to think about the message that the law sends, because I'm less concerned about the black and white few cases that end up in a court and more concerned about the chilling effect of this is the new bar that we're setting in the way that we go about doing that. If we introduce religious belief as a protection that is equal with all other protected attributes, I think we've done a really good job and we've delivered on what was said should be done. If we introduce a piece of legislation that privileges that protected attributes over others, I think we're going to get into some trouble.
Okay, and so that is your main point then?
Yeah.
Okay, thank you, that's all.
Thank you. Senator Rice.
Thanks, Chair, and thanks, Mr Earlham. I actually want to continue on, given this uncertainty, given we don't know, what the law would do with this, what is then the practical impact on the ground for both aged care providers and people in aged care facilities or services? What would the introduction of this bill actually mean practically on the ground for them?
Well, for the most part, it's going to be fantastic because it's going to be really clear that somebody who has a religious belief or doesn't have a religious belief is going to be protected for that fact. And that's something that's been missing from federal anti-discrimination law since day dot. Would have perhaps been better to do as part of consolidation, where you would have been easier to be able to balance all of these competing needs in a controlled framework. But the introduction of Section 12 saying it overrides all the others is largely where the problem is, because unlike being able to say when we introduce the Sex Discrimination Act we're just protecting women, we're actually introducing religion and overriding other things, saying it's not discrimination if it's a statement of belief, very broadly worded with a very high bar, saying when it's not a statement of belief, inconsistent with other human rights acts. So I'm probably less concerned about people who are in the facility and more concerned about the message that it sends to a prospective person looking to go into a facility and being fearful of what that will mean. Because my experience of residential aged care facilities, once you're in there, you realise what the beautiful place they are. They look after people. There's some issues, sure. We've seen a Royal Commission showing what they are. But as the former senator just said, genuinely staff are trying to provide that best environment. But when you haven't experienced it and you've got a message that says, this could be said to you, that's where I think it's problematic.
I think I need to point out that Ms Hammond is not a senator.
She's not a senator, that's right. Ms Hammond.
Sorry.
The member,
on behalf of the House of
the member for wherever.
I apologise. I apologise.
Thank you for rescuing my reputation.
I'm so used to Senate committees.
But can I take you then, in those circumstances, such as the example that Ms Hammond and you were discussing of, is this discrimination or not if somebody is saying something on the basis of their beliefs, where would that leave that aged care provider in terms of dealing with this is offensive towards my client, but it seems to be protected under Section 12? How would those... tell me about the dilemma that would then leave that aged care provider in trying to work through this.
Can you give me 3 days, a bunch of fair work experts, and we'll try and figure it out, because the interaction is very complex and I don't have an answer for you.
So essentially it would leave the aged care provider in a complete dilemma though, and uncertainty and, not really knowing where to go.
That would be my guess.
And potentially up for, engaging in a legal case that they don't know whether it's successful or not if they wanted to, sanction that person who was making what seemed to be offensive statements.
I guess that depends on what actions the provider took.
Right. So, very complex. And a difficult situation to put aged care providers in.
Yep.
Yep, okay. Thank you.
Lovely. Well, thank you for... One?
Yes, thank you very much. It is one, just for a change. Mr Earlham, you have more confidence in your answers than any of the previous witnesses who are very unclear about what everything might mean. I'm interested how you've come to such certainty about your position, but I do want to ask a question on the back of that, because it looks like you've read this very carefully, even though you profess not to be a lawyer. With regard to the Racial Discrimination Act, just the intersection there with Section 12.1c, which provides that a statement of belief does not in and of itself contravene the provision of a law prescribed by the regulations. Now, my question is, do you think that that provision could be used by the current or a future Attorney-General to prescribe Section 18C of the Racial Discrimination Act? If so, would you support that, or would you support the prohibition of that by further amendment?
Thank you, Senator. Let me just say my confidence is about the issue, not about whether or not the solution is right, because until it actually gets heard in the court, who knows? But thanks for picking that up.
Okay, because there's a high degree of uncertainty about what's going to come out of this. Yeah,
it's going to be uncertain. Okay. In relation to your question, it already will rule out Section 18C because the Racial Discrimination Act is listed there. In our submission, we've raised concern with paragraph 1C that it could be any ministerial sign of the pen, and then we go through the whole disallowable process that can be complex and a very high bar to reach. I personally think that the Parliament should be setting these laws if it's to be included in Section 12s to continue, as opposed to having it by regulation, but that's a matter for Parliament to discuss.
And my continuous question is, can we have any amendments that you think are necessary to the legislation provided?
I'm happy to give that to you by the 7th, yeah.
Thank you, Chair.
Thank you very much. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice or amendments are provided to the committee secretariat by close of business 7th of January 2022. And the committee will now adjourn for lunch and recommence at 1:45. Thank you. We will now recommence. I now welcome representatives of the Executive Council of Australian Jury. Welcome to Mr. Peter Wertheim. Can I confirm that you can hear us?
Yes, I can hear you.
Lovely. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
It's Peter Wertheim, and I am the co-CEO of the Executive Council of Australian Jury.
Wonderful. Mr. Wertheim, could I ask you, do you believe there is a need for religious protection to be implemented in our legal framework?
Yes, I do. Our submission has gone into some detail as to why, but essentially we have a situation in Australia at the moment, which was noted by the Ruddock Review, where we have some protections for against religious discrimination in some states and territories, but not in others, and the nature of that protection varies between jurisdictions. We don't have anything at the moment to protect against religious discrimination at the federal level, and nothing in New South Wales, and a very partial protection against religious discrimination in South Australia. So for the sake of having uniformity across the country, we are all citizens of one nation. It is desirable that we have the same laws for everybody. And so we do believe that the recommendations of the Ruddock Review, along the lines that there should be legislative protection against religious discrimination, are justified.
Thank you. I read your submission with interest. I'm wondering, for the sake of Hansard, whether you could talk about some of the actual examples of religious discrimination that the Jewish community individuals face in Australia.
Thank you. Yes, our organisation publishes a report on anti-Semitism in Australia each year. The 2021 report has just been released and provided a reference to that in our submission, and it's on our website. It's freely accessible in the subject of comment, as it usually is. The problem of anti-Semitism is just one example of racism that occurs in Australia. and also one example of religious discrimination that occurs in Australia. The Jewish is a little unique in some respects in being both a faith community and an ethnic community, and so not entirely comparable to other communities in that respect. But we're aware that other faith communities suffer from discrimination. Other ethnic communities also suffer from discrimination. Some of it's on the basis of race, some of it's on the basis of religion. In the case of the Jewish community, sometimes you don't know whether it's on the basis of race or religion, and it makes little difference, quite frankly, to both and the victim. And it's anomalous, really, in our view, that there should be some protections for discrimination against Jews on the basis of race, but not on the basis of religion. Doesn't really make much sense. So, in terms of day-to-day experiences, our report, unfortunately, details quite a lot that happens both in the real world and in the virtual world that amounts to hatred directed against. Now, not all of that manifests itself in discriminatory conduct. Sometimes it manifests itself in criminal conduct. Sometimes it's just hate speech. But at other times it also manifests itself in discriminatory conduct, such as refusal to serve somebody in a shop or treating somebody differently at work in such a way that they're forced to leave, and the perpetrators of the abuse that they suffer at work on account of being Jewish goes unpunished and resolved. So these are the sorts of instances that we've documented over the years in our reports. And unfortunately, as I suspect is the case with other forms of prejudice in Australia, it's getting worse than better. And so laws are part of the armoury that society needs to have to protect against it. Sole weapon, of course. Education's the critical weapon against it, but the law has to play its part, set the right standards and so on.
So in your report you say that in 2020, over the period of 12 months, there were 331 anti-Semitic incidents, including physical assaults, threats, abuse and harassment, which is a 44% increase from 2017. Can you explain that? Why is it so?
Yeah, that was the 2020 report you're citing.
Yeah.
The 2021 report showed 447 incidents, which is another 35% increase on top of that. It comes from various sources, and the best advice I can give you is the advice that we have had ourselves from intelligence sources and law enforcement agencies in Australia, that it's a proliferation of both politically motivated and also a resurgence of white supremacist forms of hate and activity in Australia, which we haven't seen really before. That seems to be the major new factor that's occurred. There, of course, are more traditional factors as well, as I said, religious prejudice and so on, which go back many centuries. But the main drivers, as far as we can see, are both the white supremacist sources of hatred, and of course they don't just manifest as anti-Semitism, they manifest in other groups as well, and also politically motivated anti-Semitism. So, for example, last May, we saw an outbreak of violence between Israel and Hamas, and that, for whatever reason, resulted in a spike in anti-Semitic incidents here in Australia. We see that all the time. The number of incidents in May were more than double that of any other month. So you can gauge fairly accurately from that. You know, it's anecdotal, but it's quite specific that a good source or a good part of the source of this activity is coming from that quarter as well. It's not one thing or the other. Unfortunately, anti-Semitism has been around for thousands of years, and it's it's not likely to go away anytime soon. It has the capacity to mutate, to become a kind of an all-purpose prejudice. And there's never been any shortage of people in this world who are looking around for other people to blame for their own problems or what they perceive to be society's problems. And groups who can't fight back are an obvious target. Unfortunately, more often than not, that's been the Jewish people.
Thank you, Mr. Wertheim. How many members do you represent?
So my organisation, the Executive Council of the Australian Jewry, is the national roof body of the Jewish community. All of the state roof bodies of Jewish communities in New South Wales and Victoria and the other states and the ACT all come under our umbrella. And in addition to that, there are other national Jewish roof bodies, such as the National Council of Jewish Women of Australia, Australian Union of Jewish Students, Maccabi, a number of others, which also come under our umbrella. So if you were to look at both the direct affiliates and constituents of our organisation and the organisations that are affiliated to them in each state, it comes to around 200 organisations across the country. And our organisation has been generally accepted within and outside the Jewish community as the representative of the Australian Jewish community since it was established at the end of World War II.
So how many people would that represent?
Altogether, there are about 117,000 Jews in Australia, according to our demographers. That's extrapolated from last census and certain adjustments that are made to account for some anomalies with the way the census happens. But generally, the figure that's been accepted is 117,000 people. So we're about 0.5% of the population.
Thank you. Senator Ross, do you have any questions?
Thanks, Mr. Wertheim, and thank you for your submission and for the awful instances of anti-Semitism that are being experienced in Australia, which is truly horrifying, and obviously the need to be protecting people of faith, which we absolutely support. Of course, the issue is how we go about doing that. In your opening statement that was tabled, you state that Clause 12 would also override Section 17 of the Tasmanian Anti-Discrimination Act, and so that it's very much an outlier provision compared to other laws. Are you aware that most cases taken under Section 17 of the Tasmanian Anti-Discrimination Act have in fact been on the grounds of disability, and with a not insubstantial number of those being because of statements of religious belief about someone's disability?
Yes, I received an email yesterday from somebody in Tasmania representing a disability organisation making that very point. Look, I'm well aware of the fact that, and I don't doubt, that people make insensitive and thoughtless comments all the time about all sorts of things, including on the basis of religion, but not exclusively on the basis of religion. And the question is not whether these things should be condoned or whether they're right or wrong. They're clearly wrong. Every monotheistic religion in Australia has a version of what we call the golden rule. Treat other people the way you'd like to be treated yourself. And so nobody can say that that sort of conduct, whether it's in the name of religion or not, can be condoned. It clearly can't be. The question really before this committee is whether it should be legally prohibited. Now, if you have a look at the provisions in the bill, they are hedged about with significant qualifications. A statement, first of all, has to really be on the basis of religion to even qualify for protection, not an expression of a political opinion or some other opinion. Secondly, it has to be made in good faith. Now, I would say that a lot of the statements you're referring to on the basis of religion would fail on that ground.
Continue, sorry.
I'll just finish my answer, but I'm happy to continue the debate after that. And then thirdly, of course, if any such statement is motivated by malice or it intimidates or threatens or vilifies or harasses, then again, it's not protected. Now, what we're talking about then is something that falls within, I think, a very narrow band. Statements that are thoughtless and that are insensitive and are going to be taken rightly by the people against whom they're directed in an effective way. The question is, we're talking about this sort of low-level kind of denigration, I think you're referring to, and is the law going to intervene to prohibit that? That's the real question, if it's made on the basis of religion. And I think that's the real question for this committee.
Yes, and indeed. And so, I mean, your assertion that these things will only fall in a narrow band is at odds with the legal advice or the legal opinion of anti-discrimination law experts. We heard from the Australian Anti-Discrimination Law Experts Group this morning, and who very strongly feel that because statements of belief will be protected, that in fact that will be overriding state and territory discrimination laws, that in fact those sorts of statements will actually be protected. So I'm interested in what legal advice you've got that is at odds with the advice, the expert advice from anti-discrimination lawyers.
Well, I've heard from other anti-discrimination lawyers to express the contrary opinion, and I suppose the answer to your question is that we'll have to wait and see if the law is enacted and how it operates in practice to see whether the fears that have been expressed about it are borne out. One of the things that we've recommended in our submission is that there be a review of the legislation every 2 years to check precisely the sorts of things that you've been referring to, and there'll be other things as well that will adapt. But I mean, you can talk to any number of lawyers and get any number of opinions. I used to be a practicing lawyer myself in a former life, and I'm aware that there's a big difference between lawyers' opinions and judicial verdicts and decisions. And lawyers are proved wrong every day of the week by judges, even judges are proved by courts of appeal. Before one can be really dogmatic about what the effect of new legislation is going to be, I think one has to take the words in context and then understand how they're going to how they're likely to operate in the context of cases that have occurred already. Now, you've referred to cases that have been brought in Tasmania under the Tasmanian Anti-Discrimination Act, under Section 17. And I'm not aware, whilst I'm aware that there are many complaints that have been brought under that section, the decided cases, insofar as they relate to religious statements, I think are fairly sparse. To look at that once a track record is developed. And then the real question is, what is it that is now legally prohibited that will be now legally permitted if this bill is enacted?
And certainly the discrimination lawyers this morning said it was going to probably take decades to sort through that. So clearly there's a big difference of legal opinion currently. And a continuation of that is, because of the privilege given to statements of belief and their ability to override state and territory discrimination laws, is your organisation concerned about actually the prospect of anti-Semitic speech being legal because it is said as a genuine statement of belief from somebody of a different religion, or in fact a non-religion?
Well, look, we're always concerned about anti-Semitic speech. The question is whether every instance of it should be subject to legal prohibition and potential legal action, or whether there are other ways of... Now, in the case of anti-Semitism, of course, because the Jewish community is both a faith community, we have the benefit of protection under Part 2A of the Racial Discrimination Act. And Part 2A of the Racial Discrimination Act has Section 18, which again prohibits conduct that would offend, insult, humiliate or intimidate people on the basis of race. The difference between that section and section 17 of the Tasmanian ADA, and I don't know whether you heard from the experts about this, the difference is the case law. The case law with regard to section 18C qualifies the threshold by saying that the offence, insult, etc., must have profound and serious effects that can be demonstrated by the applicant, and the onus is on the applicant to prove that. And it's not sufficient to establish low-level denigration of the kind that I think section 17 is directed to. Now, to our way of thinking, the remedies that we have available under the current law for anti-Semitism are sufficient. The potential for low-level denigration of the kind that you're referring to, and which happens every day and which is documented in our anti-Semitism report, is always there, and no amount of legal regulation is going to eliminate it. The certain amount of legal regulation is needed against the more serious examples of it, but the chief weapon in combating it has to be education.
On your statement there that you feel that you're going to be protected under using the Racial Discrimination Act in Section 18C, I just wanted to point out that, you know, the law, this bill says under Section 12 that a statement of belief in and of itself does not constitute discrimination for the purposes of any of the following, including the Racial Discrimination Act. And so it actually has got that override. So it's actually not accurate that you're going to be able to rely upon, you know, Section 18C or any other parts of the Racial Discrimination Act because of the statement of belief clause.
I beg to differ. And in fact, I'll take you through this because it requires some care. What the Clause 12 says is that a statement of belief will not constitute discrimination under the Racial Discrimination Act. And there have been cases brought under the Racial Discrimination Act where mere statements have been made and they've been held to be discrimination. What Clause 12 does not say is that a statement of belief will not contravene the Racial Discrimination Act at all. And in fact, if you read the explanatory memorandum, there is a paragraph there, it's referred to in our submission. I don't have the paragraph number there to get to at the moment, but I could find it, which says that the vilification provisions, the prohibited conduct in terms of racial hatred, will not be overridden by Clause 12. And the same is true of all the anti-vilification provisions in the state military legislation. If you read this Clause 12 carefully, it's very clear. It's not a general override saying it won't contravene any of these acts. It says it won't constitute discrimination under those acts.
Yes, but that's if it's vilification, which is a very high bar.
Well, vilification is with regard to the state and territory laws, including Section 19 of the Tasmanian ADA. That will not be overridden. But also what will not be overridden is Part 2A of the Racial Discrimination Act, because Part 2A does not deal with discrimination. It deals with prohibited conduct on the basis of racial hatred. It is not an anti-discrimination provision. It's a separate part of the Act that deals with something other than discrimination, and therefore, as the explanatory memorandum confirms, it will be overridden.
Okay, look, my last question, and I think there are a variety of legal views about that, which I'll ask some other witnesses.
Well, the explanatory memorandum makes it very clear. It's very explicit. So I don't know that is as open to legal argument, if I may say so, as what the likely effect of the provision will be in other respects that we were discussing earlier.
What I wanted to go to in my final question was, because of the provision that allows for religious organisations to preference people of their faith in all sorts of services that they provide, and not just employment, whether you are concerned about the potential impact of that actually potentially being discriminatory against people of other faiths. And so there could be, some religious organisations that would say, no, we're not going to have anything to do with you because you're a Jewish person.
Yeah, I don't think that applies with regard to service provision.
It does. It's pretty clear. It's not just restricted to employment, which is what other witnesses were saying this morning, but I've actually had a look at it, and it's not explicit saying it's just about employment.
Well, with regard to things like hospitals and aged care facilities and disability services, I think it's quite explicit in Clause 7 that it does not. It extends only to employment and not more generally. I think when it comes to other things like conferring charitable benefits or having youth clubs or whatever, I'm less concerned about it because I mean Australia's full of voluntary organisations and youth organisations and so on, which have been established to cater for particular parts of the community, whether it's a Christian youth club or a Muslim women's swimming club or a Jewish sports club or whatever. And I don't see anything particularly sinister about that. They've been around for a long time. They've operated without controversy, and I don't see why that should not continue to be the case. So my answer to your question is, sorry, go on.
How about the examples? How about a soup kitchen or a service for homeless people?
Well, again, accommodation providers are specifically excluded from preferencing in services, as far as my reading of the bill is concerned. And a soup kitchen is a conferring of charitable benefits. And again, if a particular faith community wants to set up a soup kitchen for needy people in their own community, that's something that happens now, and it doesn't seem to have caused any great headlines or controversy that I'm aware of. I think most organisations that provide those sort of services would hold them open to everybody, but if there's one, a small community that has a particular need and wants to look after its members in a way that they can't be looked after in the general entity with organisations in that particular sector, that happens now. I don't see anything wrong with it, and I don't see why this law should stop it.
So you'd be fine with that person turning away a Jewish person because they are clearly and obviously Jewish?
No, not because they are clearly and obviously Jewish, but because we are an organisation that services members of our faith community, and it's not directed specifically against your community or any other community. It's something that we have set up to look at our community. So it's, there's a difference between that negative discrimination, which is directed specifically against Jews because they're Jews or Muslims because they're Muslims, and something that says, look, we've set up a youth camp for Anglican kids, and it's for Anglican kids because we want them to have that religious experience. It's not directed against anyone in particular. I think there's a big difference there.
Thank you. Okay. Thank you, Senator. Mr. Goodenough, I believe you've got a question.
Yes, thanks, Madam Chair. Mr. Wortham, do you believe that Jewish people in Australia will continue to be at risk of religious discrimination if this legislation is not introduced? And what steps can be taken to protect Jewish people in Australia from discrimination?
Look, I think there'll always be discrimination, whether it's against our community or other communities. It's something that seems to be embedded in the nature of society. It's always been there, probably always will. The question is, at what point does the law intervene to protect vulnerable communities from discriminatory conduct or alternatively vilification? And we have, over the decades, developed a system of laws with regard to discrimination on the basis of race and sexuality, age and disability at the federal level, and on certain other grounds at various state and territory jurisdictions. There is no uniformity about this across Australia, which in and of itself I think is something of an anomaly. And different jurisdictions have made different judgments about where to draw the line. So whether this bill is passed or not, I think our community will be vulnerable to discrimination, whether on the basis of race or religion or some combination. This particular bill, if it is enacted, will provide an additional protection that isn't there and which I think needs to be there because it's there in most other state and territory jurisdictions, and we need to have some uniformity about this across Australia. And what more done to protect our people from discrimination and vilification? I think the answer to that lies, as I said earlier, with the education system. And particularly, I note that ACARA, the body that's charged with overseeing the Australian curriculum, is undertaking a review at the moment, and I sincerely hope that they do look at introducing elements within the curriculum that will teach to think critically and to be aware of prejudice and to know how to counteract prejudice when they encounter it, especially online, because they are very vulnerable to it. And I don't think our education system addresses that adequately at the moment. But that's for another committee on another day.
Thank you, Mr. Wertheim. Mr. Goodenough, have you completed your questions?
Yes, thank you.
Mr. Burns, I believe, welcome, and I believe that you have a question.
Thank you, Chair. Can you hear me okay?
Yes.
Excellent. Thank you, Mr. Wertheim, for your comprehensive submission and really detailed evidence to the committee. It's nice to see you, as always. I guess what might be useful by way of background is the ECAJ is an organisation I know well, but it is an organisation that represents a significant array of views, and I think one of the mistakes that people often make is that any particular religion or religious group has a single view or is a homogenous entity. Maybe just if for the committee's sake, by way of sort of background, the different views of the Jewish community, how the ECAJ came to its position in consulting with the very vast and opinionated corners of our wonderful Jewish community.
Yes, well, you're quite right. There's always going to be a variety of views in any community. However, this is not the first bill that we have been presented with. There have been two earlier exposure drafts, and in both I sent around the exposure drafts to interested bodies within our community. So it was a variety of organisations, all of the roof bodies of the states, sporting clubs, women's clubs, organisations, and hospitals. There was one hospital in Sydney in particular, aged care facilities, accommodation providers. So all of the stakeholders that we thought might be impacted by this legislation, copies of the legislation, given some notes as to what the issues were as far as we were concerned, and invited to come back to us with any thoughts. Now, most of the ones who came back to us were concerned, are we going to be able to continue to operate the way we've been operating in the past? So will the Jewish hospital, for example, be able to continue to kosher food and have Jewish observances and so on? Will the sporting club be able to restrict its board of management to people of the Jewish faith as it does at the moment? So most of it related to preferencing. That was where the major source of concern of our community lay. The secondary source of concern, of course, was about vilification and, will this particular legislation override Part 2A of the Racial Discrimination Act? I think the clear answer is no, but that was a secondary concern and it was addressed. And I even took some of the representatives of those organisations with me to meetings with officers at the Attorney General's office to explain their concerns and to hear out what or have the Attorney General hear out what their concerns were. And a lot of these concerns now have been accommodated in the bill itself or in the explanatory memorandum.
So that was the process we went through. Having said that, look, there will always be people in any community who will have a different view, who will interpret things differently, but I would say overwhelmingly the response has been that they support the position we put to you, and that is a mainstream view of our community.
Just on that, one of the things you mentioned in that answer was that basically many of the organisations, including aged care homes and schools and whatever, have existing practices, and this is not something that there is a desire to do something new. This is an existing practice from a faith-based community that is potentially going to be codified, and so would you say it's fair to say that these laws are not enabling anything new, but rather this is already going on in Australian society? There's nothing extra being added by introducing these laws.
Look, from the point of view of the Jewish community, I think that's broadly correct. The one thing that has exercised a lot of comment, and Senator questioned me about this earlier, is the over 17 of the Tasmanian Anti-Discrimination Act. But that's just in Tasmania, and I do think that there is legitimate argument about what the true scope of that will be. I don't believe that it will be as significant as has been suggested, but time will tell, and there'll be periodic reviews. So we'll see. But in terms of the rest of the country and the override of anti-discrimination law, and it's only the discrimination provisions of anti-discrimination law that are overridden, I think the band of impact will be extremely narrow, and I've given the reasons for that in our submission. And I think that generally the country is not going to be radically different after the enactment of this legislation compared to what it is now.
So so my final question, and just to sort of flip things, right? So if it's not changing it, and I think where there is universal agreement from every single person that I've ever spoken to about this bill is that there should be protection against people of faith on the basis of discrimination. There shouldn't be any discrimination of anyone in Australia on the basis of their faith. I think I'm yet to meet someone who disagrees with that component. As you say, there are sort of more contested aspects of the bill, but broadly, you think the impact will be minimal. Then the sort of obvious question is, would it, do we need the extra bits in the bill? Is it not simpler and cleaner to not have that? Does the ECAJ have a view on is this more trouble than it's worth? Obviously, there's been 2 iterations of the bill that the government has dropped. Is there not an aspect of trying to solve something that isn't a problem already, in your own words?
I don't think that's the case, if I may say so. I take my lead from the Ruddock Review, which said that there needs, if you're going to have if you're going to have a law which prohibits discrimination on the grounds of religion, then by definition almost, you are going to need carve-outs for religious organisations which practice positive discrimination, if I can put it that way, in the sense that they look after their own adherents and give preference to their own adherents in various ways. It's not directed against any particular group, but it is a situation where faith-based organisations are looking after a particular need within their own faith communities. For example, if there were no Jewish schools and we only had public schools and there were no private schools, just for example, well, there'd be no opportunity for Jewish children to obtain an education in their own faith and their own tradition and their own heritage other than outside the school system. So it wouldn't be incorporated into their overall education. It would be something
separate. And that would be, I think, a retrograde step. We've had Jewish schools in this country since the 1940s. And again, they're no more controversial than any other faith-based schools. They are there to ensure that Jewish children have a good secular education as well as a good grounding in their own heritage, and that the two are not regarded as compartmentalised, but that they are combined. So that's really all we're seeking to do, and seeking to see this bill achieves, is to continue the opportunity for faith-based institutions to operate in a way that they have, without controversy for a long, long time. There's very little that will change, but the importance of the bill is that it will make a very strong statement that religious discrimination, that is, discriminating against a particular religion per se, is wrong. And it will also make another important statement, I believe, that religious freedom is so fundamental and is so bound together with other freedoms, such as freedom of expression and freedom of association, that it is only to be interfered with when it is really necessary and demonstrably necessary to avoid harming the fundamental rights of others. That's what the International Covenant on Civil and Political Rights says, and that's what the Syracuse say.
Thank you very much. Thank you, Mr Burns. Ms Hammond.
Thank you. Thank you, Mr Wertheim, for your... I'm just very, very quick, because I think you have covered all of this off. A lot of the concerns that have been raised with us have actually, I think you and Ms Abdo have made very similar comments, that you essentially see this legislation as a shield, not a sword.
Yes.
Yeah. Do you have any fears that it could be used as a sword?
I don't believe that is likely, given the way the bill has been framed and given the very detailed exposition of the bill in the explanatory memorandum. However, as I said earlier, it's unwise to be dogmatic about the likely effect of new legislation. And I don't want to fall into the trap of others being dogmatic about it. And that's why I believe periodic review is wise, why our submission recommends it.
Yeah.
And although I think it's highly unlikely that it will have the deleterious effects that some have claimed, I don't want to be so dogmatic about it as to rule out any future adjustments if, in practice, the bill turns out to work an injustice and operate as a sword rather than a shield.
Yeah, and so that's effectively what you and I think have been presented to us by other faith groups earlier. It's about the freedom to be, as opposed to the ability to persecute somebody else for their beliefs or views or how they live their life or themselves or some natural aspect of them. That's what you are seeking, and you think that this bill delivers that?
I believe it will, yes.
Yeah, but without being dogmatic, because no legislation is perfect, and I agree with you fully that any legislation should have review in it, so for unintended consequences. Thank you very much. That's all I have, Mr Wertham.
Thank you, Mr Wertham, and thank you for...
I've got one question.
You can, I'm sorry, you will have to take a question on notice because we're out of time. Thank you.
It could be a one-word answer.
Yep. Okay.
So I understand your position that Section 12, subsection 1A would not override Section 18C. And as you said to Senator Rice, the explanatory memorandum supports your position. But Section 12(1)(c) allows the AG to make regulations listing other laws that statements of belief will no longer have to comply with, provided the statements of belief are not, among other things, malicious. And Section 12(1)(c) does not say the Attorney-General may only prescribe laws that relate to discrimination. So isn't it possible that the Attorney-General could prescribe and therefore override Section 18C of the Racial Discrimination Act using Section 12(1)(c)? And do you have any confidence that the current or a future Attorney-General would not exercise that power in that way? And feel free to get back to us. Or it could be a one-word answer.
I feel confident that that will not happen for
two reasons. One is because the explanatory memorandum is very explicit that there is no intention to override Part 2A of the Racial Discrimination Act. Secondly, I've been through two campaigns where the federal government has attempted to water down or repeal provisions of the Racial Discrimination Act, and they both failed.
I remember them well. Thanks, Chair.
Do you still want me to take that question on notice? Because I don't think I can add to what I just
answered
said.
it.
Thank you.
Chair, can I put one on notice too? I just note in the
Briefly.
submission that's just arrived today from Equality Australia, at point 3 in their submission, they indicate that religious belief and activities share some similarities with other protected attributes such as race, sex, disability or age, but they also differ from other protected attributes. Legislating prohibiting discrimination on the grounds of religious belief or activity needs to contend with these key policy considerations. You are one of the few people today who's mentioned the Syracuse principles and the way in which these fundamental rights might intersect. Could I ask you to, on notice, critique the claims that are made about the differences between protected attributes and the fundamental nature of religious identity or not, and a few other claims that are made just in that document today? Some religions are dominant while others are not. You are a minority religion according to this.
Yes.
It doesn't seem that way from your evidence, I have to say, Mr. Wertheim, but I am interested in your response to the claims that are made there. Thank you.
Well, I'd be happy to provide an answer if the submission could be to me. I don't believe
Yes.
I've seen it.
Thank you.
I have spoken with representatives of Equality Australia. I respect their views.
Yes.
I respect their people much. I know their concerns are genuine. I'm not in any way suggesting otherwise.
Agreed.
But that doesn't mean that we have a concurrence of views about these matters. So if that could, even if it's just that particular paragraph you want me to respond to, could be made available, I'd be grateful and be happy to provide some response to it.
Thank you, Mr. Wertheim. Thanks,
We
Chair.
will make sure that happens, Mr. Wertheim. Thank you for appearing before the committee today and giving your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 7th of January 2022, and of course we will get the material to you as soon as possible. Thank you. I now welcome representatives of the National Catholic Education Commission. Welcome to the Honourable Jacinta Collins and Mrs. Egan. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Thank you. For the Hansard record, will you please state your full name and capacity in which you appear today?
Thank you very much, Chair. My name is Jacinta Collins. I'm the National Executive Director of Catholic Education, and with me is Sally Egan, who's the Deputy Director of the National Catholic Education Commission.
Thank you very much. And I will hand to the Deputy Chair for the first interrogation.
Thank you.
That's a joke, Hansard.
And I do declare that I have worked at Catholic schools and my kids go to Catholic schools. So, Senator Collins, sorry. Well,
you've done it now too.
Jacinta, the submission of the National Catholic Education Commission makes comment on the example provided under Note 1 of subclause 7.1 in the bill. The note says that it is not discrimination for a religious primary school to require all of its staff and students to practice that religion, if such a requirement is necessary to avoid injury to the religious susceptibilities of people of that religion. The NCEC says that that example is, and I quote, not in line with the reality of Catholic schools. Could you explain to the committee how the practice at Catholic schools differs from that example?
Thank you, Mr. Perrott. Yes, Catholic schools have been delivering education in Australia now for 200 years. We've celebrated the bicentenary this year under COVID conditions, but throughout that period of time we have delivered education to Catholics and students of other faith and none Our concern is to be able to continue to operate with a critical mass of staff and students that are in sympathy with our faith, but we continue to provide what you might call a common good, which is to educate students of any faith or none.
Did you use critical mass deliberately, or is that just a...
Oh, deliberately, yes.
Yeah, in the physics sense.
Oh.
Okay. Despite the practice at Catholic schools, does the Commission support other religious schools managing their schools as described in the example given in Note 1 of subclause 7.1?
Look, Mr Perrott, there may well be some of our own schools that preference exclusively, if I could use that word. In the main, we do not. We respect that some other faiths might. Indeed, the Jewish faith, from the previous witness, may in some instances. We would respect a faith's ability to preference in such a way, but we wanted to point out to the committee that's not the reality of how we operate.
Okay. And I think you heard the evidence given by the Executive Council of Australian Jewry in total, and if you remember my question right towards the end, and it's such to the role of the Minister, but I'll read my question. The submission of the Commission says, it holds no significant concerns that conduct engaged in by an educational institution must be in accordance with the publicly available policy, as provided in Clause 11. Many submitters to the committee have shared concerns about delegating such authority to the Minister or future Minister to determine the content of a school's policy. Does the National Catholic Education Commission hold any concerns about that requirement for a policy?
What we've indicated in our submission is the bill isn't clear as to the extent of a minister's authority in that respect. We can understand that a minister should require standards over when and how a policy should be available. As to the content of it, that's a much more complex issue that simply giving authority to a minister might create problems.
So I don't think the Noosa Temple of Satan have any schools at the moment, as far as I can tell, but as long as their statement was clear, you think that would be, and publicly available for their school community, you think that would be something that you guys would be supportive of? So.
Sorry, the Noosa Temple of...
Well, I was trying to pick a very small religion, and there is a Noosa Temple of Satan, believe it or not.
Okay.
That they often appear in the media asking questions about the chaplaincy program.
Sure.
But I could have picked the whatever institution.
Look, Mr Perrott, I am reluctant to get too engaged in some of these somewhat extraordinary hypotheticals. Yeah. A school well, one, would it be a school is the first question. Yeah. Two, would it meet all the other standards around regulation and curriculum is another issue. Yeah. And three, how would it be addressing the curriculum in relation to a broader range of issues than simply what they might want to put in a code. Now, I think that there's a reasonable understanding under this bill that we're talking about established religions and religious principles. Yeah. I think the satanic one is having problems getting registered in Queensland in one way or another, if I recall correctly.
I haven't done any research in that area, as you can imagine. Bad example. Thank you, Chair. But yeah, generally you'd be supported. Catholics have been running schools for 200 years, educating significant students in that time. So, no pun intended, it would be a very broad church in terms of the people that walk through the doors of most Catholic schools.
Look, establishing a code of conduct and referring to the tenets of our faith is not problematic for the Catholic faith. And
the contract between the school and the parent is very clear. No one signs up by accident. They know what the school will be about.
Well, they know what a Catholic school is.
Yeah.
And indeed, in the opening statement I've provided to you, recent research highlights how well respected our schools are as operating in delivering education not only for the public good but also for the transference of faith. That recognition is a very high standard of 80% in terms of Catholics and parents with kids in Catholic schools, so it's not just Catholics, but also the general population at large. 2/3 of Australians support our capacity to preference with respect to students and staff to ensure they're in sympathy with our religious ethos. But just while I'm on that point, if I may, Chair, there's an aspect of some of the evidence that I've been observing today that I think might reinforce this point, and that's the evidence of COTA, where they support the distinction between the provision of aged care services as opposed to those covered by Clause 7. They highlight one issue which is probably a little bit more contemporary than back in 2012, where an exception was made in relation to the delivery of aged care services in residential services, where it had been demonstrated at that time there was a limited supply, particularly in regional areas of Australia, for aged care facilities for LGBTQ couples. And the government at the time dealt with the exemptions to ensure that those services would continue to be available regardless of people's personal attributes. In the education area, in terms of faith-based schools, that issue is simply not an issue. If families are concerned about an education being delivered within a faith-based ethos, a well-established one that's been operating for 200 years, they can choose a secular school. If people don't want to work in an environment which is operating within a faith-based ethos, they can work in a public school or a school of another ethos or faith. It's an issue of choice, or in my view, it's actually an issue of freedom of association. Listening to the previous witness, freedom of association is the critical word. If you look at the submission, and I've only been able to see the brief submission of Equality Australia, and you replace associate with some of the ways they use discriminate, that describes what we seek to do in our schools. It's associating around our faith so that we can meet our mission about the transference of faith, at the same time as delivering a high quality education. And I thought it might be helpful just to give the committee this concept. If you look at the definition of discrimination, it's actually there's two different definitions of discrimination. One is to take unjust action against someone, but the other one is to discern or to differentiate. And in our schools, what we are seeking to do is differentiate how we provide education so that it can be done within the broader aspect of a faith-based ethos.
Thanks, Jim. Thank you. I have one question. How many Catholic schools are there in Australia?
I'll check my actual numbers here. They're in the submission, but I forever forget exact numbers. There are 1,756 today.
And how many students approximately?
777, sorry. 777,000. And 100,000 staff.
777,000. I was going to say 7,000.
777,000.
Okay.
And 100,000 staff. And with respect to those staff, if I might take the opportunity, we hear a number of anecdotal reports about what may be discrimination against staff members. I noticed also in the statement from Equality Australia, and I look forward to seeing the case studies that they indicate may be available, that there are a range of anecdotal reports, and as we highlight in our submission, those anecdotal reports, once you look at the detail of the circumstances, can often relate to other factors. Sometimes those factors are about misconduct, sometimes those factors are about other breaches of an established and published code of conduct. It's very difficult to deal with anecdotal cases, even where they are published in university reports. The Minister in Victoria referred to some peer-reviewed research. I'm yet to see credible research that does provide any solid evidence, particularly in our schools, that we are discriminating against people on the basis of their personal attributes. It's just completely against our approach to the inherent dignity of the human person. We do not discriminate against people by virtue of their personal attributes.
Thank you. Handing to Ms Hammond.
Thank you, Ms Collins. I have to acknowledge that I have had a connection with the National Catholic Education Commission in the past. thank you very much for your presentation and also for the submission. Within that 100,000 staff or employees across the Catholic school sector and 777,000 students, there would be, I imagine, many in there who are not Catholic and or who do not perhaps live their lives fully in accordance with all the Catholic doctrines and tenets.
Yes.
Would be a safe assumption? Yep. How does the Catholic education system deal with that?
Well, it goes back to my point at the outset, which is our requirement is to have staff and students that are in sympathy with the faith-based ethos of the school. And to the extent that you don't have people that want to engage in, a high-level public active challenge against church doctrine, it's simply not a problem.
Right. But if it, okay, so there's that distinction there between high-level antagonism or action against teachings of the church.
Yep.
Yep. Do schools have codes of conduct for staff and for students?
Yes.
Yep. And do those codes of conduct, is your understanding under this legislation, this bill that's being put forward, that those codes of conduct would override the bill or they'd be in simpatico with the bill? Do you have any concerns about the codes of conduct and the bill?
No, we may need to modify codes of conduct to ensure that they're compliant or consistent, but that wouldn't be a big issue or a problem.
Right, okay. And have you got any examples of any situations where you think which show that religious schools or Catholic schools in this instance have been discriminated or unfairly treated because of the ethos they hold?
Look, the main challenge we face in terms of unfair treatment is the Victorian legislation, where religious schools have been targeted and are now required, if this is not overridden, with standards that require us to demonstrate that the intrinsic characteristics of a role require the sympathy that I refer to. And this is the point I made to Mr Perrott earlier, which is our schools operate on the basis that we would want a critical mass of staff that are in sympathy with the religious ethos. And if we need to demonstrate that staff have as an inherent requirement of their role such sympathy, then that's quite a difficult challenge.
Yeah, yeah.
Can I make a point just on that point too? I've noticed with respect to all of the submissions I've seen so far, which includes organisations such as Beyond Blue, probably the only group so far is two of the, inverted commas, expert or lawyer evidence that has suggested that inherent requirements are necessary in Australia. We certainly don't believe so. And indeed, I make the point in the submission, it's actually quite contrary even to the ALP's party platform in Victoria. Their platform is about protecting people's inherent characteristics, not implying standards on schools that only those roles that inherently require sympathy should operate that way.
Yeah. Ms Collins, I'd allow you to go on all day if you want to bag the Victorian Labor Party, but I think I'll get back to the bill and I might hand back to the chair now. Thank you very much.
Yeah, the chair's away, Ms Hammond, so you'll have to put up with me and I won't let you bag the Labor Party any longer. Did Senator Rice?
Yes, thanks.
I wasn't, for the record. I wasn't.
I wasn't either. I was just saying there was a policy inconsistency.
Thanks, Ms Collins. Thanks, Acting Chair, and thanks, Ms Collins. So I wanted to go to, although the related issue of the Sex Discrimination Act, and we've heard that there are deals being done to, as part of support for this legislation, to the proposal from the Minister to remove Section 38(3) of the Sex Discrimination Act. So I get your response to that proposed arrangement that's been proposed.
Okay. Well, the first thing is I'm not sure what arrangement has been proposed.
Nor am I.
So we're all second-guessing what may or may not have
Except
occurred
for some
there.
members on the Liberal backbench, they might know.
The second point is the Sex Discrimination Act is quite distinct from this legislation and indeed its purpose, which is addressing religious discrimination, not the various other elements of discrimination covered by the Sex Discrimination Act. And in thinking about this, I was thinking of the state funeral recently for Susan Ryan, who I would say was the mother of the Sex Discrimination Act, and the course of history that's occurred since then. It may well be sensible to change the name of the Sex Discrimination Act at some point in the future as well, so that it reflects the various attributes that are now covered by it. In respect to Section 38(3), I've had what I'd call a relatively cursory look at that, because again I've been waiting to see the facts of exactly what may or may not be proposed. And Section 38(3), looking at it on the face of it, does appear to be limited to students, in which case the considerations might be a bit clearer than if we're talking about some broader issues. But whether there are unintended consequences in terms of other provisions in the Sex Discrimination Act, I couldn't tell you at this point in time. So I would say in terms of the Sex Discrimination Act, we didn't propose the process that this government took in relation to the Australian Law Reform Commission. We did engage with them at the outset and were ready to participate in their consideration of some of these broader issues, and were happy to. If there's some other process by which these matters can be addressed, we're happy to engage and discuss our concerns with what I would characterise as relatively clumsy exemptions in the Sex Discrimination Act that leave our schools, frankly, prone to the sort of criticism that we believe is quite unfair, or the targeting by, most recently, the Victorian government, which we think is quite unfair. Our schools have provided a public good in the Australian community for 200 years, and we do not seek to discriminate against students by virtue of their personal attributes.
Okay, so that's, you feel that that's unfair. Let's go to staff, and in this bill, there's, you know, it says that religious schools should have the choice to choose to employ people whose religious beliefs will uphold the religious ethos of their organisation. And then the intersection with that, with staff's attributes of being same-sex attracted or gender diverse. And does the Commission feel that schools should have the ability to sack staff if, for example, they decide that they wish to marry their same-sex partner, or if they wish to transition?
Well, we would have a mixture of circumstances across our 100 staff that might relate to that question, and they've all been managed in different ways according to the different circumstances, on a case-by-case basis, with compassion, understanding and respect. This is one of the reasons why only very vague anecdotal examples of these sorts of cases exist, because as Catholic organisations, we value our staff, and we respect that even in one instance, a staff member who has chosen to come and work in a Catholic school, their circumstances may have changed. I noticed that in some previous evidence to, I think it was a New South Wales inquiry, one of the examples refers to a Catholic principal who has chosen, by virtue of a mixture of circumstances, to move to be the principal of another Catholic school. Now, we don't know, looking at that particular case example, whether that choice was made actually by the principal because that was their preference to manage, for instance, local bigotry, or if it was made by the employer. Until you get the full details of the cases, it's impossible to suggest there's solid evidence that we discriminate against people on the basis of their personal attributes.
But you say that it will be, that these cases will be considered on a case-by-case basis.
Yes.
So in some circumstances, you think that it would be acceptable for Catholic schools to sack a teacher because of their sexuality or their their gender identity.
Well, again, I wouldn't go into a hypothetical about a sacking either. There are a range of reasons why an employer would take disciplinary action against staff if they breach the school's code of conduct. And you may well have staff who sign on to a code of conduct who subsequently decide for one reason or another that code of conduct is not acceptable to them anymore. That's something that we need to balance as organisations and treat people with dignity and respect.
I will take you to some of the stories. We've just been given a copy of the submission from Equality Australia, which is very comprehensive, and we're going to be talking to them shortly, and which is signed by some thousands of people with personal stories from the signatories. Just looking through that, this list, you've got many cases here of teachers at Catholic schools. So, I mean, one person who says, as a 14-year-old bisexual, I was struggling with a range of unrelated social anxiety issues in a Catholic school. There was a particular teacher who noticed that I was struggling and worked to have me included in some extracurricular activities. He helped me immensely. A few months later, he was sacked when it was discovered he was gay. He was an amazing teacher and he was robbed of his place in his profession. Another one, I was not...
Sorry, that's a second-hand report.
Well, it's a submission that's been included with us.
Chair, could I ask we deal with this issue on notice? I've not seen the cases that Equality Australia is presenting,
absolutely.
and I cannot deal with, on a case-by-case basis in this fashion, the veracity of the sorts of reports that are like the one just covered.
NCEC doesn't employ people.
Not directly,
It does funding.
No.
So, I mean, they don't do dismissals. So.
No, but Mr. Perrott, can I give you one example? One of my former political colleagues spent many years working in industrial relations in one of our state authorities Melbourne actually, so one of our authorities that does directly employ teachers in industrial relations. And when you raise with a person of this standing, what's your view of these cases? They say, well, they're unknown to us. Now, that doesn't mean local bigotry doesn't occur. In fact, our Catholic schools spend a lot of time, if you talk about your previous witness, educating people away from bigotry.
Exactly.
And that doesn't mean we don't have to manage examples of that, again, on a case-by-case basis with respect. But because we've been operating under fairly clumsy exemptions of the Sex Discrimination Act, there's been no way to verify or establish case law or any of the factors you might deal with if we dealt with religious liberty in a different way in Australia.
So I will ask you, Ms Collins, to have a look at these cases in the Equality Australia submission and to take them on notice. And because I am worried about your immediately questioning the veracity of these accounts. I mean, somebody else who said I was not employed by a Catholic school because of my sexuality. My wife was told point blank...
Senator, can I get you, please, to put these on notice as the Honourable Jacinta Collins has requested, and we'll need to move on because we are running out of time.
Could I just summarise then? I mean, without going to the particular cases, just to clarify that, I mean, there is a dozen here statements of teachers who are employed at Catholic schools who have lost their jobs because of their sexuality. And my overarching question is whether you feel that in certain cases, on a case-by-case basis, is an acceptable outcome and should be acceptable under federal legislation.
Well, I think the first point is you've mentioned a dozen cases. That's very different to how you described the number of cases earlier. A dozen cases in the context of 100,000 staff and second-hand reports makes it impossible for us to verify them. Now, I will look at what Equality Australia has provided. I respect quite a lot of the work that they do, but to date, and this is why we say in our submission, there is no solid evidence. The standard of evidence in this area has been constrained by the nature of regulation and by the character of the cases that are run in the public realm. We are very clear in our position. We do not, in our schools, discriminate against students or staff by virtue of their personal characteristics, but we do expect our staff to operate in sympathy with the religious faith that employs them.
Thank you. I believe, Mr Burns, you have a question?
Sure, thank you, Chair. Sorry, I was just leaning back on my chair and good afternoon, Ms Collins, and thank you for appearing before the committee. I guess one of the points of evidence that was raised by the Executive Council of Australian Jury was that actually not much would change if this law was enacted, and I guess I'd sort of seek your view. Is that already I would assume that Catholic schools and the Catholic education system, the whole point of them is to impart a Catholic education and to to give a young person all of the lessons and guidance and ethos that comes with that. In your view, if these bills are enacted, is there anything really that's going to change to the practice that already exists at the moment in Australia?
No, I don't think a great deal would change, other than, as we indicate in our submission, we would be, and I think you made this point earlier, codifying the relevant sections of Article 18 of the International Covenant. And I'd like to remind members of this committee what two components of that are. D is to enable the establishment of seminaries or religious schools. And E is the right of parents to ensure the religious and moral education of their children in conformity with their own convictions. We don't have that codification currently at a national level, and we're concerned about the erosion of it in some state jurisdictions. The most recent and obvious example, Victoria, where we will now be required, again contrary with Labor Party platform, to demonstrate that it is an inherent requirement of a role that sympathy with our faith is required for a position. That's like tying the hands of a religious organisation behind their back and saying, go teach.
Can I just clarify, you're referring to Victoria's state
Yes.
platform as opposed to the National Party, Labor Party federal platform?
Yes, there is also a distinction there, Senator. The Labor Party federal position was established quite clearly back in 2018, supporting the role of religious schools and their capacity to preference. Earlier than that, the platform position about, I suppose I could bring to the committee's attention as well, the harmonisation of anti-discrimination law. So at the moment we're dealing with a gap, and part of the commentary in the hearings today is about, well, whilst we're filling this gap, how does that fit with all the various other anti-discrimination elements? And that's why the Labor Party for quite some time has had a policy that we should try and harmonise across state and federal jurisdictions and across the various different characteristics that you might want to defend, that we would try and harmonise those. So again, with this bill, we're addressing one, which is religion, which has been a big gap for a long time. We're struggling because we've been operating in an environment where we just have exemptions under the Sex Discrimination Act rather than direct protections. Harmony in the longer term would be an objective I'd encourage both major parties to pursue.
My final question.
Thank you.
Sorry.
Go ahead.
Do we not have time, Chair? Or?
No, go ahead.
Rightio. It's standard Zooming delays. So I guess personally, Ms. Collins, I'm a product of both government and Jewish education, and one of the things that was sort of made clear to me was especially in the Jewish education system, there are obvious subjects where having someone with a deep understanding and connection to the religion would make sense in the teaching of that class. But there are other subjects where, frankly, it was probably more likely that my teachers were Catholic than Jewish. Chemistry, mathematics, these sorts of things being the obvious ones. I guess it would be beneficial to hear, why does the Catholic Education Office feel that those sorts of subjects need to, other than the sort of obvious respect for the school and the values of the school, which I fully appreciate. Why does it need to go beyond that? Why is it at all relevant to a teacher's characteristics if they're teaching mathematics to your students?
Well, I'd refer you to our submission where we give you an example in case law of one of the areas of difficulty here, and that was referred to by your colleague in his earlier evidence too, which is the right to preference in terms of, for example, people that occupy positions on your board. Now, that's been a contestable and many years difficulty to establish. But in terms of our schools, you're right. Some roles require more than others. People to have a higher level of either education or sympathy, and we manage that on a day-by-day basis. The difficulty with the Victorian legislation, though, is some interpretations of it, and it remains unclear. Some interpretations of it suggest that it would only be the principal and the deputy principal that would meet an inherent requirement test. Now, that would be a problem. Well, and again, why is it an inherent requirement? The party's platform position is about protecting the inherent characteristics of teachers. It's not about roles having inherent requirements. It's just a level of interference by the state that is unnecessary and unjustified in our operations. Perhaps if I might give Ms Egan an opportunity to comment. She has worked across Catholic schools, other faith-based schools, government schools, and other independent, and I think even possibly non-faith schools. And these issues are not a mischief. There's not an issue with allowing the schools to respectfully work within the ethos, whether it's faith-based or other-based.
Philosophically.
It's freedom of association.
Yes, so following on from that, Ms Collins, look, I think having had the privilege of working cross-sectorally in New South Wales, in all jurisdictions, there hasn't ever been, in my experience, an opportunity for a teacher to feel undervalued or disrespected in any faith or non-faith school. In relation to our schools in Catholic education across the country, all our teachers are employed, whether they're Catholic or non-Catholic, but I suppose there's a very strong understanding, as already suggested today, that our teachers and our staff in our schools support the ethos of the school. That is no different from my experience to any faith or non-faith based school in the experiences that I've had in New South Wales.
And we have Senator O'Neill.
Thank you.
With two questions.
So,
2 minutes.
Having been a teacher in Catholic schools, a product of Catholic schools, and taught in non-Catholic education institutions, preparing teachers to go into multiple sectors, I have to say perhaps one of the best experiences of teaching was teaching 2-unit religion in a Catholic school, which is the phenomenological approach to understanding of religions, all religions. So, Mr Wertheim, I think, was on the money. Education is critical. That being said, I don't know many saints in the Australian Catholic system, except maybe Mary MacKillop. The rest of us are just a community of faithful trying to do the best that we can. And can I go to that concept of what the ethos is and what that means? And I'm trying to think about it in a way that people might be able to experience and understand. If they haven't had an understanding of Catholic schools, they haven't had the experience. And I was thinking about when my husband cooks Italian sauce and he puts the garlic in, it's kind of like getting to the end and trying to pull the garlic out. You can't, it suffuses the place. That's the idea of having an ethos. It's something that is not locatable in a single action or a single sentence or a single job. It suffuses the education with a particular orientation of faith. Do you have a view about what the current legislation will do in allowing that suffusion of faith? Is this going to help that, or are there critical parts of the bill that you think are a threat to that?
Oh, in terms of this bill, no, it will help that, or it will help us to continue to operate as we have, and it will help us address recent challenges that would limit that capacity. Now, we deliberately put in our submission not only a section about the role of Australian Catholic schools, but another one addressing the freedom of religion and how Catholic schools addresses that. We refer, for example, and I think it's related to your point there, to Pope Francis, where he, in referring to religious freedom, says religious freedom certainly means the right to worship God individually and in community, as our consciences dictate. But religious liberty, by its nature, transcends places of worship and the private sphere of individuals and families, because religion itself, the religious dimension, is not a subculture, it is part of the culture of every person and every nation. Now, I also put in the submission a different reference, which is from Pope John Paul II. And this is, in a sense, a caution to the committee in a way. This is on page 3 of our submission, where he called on the 50th anniversary of the UN Declaration of Human Rights for a collective examination of conscience. He said, "The tendency of some to choose one or another right at their convenience, while ignoring those which are contrary to their current interests, occurs too frequently. Others do not hesitate to isolate particular rights from their context in order to act as they please, often confusing freedom with licence, or to provide themselves with advantages which take little account of human solidarity." And that would be my caution, perhaps in closing, to both extreme ends of this debate.
That we need to come to the middle. Can I put one on notice? One of my concerns today, Ms Collins, it has been the practicality of what is proposed, particularly whether Section 11 and Section 12 will operate as they have been heralded and announced by the government. And it seems to be there's some contention around whether they're actually going to do the job that they're being advanced as being able to do. My concern is that there might be a tit-for-tat, ongoing interaction that would disturb for all communities of faith, big sectors like yours that deals with 750,000 Australians, this battle between the states and the Federation. We've seen it in COVID. We've seen how fraught it can be, that this battle could be set up by the establishment of clauses 11, 12 in the way that they might play out. If you have a quick response, it'd be great, but if not, I'll notice.
Look, Senator, I'd say that's already been happening, and it's been happening, at least to my understanding, since certain elements of the Ruddock Review report were leaked in advance, and that was with respect to students and sexual orientation. And I anticipate it will probably continue regardless of how Clause 11 and 12 are framed. We support in particular Clause 7 under this bill, because it represents a positive reflection of what some have described as positive discrimination. Now, to me, that positive discrimination is really more about freedom of association. And our schools, whilst parents have a choice, should be able to freely associate in how they educate and transmit their faith.
Thank you very much for appearing before the committee today and giving of your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by the close of business January 7, 2022. Thank you very much.
Thank you very much.
I'm also now going to suspend the hearing momentarily. If I could ask the Equality Australia representatives, Anna and Ghassan, to please log off, and we will call you shortly to have you join us again. And if everyone else could please leave the room, that would be excellent. Sorry?
That's not Equality Australia in camera, it's Equal Voice.
No. Now welcome representatives of Equality Australia. Welcome Ms Anna Brown and Mr Ghassan Kassasia, I hope that's correct, via video conference. Can I confirm that you can hear me?
Yes, Dr Webster, we can hear you. I can hear you anyway.
And I can too, and that was the correct pronunciation. Thank you.
No worries at all. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. You can just nod. Awesome. Before we begin, could I ask each of you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
Anna Brown, CEO, Equality Australia.
Ghassan Kassasia, the Legal Director at Equality Australia.
If you've provided a written opening statement, and I believe you have, would you like it to be incorporated into the Hansard record?
Very happy for that to happen. Thank you, Chair.
I will flag with you that the petition that you have, we are holding in confidence. We'll discuss that as a committee further, just because of our own protocols. I invite Senator Pratt to begin the questions. Thank you.
Thank you, Chair. I'm going to begin. I understand you've got a range of concerns around the bill, and I know some of these aspects are covered in your tabled opening statement. The principle of protection on the basis of religion. What's Equality Australia's position on that, please?
Well, our principal submission is that our laws should protect all of us equally, and that includes people of faith and indeed people of any belief. But unfortunately, this set of bills fails to do that. And for that reason, we argue they should be rejected by this committee in their current form.
Thank you. In that context, one of the provisions that's public attention is section 12, a statement of belief provision. The section provides that the expression of a statement of belief does not contravene Commonwealth, state or territory anti-discrimination laws. Section 17 of the Tasmanian Discrimination Act. So I'd like to ask specific questions, please, about section 12.1a, 12.1b and 12.1c. How often, in Equality Australia's view, do state or territory tribunals, the Human Rights Commission, or other, well, it's one or the other, find that statements of belief in and of themselves constitute discrimination under existing anti-discrimination laws? And if you can contextualise examples of discrimination both in the broader context and also more specifically that statement of belief.
Sure. I mean, sadly, we know all too well that the communities that we represent and work with every day, that is lesbian, gay, bisexual, transgender, intersex and queer people and their families suffer discrimination on a daily basis and all of the harm occasioned by that. But I assume you're talking generally about discrimination experienced by our communities in the form of a potential statement of belief?
Yes, in terms of a statement of belief made that constitutes discrimination against, well, constitutes discrimination for the purposes of the protection of the Sex Discrimination Act.
Yeah, and I mean, we can give some hypothetical examples, and we've certainly been, analysing these provisions very carefully because they are, as people have identified, quite complex and uncertain in their effects. But ultimately, the main problem with them is that they're completely unnecessary, and there's nothing like them in discrimination law in Australia that we've seen before. So in order to fulfil the objective of providing that shield, this provision is not necessary. And some of the examples that we've considered that could, depending on the circumstances of the case and the context and the tone and manner of communication at the time, that could constitute a statement of belief that could be protected under this provision are the sorts of examples we've ventilated, such as a disability support worker telling a young girl that disability is the work of the devil, or saying to a queer woman in a cafe that her relationship is an abomination in God's eyes, or indeed a manager saying to a female employee that it's who's experiencing family violence, that it's God's will that she submit to her husband. I mean, the sorts of statements that we've tried to develop to meet these criteria are just some examples of. And I'll just hand over to Gassan to see if he can provide some further.
Just to clarify, that's examples in the context of statements of belief in the existing law, which would now be protected. Are those the kinds of cases that we have seen before tribunals that will no longer be able to come before those tribunals because there's now a defence?
Yeah,
I think it's such a statement.
One comment to make about discrimination law cases is that the jurisprudence is very scarce and limited. I'm sure you've heard this ad nauseum today, but the reality is that there are very few cases. They settle often on confidential terms, and we have very little guidance. And as sort of Michael Kirby famously once said, the area of discrimination law is littered with the bodies of the wounded because so many cases do not succeed. But I'll hand over to Gassan to see if he can speak to the question in any further detail.
So just further to Anna's comments, there's a number of cases that have happened overseas that give us a clue to where this provision may be headed. The case of a professor in the US who refused to use the correct pronoun for a student based on a religious belief that a student, this particular student's gender identity was not in accordance with what he believed it to be. So that was an example of he misgendered the student. And that was an example that was accepted as being a form of discrimination in the way that education was provided to that student. The courts here, particularly the federal court's case in Gamma, talk to when speech can constitute discrimination. And discrimination laws already provide ample room for people to discuss things. So they don't prohibit, but they do prohibit speech that then constitutes discrimination because it, for example, imposes or impairs the enjoyment of a right to work or the conditions of work or the manner in which a service is provided equally with others. So
there are cases where that statement of belief causes a detriment, and in that sense, it constitutes discrimination.
Yes, that's right. But we haven't actually seen that many cases for the reasons that Anna mentioned, but also because we haven't had a statement of belief clause like this. So there's no, most of the cases that do go are racial discrimination as examples. And so we've got some examples that have used 18C as an option instead of discrimination law because the threshold is offensive conduct, etc. So some of these cases use both grounds for making a case as well. So courts might not always deal with it under general discrimination protections, but look at it through the prism of 18C.
Can I ask, you might have heard the previous witnesses from Catholic education referring to a sense that discrimination in Catholic schools doesn't, sorry, that's not quite the right way of saying it. They were saying that the exemptions are clumsy. Is that something in the context of where perhaps the Sex Discrimination Act has exemptions to it that contributes to, one, a lack of visibility of this issue, which the Catholic Education Commission also highlighted was true, but also means that there's a lack of data and understanding about what these issues actually look like at the coalface?
I'm happy to answer that. And this is actually a really good example of the way that law on paper is one thing, but when we assist people in recent times, several people who've lost their jobs, either based on a religious belief around sexuality or based on sexuality, very few of them have taken cases forward because of those exemptions, which means that the risks to them of losing is greater than the reward of potentially succeeding. When you look at the cost and effort that's involved, the risk of losing, but also the fact that most people have been really traumatized by the experience of being terminated because of their sexuality or because of their beliefs around sexuality.
Thank you, that's helpful, and I'll cover that off with the education unions later. In terms of the way the draft law departs from the protections available to others, are you able to highlight Equality Australia's concerns around that, please?
Perhaps I'll start at a high level and then Ghassan can offer some further detail. The committee might be aware by now that we have serious issues with these provisions that do go much further than any other discrimination law in the country and are unprecedented. Section 12 is one of them, and we've already discussed it. And then we have provisions that deal with well, I guess Section 16(3), which allows corporations, for example, to use discrimination laws to force their views on others. So these sorts of provisions, together with the provisions around qualifying bodies that are, I guess, an add-on to the protection against indirect discrimination. And Ghassan's going to help me flesh out the rest of the list.
So we've been through the bill in quite a bit of detail. The regulatory bodies clause, which sort of shortcuts the indirect discrimination complaints, and the whole way that the bill deals with religious exemptions is actually quite unusual. And what it does is it establishes 3 different employment legal standards for religious organisations across 3 different Commonwealth laws. So it actually means that the Fair Work Act, the Sex Discrimination Act and the Religious Discrimination Bill, if it's made law, would impose 3 different employment law standards for religious organisations, not even dealing with services, which is even more convoluted about what you do when you've got mixed services. So you're not just a hospital or you're not just an accommodation provider. There are provisions that override local bylaws that give people protection against religious discrimination when that occurs. There are provisions that also expand liability. So Section 70 uses the language of direct and indirect knowing concern in a contravention. The problem with that provision is discrimination law, its purpose is compensatory. It's intended to remedy discrimination that's occurred. And what that provision has seemed to use is penalty provisions that exist in federal law, so penalising contraventions rather than compensating for them, which expands the liability of who's responsible and who might have deeper pockets that you can go after where a discrimination complaint has brought about. And it also includes attempted contraventions, and those are pretty unique. They don't exist in any other federal law. And we've also looked at the related bills that come with the provision, and the provisions that deal with the Charities Act are very unconventional and we would say offensive.
One simple way of expressing the issues around the ability for corporations to sue under this legislation, which is very unusual and I think hasn't been canvassed all that much today in the evidence, is that human rights belong to humans. And so traditionally discrimination law protects the individual against unfair treatment on the basis of a protected attribute. So we're quite alarmed by the inclusion of these sorts of provisions that protect entities as well as individuals.
So what do we need to do to address that? Those provisions are. Sorry, I'll return to a different question. Section 12(1)(b) in the current Act, the draft bill before us, relates to Section 17(1) of the Tasmanian Anti-Discrimination Act, which is an anti-vilification provision. That's a law directed at limiting certain types of speech. Can I ask if Equality Australia knows of cases where a claim has been brought against someone under Section 17.1 that related to religious belief? And if you've got any awareness of how those are resolved?
Yes, but withdrawn. So the usual example that's used is the Archbishop Porteous example. But that was a matter that was withdrawn before it went beyond the complaint stage. And I would say about the Anti-Discrimination Act of Tasmania, they've managed to solve this problem for themselves because the discrimination law in Tasmania has its own exception that allows statements of belief to be made for certain, well, actually broader than statements of belief, things that are done for the public benefit and for other public purposes. And so the Tasmanians have been able to manage and balance the provisions in 17.1 against the exceptions that exist for certain conduct that is done in good faith without the need for sort of this particular overriding provision.
And Senator, we're also alarmed by the fact that the number of laws that can be overridden could potentially be expanded as well. So we're particularly concerned that protections against conversion practices that have been legislated in some jurisdictions across the country. We know that a number of churches have been lobbying for those laws to be overridden, and I'm quite concerned that progress could potentially be undone if such a law was to be prescribed at a later date.
Thank you. Senator Pratt, can you make this your last question, please?
Thank you. In the context of laws being overridden, there's been some debate about whether the government could use this legislation to override Section 18C of the Racial Discrimination Act. That's not something I've heard people of faith advocating for. So would you support an amendment to prohibit the government from prescribing Section 18C by regulation? And how might also those concerns apply to what we're picking and choosing to override or not override, as the conversion practice example shows?
Well, I just think no discrimination protection should be overridden by any federal law. It's an anathema to our democracy that state laws could be overridden in this way, and that these hard-fought protections that have existed for decades in many cases can be, unwound and overridden and undermined by this bill, which purports to protect people of faith, but it does much more than that, sadly, at the expense of other groups.
Thank you.
And those laws...
Go ahead, Ghassan.
Sorry, just to say, I mean, Section 18C is a good example. There's Section 18D, which follows Section 18C. It's its own exception to the section, and it uses language that allows conduct that is reasonable and in good faith for certain purposes. So it's better to look at each law on its face rather than allow an attorney to instruct a Governor-General to make regulations then subject to a Senate allowance process. It's just a very... it's a blank check, really, for future laws to be just overridden like this when democratically elected state and territory parliaments have sought to strike careful balances in their own laws around these much more difficult questions of whose rights and in what context they should be allowed and removed.
Thank you. I have a couple of short questions, and then Senator Rice, you would have some questions. You had recommended that the bill should clarify that protections on the basis of religious belief are not afforded regarding conduct which is unlawful. This has been accepted, and a new subsection of the definition clarifies that the bill does not extend protections to religious activities that are unlawful. Do you believe this is a favourable outcome for individuals who identify as LGBTIQ+.
Gassan, do you want to address that one?
Well, yes, that's definitely welcome, but it's also standard that our laws don't protect unlawful conduct, and that's been the case in every state and territory that's protected religious belief and activity. But there are elements of the law that actually then override what is treated as unlawful. So the statement of beliefs provision converts what is a contravention of discrimination law into a defence against that contravention. So it's not across the board that unlawful activity is being proscribed rather, by this Act, and we would certainly welcome the removal of sections like Section 12 or Section 10, I think it is, that actually override laws that would make it unlawful to discriminate.
Thank you. My final question is, what is your view on the sincerity test that has been included?
I'm happy to have a crack at that. The issue with the sincerity test, so this is in respect of statements of belief, and it effectively allows a person to speak about a matter that they consider to be religiously based, even if no one else agrees with them as to what that religion says about that matter. The problem with it is not that it protects that ability to believe and say what that person believes genuinely, but the way it doesn't then resolve what happens to the person on the receiving end of that statement. And so discrimination laws have generally two principles. One is direct discrimination, which means you treat people consistently, regardless of their attribute. And second is indirect discrimination. You treat people reasonably so as not to unfairly disadvantage them based on their attribute. So that particular sincerity test is used in a provision that then overrides those two principles for everyone else. People with disability, women, sexuality, gender identity, every other attribute. So it's all well and good to say that certain beliefs and expressions of those beliefs should be protected, but you need to then protect the other side of that equation, the person on the receiving end, so that they can work, study, and access goods and services in a way where their lives aren't peppered with these kinds of statements that demean them or offend them in the way that it might happen when we're talking about discrimination laws. Because at the end of the day, this is an act that says what can happen in someone's workplace to treat them fairly or unfairly, or what can happen when they go to the local shop or see their doctor or access a banking service. That's what discrimination law does. It's not about speech per se, it's about conduct that would otherwise discriminate.
Thank you.
And I think it's
just
highlighting the double standard that's inherent in this provision, because it elevates speech about or derived of a religious belief or of a non-believer about a religious belief to a elevated status as compared to other forms of speech. So it does entrench a double standard, which I think is unhelpful in a society where we are trying to bring people together around shared values and equal protection for all. So this is an issue throughout the bill with the barbs that we've picked up, is that it puts one set of Australians' rights above another set of Australians' rights.
Thank you. I'm going to hand to the Deputy Chair, and we've got two more after that, so we're going to have to be succinct.
I'll be quick, and you've just touched on it, Ms Brown, that idea, and it's touched on by Professor George Williams in his submission, in that the bill is inconsistent with Article 18 of the International Covenant on Civil and because the bill provides an elevated status to religious speech but fails to protect speech on matters of thought or conscience. Would you like to comment further on that?
Just that I agree with Professor Williams, as I often do, and that, I mean, it goes without saying, and I'm sure will be discussed further in the committee, that it's often forgotten that the right to manifest one's religious belief in conduct has limits when it comes to clashes with other human rights and the rights and interests of other people. And that's exactly the sort of scenario we're seeing play out with Section 12. And it's exactly where the balance should be struck to ensure that discrimination isn't allowed and those sorts of religious statements can't be used to harm other people.
Well, the other question you also touched on earlier, I think it was you, Ms Brown, the notion that human rights belong to people, not to bodies corporate. I think you touched on that. Would you like to tease that out and what the ramifications might be? I would have thought the clue was in the title, but this is a little bit different.
Yeah, no, and I think it might be useful if Ghassan takes you through some of the potential consequences and scenarios that we go into detail in our submission, just about the level of, I guess, lawfare that can arise with corporate entities and through both the granting of rights to entities, but also the associate liability clauses. Ghassan?
I mean, part of it is it's a little bit unclear because it is unprecedented to have these kinds of protections in this way. But because discrimination law is compensatory in nature, when an individual brings a complaint, the kinds of things that they're seeking is usually reinstatement or damages for lost income or potentially an apology or a restraint on future conduct or something like that. But it's very much directed at resolving the issue for the individual. If you have a corporation on the side of the complainant, suddenly the magnitude of damage that lost business income, as an example, that they can allege becomes much more significant. And it tips the balance in discrimination law, which has been about protecting individual human rights, into an opportunity for businesses to take on other businesses in the way that services are being provided or not provided based on an association with a person with particular religious beliefs. Kinds of examples that we were thinking about were an advertiser, for example, that refuses to accept advertising with views that they don't agree with. Would that be because of the organisation that's proposed the advertising is associated with an individual? So the scenarios that we see here are basically secondary boycott style scenarios where organisations that are associated with a particular individual that has expressed a particular view, like a sponsor who says to an organisation that they have a relationship with, we won't continue our sponsorship with you while you maintain this person employed in your, or you don't do something about the comments made by this person who's employed by you. Those are the kinds of disputes that could be enlivened by a company then being able to bring a claim, not the individual on the employment end of that scenario. So it enlarges the group of people who can be sued for discrimination, but also who is able to sue for discrimination. And these laws are ultimately about, dealing with very human scenarios in a low-cost, conciliation-based forum, and suddenly you've got what is effectively happening now, but with companies wanting to show the values that they are, or being caught by debates by their customers or clients or other stakeholders about the positions that they've taken on certain issues, being foisted into a legal system where their rights and what they can and can't do is going to be mediated by these provisions like Section 70 that deal with liability for people who are concerned in a contravention, and also the ability for an organisation to take direct action for, say, loss of sponsorship or loss of advertising revenue or those sorts of things.
So any similar examples in common law countries or civil anywhere around the world of corporations being able to sue for basically their human rights being infringed?
I'm not familiar with too many. The only ones that I can think of are, for example, the United States, under its Bill of Rights, sometimes gives companies the rights of say, freedom of speech, but we don't have that same kind of rights charter or constitutional charter.
For corporations, it's important that they respect and uphold human rights. That's the way international human rights law applies to business rather than ascribing rights to business.
Thank you.
Thank you. We are literally out of time, so go Senator Pratt. Thank you.
Right. Thanks, and thanks Anna and Ghassan. And I'll try and be quick. I wanted to go to the difference of views between what overriding the state and territory legislation that Section 12 does. We've received evidence today from a range of different organisations that basically said that the sort of statements that your submission says would make lawful, on page 12 of your submission, a colleague telling another colleague that women must learn to stay silent, a taxi driver telling a person with a guide or assistance dog that their dog is unclean, all of these sorts of statements, that your reading of Section 12 is that they would become lawful statements. Others have challenged that and said, oh no, they wouldn't, these sorts of statements wouldn't be legal, that there'd be other provisions that would kick in to enable these sorts of statements to still be unlawful. So I just wanted to get your response to that pushback against what you were saying about these types of statements.
The first thing to say is that this clause operates by overriding discrimination laws. There's just no ifs and buts about it. That's what it does, and that's in essence why we object so fundamentally to it. And there's really no way to improve it. There's obviously the government has developed some drafting which provides a limit and thresholds to where discrimination laws can be overridden. But at its heart, this is a fundamentally problematic clause and should be removed in its entirety. So then we go into I think what I would say is a less important discussion about the scope of exactly what sort of speech is and isn't protected, because by saying that our examples are inaccurate, which we obviously respectfully disagree with, and it's always going to be context dependent in the particular case, we're left with the question of, well, what speech is protected? What speech is discrimination today that is acceptable to be lawful tomorrow? And we come back to the fundamental problem with the clause. So, with respect to Senator, I'm not sure if the discussion is altogether that useful. But in any case, the real damage, I think, that it's occasioned by this clause is the chilling effect it will have and the message that it sends. And we've heard already from a number of witnesses about the importance of the law sending a message. And we know that most people out there aren't lawyers, and even the lawyers are confused about this one. And what will be sent as a message to the community is that it's okay to say things that are offensive, demeaning, and discriminatory to people out there in the community. And from our perspective, that is a terrible message to send, and it will, in practical, I can hear the voice. Sorry. Distressing. It will, in practice, for a manager in a workplace context, when a complaint's, when at the moment, for instance, a colleague says something says something offensive about a gay colleague, for example, and these are the sorts of examples we're seeing day to day, and they may be anecdotal, as Jacinta said earlier, but they're examples we're hearing from our community every single day that, for instance, in our submission, our people submission, a single parent was told by a Christian co-worker that her children were more likely to be criminals. This sort of low, I daren't even say low level, but these sorts of comments that may not reach the threshold that the government has been speaking about. But nevertheless, a manager will feel unable to call out because they will pause. They will say, well, is this religious speech? Can I afford to engage legal here and external legal counsel? Should I just sweep it under the carpet? And sadly, I think what this legislation will do is a whole lot of nasty statements, a whole lot of really awful things that can be said to people in workplaces, in schools, in healthcare settings will be swept under the carpet. And that's at its heart what is so damaging about this provision.
Could I just take you with my final question, knowing that we haven't got any time? The specifics in terms of overriding state and territory legislation, we've heard about the override of Tasmania Section 17, but also the new Victorian legislation in terms of the inherent requirements of people being employed. Could I just ask you to talk me through what impact that would have, why that inherent requirements legislation has been introduced in Victoria, and what impact it would have to have that overridden?
So the Victorian legislation does two things. One is says in employment, if the role is inherently religious or inherent requirement, then you can take into account a person's religious belief. Otherwise, and it has to be reasonable and proportionate to do it. Otherwise, whether or not someone should be employed depends on whether or not they can do the job. And what courts have told us about inherent requirements, and there's been a lot of, I think, misunderstanding about it, is the employer gets to decide what the role involves. They get to draw up, practically speaking, the position description. And so if an employer sets those requirements and says inherent to this role is that you engage in a certain form of religious practice, what the court in X and the Commonwealth told us was you look at it practically speaking and from the perspective of the terms and conditions that the employer has determined. So it really does come down to whether or not that role that the employer has set requires that person to hold every single belief that their employer imposes on them. And what we have seen is those laws have been used to basically purge people based on their sexuality or beliefs on their sexuality. You only need to look at the case of Rachel Colvin in Ballarat, who was fired after 10 years of working at a school because she refused to personally affirm that marriage is only between a man and a woman. This was a woman who was married with 3 children, deeply Christian, working at that school for 10 years, and had a personal religious belief that she was happy to keep quiet that marriage could also be between 2 people of the same gender. And she was counselled and forced to resign. So what the Victorian law does is it says, look, just be real about it. Do you really need someone who believes in 100% of your doctrine in order to perform this role? And that's very different to saying, do you get to say to your employees, these are our policies, these are the ways that we want you to conduct yourselves. Those things are all open for employers to do. They can impose reasonable directions on their employees no matter what their religious beliefs are. The only difference is this law says that for religious organisations, is it reasonable and proportionate for you to impose your beliefs and conformity with those beliefs in every aspect on your employees, or do you give them some space for their own religious beliefs to differ, which is what religious freedom is actually about?
Thank you. I will go to Senator Small now.
Thanks, Chair, and I know we're well over time, so maybe if you can respond to me on notice, please. But in raising conversion therapy, I just want to point something out, and that's that the Prime Minister himself has made some public comment on this, and I quote, "I've never been involved in anything like that. I've never supported anything like that. It's just not an issue for me, and I'm not planning to get engaged in the issue. People should abide by the law, and people should respect everybody else's choice, faith, sexuality and lifestyle." He went on in a different interview to say that, and I quote, "I don't support gay conversion therapy, don't recommend it, never have, but ultimately it's a matter for the states." Now, given that the bill in no way affects the ability of states and territories to introduce laws covering conversion practices, and nor does it impact state and territory laws relating to the unlawfulness or criminality of acts or practices, I'd be really keen to understand why you still have concerns in that area. So maybe on notice, if you can come back, that'd be really useful. Thank you. And thanks for the time, Chair.
Thank you. I'm going to head to Senator O'Neill now, who also has some questions on notice. Thank you.
Thank you very much. I just want to indicate that probably like many of my colleagues, I received a large number of incoming emails, and the title in the box was Religious Discrimination Handmaid's Tale Bill. I have read the novel, not seen the show, but basically it's described as a show that has an extremist theocratic religious organisation that ends up forcing women into sanctioned rape. I have to say, as a person of faith, when I received that, I was quite offended that that was the way that it was constructed. So we are having an important discussion about religious protections, and I guess, do you have a view about the need for religious protections? Because if I heard you correctly at the beginning, you reject this bill in toto. Is that correct?
We said that the bill should be rejected in its current form. If a bill was presented that was fair and balanced, and like the other protections in states and territories that have existed uncontroversially for a number of years, if not decades, then I don't think we'd be here having this inquiry or debate necessarily. Okay. But the problem is the bill has these unprecedented provisions. We're very supportive of protections for people of faith. Indeed, there are, of course, many LGBTIQ plus people of faith in our community, and we work closely with many faith agencies, many individual people of faith, many supportive school principals, and people out there working closely with vulnerable members of our community from faith backgrounds. So we're very much supportive of protections for discrimination for everyone.
So to understand, you actually do accept that there needs to be religious protection because of, you know, the sort of attitude I think that was conveyed in that title, and comments like the God brotherers have no right to impose their vile philosophies on the rest of us. That's kind of the language you want to try and avoid. So you support religious discrimination protection, but not as constructed in this bill, which we know has been, you know, abandoned on many occasions by the government.
Yes, that's correct.
That's your position.
We support protections from discrimination for people of faith, but not when those protections come at the expense of other rights.
And if I could just ask two questions on notice, because we haven't got time for responses. Do you think that Catholic schools should be free to be Catholic and Jewish to be Jewish? If so, how would that look rather than what the government has proposed? And do you believe that parents should have the right to choose a school for their children reflects their values and beliefs? And if so, what would any amendment to this legislation look like that would deliver that freedom to parents who may or may not hold a view about marriage equality that aligns with Equality Australia, but rather a more traditional view of marriage as a religious perspective between a man and a woman? So just that intersectionality of those very different worldviews. What's your response to legislation that would enable a generous accommodation of both worldviews?
Thank you.
Thanks.
If I can get you to take that on notice, please, Ms Brown. The final question that I have is, what role did Equality Australia play in advocating for the Victorian bill? Again, on notice, that would be great. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business 7th of January 2022. Thank you.
Thank you.
Thank you.
I think we've missed afternoon tea. There is afternoon tea if you'd like to grab it. We will continue. I now welcome representatives of Equal Voices via video conference. Welcome Ms. Elise Christian. Can I confirm that you can hear me? I can't hear
yes,
you.
I can hear you.
There you go.
Can you hear me now?
Yes, thank you. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you.
Yes, that's correct.
Before we begin, could I ask you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
My name is Elise Christian. I'm appearing as a spokesperson for Equal Voices, which is a national organisation representing LGBTIQA+ people of faith.
Thank you. If you provided a written opening statement, would you like it to be incorporated into the Hansard record?
Yes, please.
I now invite members of the committee to ask questions. Senator Pratt, would you like to go first?
Rice.
Sorry?
Rice, not Pratt.
Oh, sorry. My apologies. Senator Rice.
It's a long day.
It has been a long day.
That's
Thank
fine.
you.
Thanks. And thanks, Ms Christian, for appearing before us today. And I really want to thank you for your opening statement and your submission, which basically speaks to the really awful experiences that LGBTIQA+ people of faith have experienced such discrimination. So my first question then is, what would you say to the people who are arguing that religious freedom means that they need a right to discriminate, including the right to discriminate against same-sex attracted and gender diverse people?
To those people, we would like to say, please listen to the reality of what that looks like on the other end of what you're proposing and what you engage in. Please listen to the stories of the children, the young people, the members of your faith communities who can tell you what it's like to experience this discrimination and how harmful it has been for many of us.
Could you just outline, for the benefit of the committee now, some of those stories, the impacts of that discrimination in the name of religious freedom on people who are same-sex attracted or gender diverse?
Thank you. If I may, I'll tell some stories from my own personal experience. I was previously employed in a Christian school, and during the time of the marriage equality campaign, when discussions about LGBTIQA+ people were really happening in all the students' churches and families and communities and on the school campus. It was a very difficult time for the students who were gay or trans or gender diverse. In my own classroom, which was a class of 90 students aged between 11 and 13, I witnessed one young Christian student make 2 suicide attempts on campus because he was told by other students that he should just kill himself right now because God hated him and he was going to hell anyway. The students who bullied him in these ways were allowed to continue for some weeks. And when they were finally asked about this by the school executive, they defended themselves by saying, "But sir, I was just telling him what the Bible says." And I could see that the executive staff and the classroom staff had no real response to this. And in fact, it was only when I copied multiple staff members into screenshots of documentation of a number of these incidents that occurred with this student that the bullying behaviour was dealt with at all. And as a consequence of doing that, I lost my job at the school. There was one other student in my classroom who was targeted not so much by his fellow students, but by members of staff. In particular, a member of the school executive said to this student, "You disgust me." And it happened, I found a boy who was 12 at the time in my office, hiding behind the door, shaking and sobbing and saying, "I don't know how to be a different person from who I am." told you about ended up leaving this school at the same time that I was forced to leave. They had to for their own safety, but the school's attitude to them cost them their whole community, their whole social network. They'd both been in the school since kindergarten. They both had multiple family members closely connected with the school. They should not have had to lose their whole community at the same time as hearing these hate messages and then have to go through that alone. These are things that happened in my classroom, but since joining Equal Voices, which I did as a result of these experiences, I've heard many, many similar stories across a range of faith-based schools, from the independent kind to the established GPS kind, parent-controlled schools. In all these schools, there are students who grow up, who may have their own very strong faith, but who at a certain point in their lives realise that they are gay or lesbian or trans or bi, and they in so many cases find no support at all, and in fact are the targets of horrendous abuse. We know that the suicide statistics are clear that these children are at more risk than either the general faith community statistics or the general LGBTIQA community statistics. There's an added risk to their mental health of being LGBTIQA plus in a faith context. And it's because of the discrimination and the lack of support and the abuse that they face.
Thank you very much, and I really do want to deeply thank you for sharing that with us, because I can hear that it's a hard thing to do, to be confronting this level of hate, and I want people who are listening to know that people who are same-sex attracted and gender diverse, that we hear you and that we love you and we love people for who they are. Could I take you to this legislation, and is it your contention then that essentially by passing this legislation it is going to allow that sort of hateful speech to continue in the name of religious freedom?
Yes, that's Equal Voices' belief from having studied this legislation, is that this, if this is passed, it will embolden those people who are already dishing out this abuse to do so knowing that they're in greater impunity than they currently have. Knowing that this legislation takes away what little power students, young people and queer people of faith have in their communities of faith. So I think it will have that effect of emboldening and empowering abusive leadership and disempowering us even further.
And can I ask you, I mean, as a person of faith, my final question, Chair, and clearly your faith is important to you, do you think that it would be possible through, in another way, other legislation, to protect your religion rather than having it sort of being, as it seems to be, being pitting religion against people who are same-sex attracted or gender diverse? Can we protect people of religion without having these impacts?
Absolutely, and I would love to see that kind of legislation. Equal Voices' view is that the best way to bring this about would be a kind of Bill of Rights, but failing that, we would love to see legislation that addresses religious discrimination on in balance with other forms of discrimination, and that protects people and that acknowledges in its framing the particular vulnerability of people who find themselves at the intersection of a number of forms of discrimination. for example, queer people in faith communities.
Thank you. Thanks, Chair.
Thank you. Senator Small.
Thanks, Chair, and good afternoon. I wanted, in light of the evidence you've given today, Ms. Christian, to ask you, I guess, a fairly direct question, but I don't want it to be misunderstood in the motivation for asking. And I guess I just wanted to explore, as an example, the evidence you gave earlier around the very tragic case of a young student who ended up taking their life after being subject to the sorts of hateful statements that you outlined. And I wanted to contrast that against the safeguards in the bill that have evolved over time and on the basis of very extensive consultation with a very diverse group of stakeholders. And I guess the sorts of statements that you relayed to the committee just now don't, in my view, sit well with a test that something must be sincerely held, that the statement must be in good faith, that the statement can't harass, intimidate, threaten, or incite violence. I guess, how do you how do you sort of conceive those safeguards as ineffective?
In our view, the safeguards are ineffective because anything that falls short of, a test for inciting violence can still be defended as a sincere statement of personal belief. And to be honest, if you think it's rare for us to be on the receiving end of statements like "you're going to hell," "God hates you," then please listen to some more of our stories, because it's not at all rare. It's very common, and those are considered to be statements of faith, which it's our belief are going to be protected by this bill to the point where children and young people are going to be more and more hearing those things and without any recourse to protect themselves in a faith-based setting.
Words are very important, and so if I can just play back what you just said then, anything that falls short of a statement inciting violence would not be protected. But that's actually not the case, is it? I mean, when you look at the bill as a whole, requiring that statements of belief be sincerely held in accordance with the doctrines, tenets, beliefs and values of the particular faith, be made in good faith and not trigger any of those thresholds that are mentioned, that in I guess, essence, allows people of faith or people who choose not to hold a faith to participate in our society without being discriminated against for a factor that they can't leave at their front door. In the same way that people can't leave their sexuality, their race, their age at the front door, and therefore those tenets are protected by law in Australia. That is what we're seeking to do here. So I guess I'm just curious as to why there seems to be a sort of a misunderstanding about the intent of the provision.
Well, with respect, Senator, I don't think it is a misunderstanding, and I would refer you to Equality Australia's submission, which Equal Voices has endorsed in full, for a more detailed argument about those provisions that you mentioned. Our submission hasn't focused on the legal details because we have endorsed Equality Australia's their discussion at that point. And we have so many stories from people in our faith community of how badly they have been harmed psychologically and spiritually by statements that are intended and have the effect of harassment and abuse and discrimination.
But wouldn't you also concede that we've heard evidence today that people of faith, particularly, for instance, the constituents we've had in front of us today from the Muslim community, from the Jewish community, and from other communities of faith, that they are also subject to those same,
I'm not sure which feelings you mean, Senator.
So you said that, that it's important that people aren't experiencing things like harassment in the community, which we all agree with. The reality is that there are lots of people of faith who have come before the committee to share their stories of being subject to exactly that. So I guess my question in summary is, do you agree that it is important that we protect people from discrimination on the grounds of religious belief or non-belief, and that the discussion is then about how it happens rather than whether it should happen?
Absolutely, there's no question of that. And since you raised the question of faiths which are in a minority in Australia numerically, I think there's particular need for protections for members of those faith communities. What I don't see is a need to further privilege members of the largest and most powerful institutionally and financially faith communities, which are the Christian communities.
So how
And
does
what
this
we
bill
want
actually
to bring to your
protect Christian
attention
faith
is...
over all other faiths? That seems to be the bill doesn't mention the word Christian once.
No.
It doesn't, but it doesn't need to, because if Christians have the numbers, the power, the institutional power, the history and the financial power in Australia, which there's no doubt they do, then a bill that further entrenches what they already have is going to have the effect of disproportionately protecting statements of faith, whether harmful or not, by Christians over the protection it affords to members of minorities and minority sexuality and gender identities.
So Ms. Christian, I don't mean to take away anything that's obviously clearly important to you, but I'm looking for clear evidence of how this bill would privilege one faith over another, because that's quite frankly a fairly serious sort of contention about the bill that I haven't heard from anyone else.
All right, well, it's because the reason I'm saying that is because the largest number of faith-based educational institutions in Australia is the Christian institutions. The largest number of faith communities in Australia and of religious denominations and affiliations is Christian. And so this bill, as it's framed by especially the provisions that give institutions what is in effect the rights of individuals, further accrues more power socially and psychologically in respect of vulnerable people to those powerful institutions, which happen to be the Christian ones.
Okay, we might have to agree to disagree on that one, but in the interest of time, thank you, Chair.
Thank you, Senator. I'm going to Mr. Perrott.
Thanks, Chair, and thank you for your submission, Ms. Christian, from Equal Voices. In that submission, in your earlier submission to the second exposure draft, you raised concerns about parties being required to take proceedings from a state-based tribunal to a federal court. And I'm not sure if you heard the evidence from earlier from Equality Australia. They touched on this as well in terms of costs and process. Do you have concerns about that, and is it being addressed in the current bill?
Again, I would refer you to Equality Australia's submission at this point, which we have endorsed. But yes, from our perspective, that is another step that we consider further disempowers the ordinary person of faith in comparison with the large and powerful faith institution.
Okay, that's a short, sharp answer, Chair.
Thank you, Senator O'Neill.
Thank you. And as a former teacher, Ms. Christian, can I just endorse your care for your students in the context in which you found yourself? I think we've all been in situations in schools where, values clash, and looking after the kids is the priority number one, and certainly that was my experience in Catholic schools. So can I ask you, when you refer to the Christian schools in the answer you were giving to Mr. Perrott, if you see a differentiation across the spectrum, because, Actually, I applied for a job in a Christian school, and I was told I wasn't Christian because I'm a Catholic. So there are actually some contested views amongst Christians that can vary quite widely depending on the denominations, depending on the the newness of the denomination, etc. So, at the risk of sort of putting the whole lot into one bundle, I just give you the opportunity to speak to the richness of the differentiation across Christians, many of whom small groups would be even smaller than the entire Islamic group. So do you have a nuanced response to that?
Thank you, Senator O'Neill. Yes, it may be true that, for example, the denomination that my former employer was affiliated with was quite a small one in Australia. However, it had powerful connections in the US. And that is often the case with some of the smaller and newer groups, that they may be backed by numerically more and financially more powerful groups in other countries. So that's part of the answer. The other part of the answer is that despite the smallness of an individual denomination or group, there is often, in my experience, a strong sense that our group is in the centre of the Christian tradition, and like you experienced in your job application, that everyone else is not quite Christian enough. So there may be a sort of a sense of numerical smallness on one level that can lead these groups to feel threatened, but on another level, they definitely see themselves in the very centre of the Christian tradition.
Mm. And then we get into the theology of, an ecumenical option or an exclusivist option, and we start to really get into, quite a degree of differentiation. So we're not talking into a clean space. It's quite differentiated from place to place and from faith group to faith group.
Absolutely, yes. Yeah. Christian history and the denominations involved, it's very, very complex. What I can say though, and this is from Equal Voices experience over the last 4 years, is that the stories that we've heard come from right across the spectrum, from Catholic schools, from the older Catholic schools, from the systemic Catholic schools, from the older GPS Protestant schools, from parent-controlled schools, and from the more independent board-run schools, from perhaps more fundamentalist denominations.
And
we've had stories from every kind of Christian school you can think
And because
of.
we've got such a truncated timeline, because, this was supposed to happen in 2018 and then was promised 2019, and then there was delay, and then there was no bipartisan, and here we are, 2 minutes to Christmas, and it's been promised again. But you've only been able to get your submission into us today. We're receiving submissions as we're actually taking evidence to give people a sense of how chaotic this is. You've indicated a number of case studies there. I haven't had a look to see if you've documented those in a way that we could interrogate them for their veracity and, how powerfully they might indicate what's going on in different sectors. But it would be helpful for the committee if you have that, for us to see that, and perhaps to put it to other witnesses who've been before us today.
On that point, could I just? It's quite a difficult matter when you're dealing with very vulnerable, in many cases, minor children, and so of necessity for their protection, many of our accounts have been anonymised.
Right. Okay. Well, we can perhaps deal with that reality when the material comes forward. I just want to go to a comment from Mr. Fowler, who we heard earlier. He says that the bill declares the long-settled principle of international human rights law that the legitimate exercise of religious freedom is not discrimination. And he cites the Australian Law Council and says it has effectively characterised religious freedom as a secondary right. In this contest between rights in a very rich and wonderful pluralist democracy that I love to celebrate in all its diversity, do you have a view about the necessity for this piece of religious discrimination legislation, and what amendments would need to come into play to make it meet the needs of people who are being religiously discriminated against, and meet the needs of people who have no interest in this but will have to operate within a workplace where it's part of their world, and meet the strident opponents of the bill? What does it have to be to actually work, in your view?
In our view, the solution that would be the best and the least complex in the long run would be to start with a Bill of Rights framework rather than another patchwork piece of legislation of this nature. But failing that, any framing of this legislation that doesn't recognise the human cost of failing to cover the intersections between the religious freedom of some and the vulnerabilities to certain types of harmful religious expression of others it's just going to cause more harm. And when people are asking for the right to express their religious beliefs without taking into account explicitly the known and documented harms that can result, especially at this point, of LGBTIQA plus people in faith communities, then really they're asking for the right to cause harm to members of their own communities. And this concerns us greatly. These children and young people and vulnerable people of every age are members of our own faith communities. They are, I would say to these people, they are your own children and your own grandchildren, whether you know it or not. What you're asking for is, because we can see it from the history and the stories that we've heard, what you're asking for is the right to cause harm to your own people and the right to shame and exclude and inflict lifelong trauma on those people who are members of our own communities, faith communities. And I would say that any legislation that addresses religious freedom, which I believe does need to be addressed, and particularly in the case of minority religions, must do so explicitly acknowledging these harms and these concerns.
Thank you.
I just want to say, as a member of a majority religion, I'm frequently very offended by the parodying of my faith. And if I wasn't as brave as I am, sometimes I'd want to be silent as well. So we have to address both ends of the spectrum. There's the limitations on the sense of, being authentic to yourself seem to be impacting on a huge range of people in Australia, and that, that's a problem. So in the absence of the government getting this done, because they've been promising it for so long, I'm sure that you're doing work. So I just wonder if you could put on notice for us the kind of engagements that you've actually had with churches and other religious bodies about the proposals that are contained within the bills. And the Secretary will send you that question. But I'd like to know what work is actually going on, because, we've got a government that's MIA and that might not even come back. Thanks.
Thank you. We'll take that as a question on notice. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 7th of January 2022. Thank you. Safe travels.
Yeah.
See you, Janice. Merry Christmas. Merry Christmas.
Merry Christmas.
Merry Christmas to you too.
Yeah, have a good one, Jan.
They're in person, the next ones? Are they video games?
One is in person.
I just read that in the ACT masks indoors for the night.
That's right, looking around you.
You are, I'm not.
Oh, so sorry.
No, it's my office mistake. I thought we did go back. So, ACT. I better have a test. Yeah, I'm having one at 5:30. My wife's been lined up for 3 hours. Salavi.
Yeah, my staff are saying I might still be in place in January. Oh, I'm hoping not. Yeah, I reckon it will be the next week. Well, if you're really lucky, you might be able to go first. Depends how I feel in the moment. Mr. Greg Bonda is not on yet. Do we need to wait?
Chair, I've just raised the volume. Is that louder?
Yes, thank you. I now welcome representatives of Family Voice Australia and Human Rights Law Alliance via video conference. Welcome to Mr. John Steenhoff, and we are waiting for Mr. Greg Bonda. I can confirm that you can hear us.
Correct. Thank you, Chair.
I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you.
Yes.
Before we begin, could I ask you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
My name is John Steenhoff, and I am the principal lawyer at the Human Rights Law Alliance, a not-for-profit law firm based in Canberra.
Wonderful. And Mr. Greg Bonda, I see that you have joined us. Can you hear me?
Yes, thank you.
Excellent. Could you please also state your name and the capacity in which you appear for the benefit of the Hansard transcript?
Yeah, Greg Bonda, New South Wales State Director, Family Voice Australia.
Wonderful, thank you. If you've provided a written opening statement, would you like it to be incorporated into the Hansard transcript?
Yes, please.
Thank you. I've not read statements.
Thank you. I'll now hand over to the Deputy Chair, Mr. Perrott, for the first question.
Thank you, and it's to you, Mr. Steenhoff. And did you hear the evidence earlier today from the Australian Christian Lobby?
No, I have not been here for all the evidence. Sorry, I'm in travel, so I'm coming fresh without anybody else's evidence having been heard.
Okay. But are you a tenant at Eternity House with the Australian Christian Lobby, or are you part of that organisation?
Yes, correct. We are sister organisations, so we have some common DNA, but they are lobbyists and we're a law firm, so we have different roles.
Okay. So your website has some commentary on the bill currently before the committee, and you have a statement that says, and I quote, "This bill looks very much like any other Anti-Discrimination Act." Do you agree with that statement?
Correct.
Other submitters have said that this bill, because of the state territory override provisions, is a departure from the current legislative framework of two concurrent systems of discrimination law in terms of federal and state and territory. As a law firm, I assume you get clients working in both areas. Would you like to comment on that?
Sure. Unfortunately, all of the commentary on this bill has largely focused on the peripheral provisions. When you look at the engine room of the bill, being the protections against discrimination, those are largely rather unremarkable cuts and paste from the existing discrimination legislation at a federal level. In terms of some of the other provisions that have been had the disproportionate amount of the focus, that would include provisions that override state law in relation to speech. Those clauses are narrowly focused. They have a substantial amount of qualifying clauses, which mean that in terms of their actual practical effect, there's been a scaremongering campaign which largely doesn't stand up to scrutiny when you look at it in application. It's also a necessary part of tailoring your standard discrimination law to fit the unique properties of the attribute that you're protecting. So in this case, we're protecting religious belief and religious activity. They in turn are protected, or their protection is expressed by Article 18 of the ICCPR. And that sets out the framework that Australia has adopted for protection of religious belief, which is very, very broad, which includes
protection of thought, speech and expression. So there are some bits of this bill that are not word for word copies of aspects of other bills, but there are other parts of discrimination bills that are not in this bill. So I have no problem talking to and discussing the particular peripheral provisions that have gotten so much attention and probably have been the main topic of discussion today.
Okay. I was just wondering, when I met with the Queensland Anti-Discrimination Commission, Human Rights Commissioner, now called, I think they said less than 1% of their matters they dealt with. In Queensland, there's been a religious discrimination ground since 1991. So I was just wondering if you have had any experience with taking a client on in Queensland dealing with religious discrimination.
So we've taken on many clients dealing with religious discrimination in Queensland, but not taken formal complaints under the Queensland Discrimination Act. Our most recent discrimination claim that we took was for a foster couple in Western Australia under very similar discrimination provisions. We've certainly defended many discrimination and vilification claims that have been taken against Christians.
Sorry, how many was that in Queensland?
So in terms of matters where we've taken discrimination claims in Queensland, we haven't taken any in the last 2 years since we started running these matters. Sometimes the forms in which we are acting are not in taking discrimination claims. They're employment claims, they're code of conduct reviews, they're disciplinary proceedings at universities. So religious freedom goes far broader than just this one aspect of discrimination.
Okay. Your submission states that the legislation should not be passed without amendment. Can I confirm with you that you do not support the version of the bill as it has been introduced? And your submission also goes to the suggestion by some coalition MPs that the Sex Discrimination Act requires amendment as part of the package of legislation that this bill includes. You don't support those changes. Can you confirm that if those amendments to the Sexual Discrimination Act would become part of the package of legislation, you could not support the package, which I think was a similar, that's why I was asking about the Christian lobby, your sister organisation, because that was a similar question.
Thanks, Member. In terms of the first part of that question,
in terms of being passed without amendment, yeah.
When being passed without amendment, I think there are some oversights and fundamental flaws, and I've identified 3 of those that I think need to be remedied. If the bill was passed, we still support the bill, but we say that what looks like some clear oversights need to be remedied.
So fundamental, as in if they weren't done, you would not support? Is that what you mean by fundamental?
I think they're fundamental flaws in that they should be easy to adopt amendments and they should be largely unremarkable and not controversial.
Okay.
Because there appear to be mistakes with the bill. And they are mistakes which mean that the bill provides less protection than the existing suite of discrimination statutes federally.
Okay.
As to the second part of your question, no.
The Sex Discrimination Act part, sorry.
If there were changes proposed to the Sex Discrimination Act, we would not support that being added to the package or the passage of the bill. We think it would fundamentally compromise the bill if those changes were added to the suite of bills that are on the table now.
Thanks, Mr. Steenhoff. My final question is to Mr. Bondar. Final 2 questions, and they're not dissimilar. Family Voice Australia raises 6 issues of concern with the bill and seeks some amendments. Does Family Voice support this bill without those amendments?
Yes.
Okay, and one of your concerns is that the bill falls short of international covenants, in particular the International Covenant on Civil and Political Rights. Can you explain how the bill should be amended to reflect those international covenants?
I could, but I'd prefer to do that in a written documentation if that would be possible. The whole issue here is that Australia has become signatory to a number of these international conventions and agreements, and we have failed short. Now, I don't particularly want to give, or I can give at this particular stage, clause by clause comparison, but I can certainly put that in as an addition later on if that would be suitable.
That will be fine. You can
Yeah,
take them on notice.
seems to undermine some of the parts, the purpose of oral evidence, but I look forward to getting your submission.
Thank you, sir.
Thanks, Chair.
Can you provide, I'll go to Mr Steenhoff, can you provide examples where individuals have been discriminated against for expressing their faith?
Sure. We have acted for people of faith, mainly the Christian faith, because we're of our natural alignment with the Australian Christian lobby, all throughout Australia and the states and territories on clear issues of religious discrimination. Some of the cases that we've acted on include a security guard who worked for a large firm who was fired for sharing the gospel and talking about his faith outside of work time with another employee who took a complaint against him. Because he was in New South Wales, he had no recourse for what was clear religious discrimination. We have the case of two young Christian ladies who were in a cafe who were reading the Bible together and praying. A patron complained about it and they were kicked out of the cafe, and they would have no recourse to any sort of discrimination claim in New South Wales or in South Australia for that conduct. We have people who have lost their jobs for indicating that they were voting no in the same-sex marriage postal vote in 2017. We've got public servants who have been called up for discipline for stating in water cooler conversations that they supported Israel Folau when he was being mocked by others within a work team. We've got many examples of people who have faced hostility for their faith in the workplace and in the public square for their faith, and you can find those on our website and on australiawatch.com.au.
Thank you. One of the pictures, I guess, that we've had to describe the legislation is that it's a shield, not a sword. In terms of the statement of belief, do you believe that as the legislation currently sits, that it will support people to be able to express their faith and make a statement of belief? We've heard evidence today of other groups that say that it is used as a statement of belief could be used as a sword to harm others. How I guess that, so that's first question. Second question, how can we ensure that the legislation does provide the shield impact without it being a sword? Because it seems to me that we have an issue of contested rights, really, or contested protected attributes that are at stake here, and I'm not sure how we move through that.
Sure. I mean, that's a very good question, because I have been quite surprised by the opposition on that particular clause, which is clause 12 of the bill around statements of belief. The hypothetical examples that have been raised, to my mind, have been quite incredulous and certainly not warranted under that clause. Indeed, it provides very, very limited protection for statements of belief. And that's in two ways. Firstly, what qualifies as a statement of belief that will get protection has to be a very reasonable, very banal statement, which is not causing ridicule, harassment to another person, which does not threaten or demean that person, and which is a genuine statement of someone's sincerely held religious beliefs. So there's a very narrow category of statements that are even going to qualify to come under that clause. And then secondly, the scope of that clause's application is very, very narrow. It's only for a discrimination claim that you get under a state or territory discrimination law. So we act for many people who get hauled in front of tribunals on vilification claims for statements that they've made of their faith in the public square, and an activist has found it and taken them to a vilification tribunal. Those people won't be protected in those statements of belief, because this provision doesn't affect vilification claims. It will only affect discrimination claims and the real important sort of outlier on this is its specific application to the Discrimination Act in Tasmania, and that's with the Porteous protection of Archbishop Porteous, and that's a particular clause that's unique to Tasmania, which makes it it prohibits offending somebody. So to the extent that you have this low bar offend provision, it protects someone from being pursued by an activist like Archbishop Porteous was in those circumstances. So when I look at the clause, when I look at the narrow definition of statements of belief, when I look at its narrow application across the states and territories, I just can't compute that with some of the statements that are being made in advertisements and in the campaigns about the bill to suggest this is going to allow people to make fire and brimstone pronouncements without penalty.
Thank you. And probably, look, my last question is, we've heard quite a bit today about the bill's or the bill's ability to give the Commonwealth the ability to override state and territory laws, and I think you alluded to it then in terms of vilification. But is that actually possible where the Commonwealth would have the ability to override state and territory law?
No, I see nothing in the bill that allows the Commonwealth to override a vilification provision in a state and territory law. I don't think that is actually in the bill. There is a power to be able to, by regulation, apply the provision that protects Christian schools to be able to prefer staff of their own religion, but otherwise there's no other power of override that's been embedded in this bill to my knowledge.
And as long as they've got a public policy statement visible for the whole world to see. Thank you. Senator O'Neill, do you have any questions? No, I'm sorry. Mr. Burns, you are next.
Thank you, Chair. Can you hear me, Mr. Steenhoff? Is that okay?
I can, Mr. Burns. Thank you.
No worries, no worries. So just so I'm clear, your evidence before was that you wouldn't support the bill or the passage of the bill if, in accordance with the public reports that various members of the government MPs had struck up a deal with the Attorney General to amend the Sex Discrimination Act that would prevent students being expelled from school because of their sexuality, that would be a sort of deal breaker for you?
Absolutely. I just wouldn't support the bill being tied to the Sex Discrimination Act. They're two separate issues, and the way that this has been painted as some sort of provision in the Sex Discrimination Act that is giving free rein to Christian schools to expel students, I just think is not a proper characterisation of that provision.
So it's not necessarily that you would support the expulsion of students. It's just you don't think it should be tied up in this bill?
Well, it's providing a solution to a problem that doesn't exist. There's not a huge outcry by students who are being expelled from schools. There's only a huge outcry from activists who want to get rid of this provision, because what it will do is make schools subject to discrimination claims and just make it an activist and lawyers' playground. So I just think the whole thing is a complete furphy, to be quite honest with you, and I'm disappointed that it's got the traction that it has.
But if the opposite were to be true, and that there were cases where students had been expelled from schools and on the basis of their sexuality, on principle, is that something that you think schools should be able to do, or you think schools shouldn't be able to expel a student because of their sexuality?
No, I think schools need to be able to set a standard for both belief and practice that they agree will embody the religious principles that they've been founded on, and which embody the beliefs of the parents who send their students to those schools. Yes, I would be very concerned if there was disproportionate and unfair treatment towards a child who has same-sex attraction, which was not applied to a child with opposite sex attraction. I think the whole way that the question is framed is problematic, It completely misunderstands the reason why those rights of Christian schools have been framed as exemptions in the Sex Discrimination Act. And again, it asks me all the time to engage with a hypothetical that simply isn't happening, which is the supposed mass expulsion of gay students by these Christian schools. And my experience with Christian schools is that they are one of the safest places to be for anyone of any attraction, of any vulnerability, because they largely shield you from the modern preoccupation in schools with activism, with sexuality, with hedonism, with individualism. They provide a moral framework where everyone is safe. And I just have been really unhappy with the way that this has been discussed and framed within the media and within the activist groups who are looking to try to tie this amendment to what is a religious discrimination bill to protect religious freedom. They're just not related.
I guess the sort of most obvious point is that, you know, clearly you had outlined some of the cases that you had represented for, and that you had, no one should be kicked out of a cafe because they're reading the Bible. I mean, that clearly there's an issue there if that's what occurred. No one should be, ideally, no one should be, losing their job on the basis of expressing their religious belief, if it's Christian, Islamic, Jewish, whatever it is. I think that we would clearly agree on the fact that discrimination, and even to the extent in which you are involved, should be actively stopped, and where there has been a case of discrimination, there should be potential legal ramifications in order to protect people from that. And so I guess, why wouldn't that be extended to ensure that, as you say, that's if Christian schools are such safe places, or any school for that matter, I'm not specifically talking about Christian schools, any school to be safe places, why wouldn't you see the same level of protection that you would want for your clients to be extended to students, so that they aren't expelled on the basis of their if their gender or sexuality or whatever?
Sure. I think I've got two answers to that. The first is because the examples that I have given to you are actual examples of real Australians who faced hostility. And the examples that I'm always asked to comment on, like always, are hypothetical examples of extreme behaviour and practices that just aren't happening in reality. That's one part of my answer. The second part of the answer is that this is an inquiry about the human rights implications of a religious discrimination bill, dealing with the religious discrimination, which is the area that I practice in. To the extent that there's issues with the supposed expulsion, the hypothetical situation of the expulsion of a gay student from a Christian school, that is a matter for the Sex Discrimination Act. And it is completely inappropriate to twin that with the religious discrimination bill and tie the two things together, because they are completely separate issues.
I appreciate your comments and your answers. I'll hand back to the chair.
Thank you. I'm going to Mr. McLaughlin. Senator McLaughlin, get it right.
We've received evidence, considerable amount of evidence regarding the supporting the operation of the Victorian bill, and suggesting that the enactment of this bill would unfairly restrain its operation, particularly for Christian schools and the hiring of teachers. And it's been put to us, the Victorian bill, not quite in these terms as the standard, and therefore shouldn't be diminished. So I'm just interested in your views on the operation of the Victorian law, and possibly around the interface if this bill was passed. I rephrase it, the sort of premise put to us, the Victorian bill was an appropriate standard and therefore shouldn't be diminished, assuming a negative interaction with the Commonwealth Act. Have I made sense?
Sure. The bill I believe you're referring to is the Equal Opportunity Religious Exceptions Act in Victoria, which whittled away or withdrew the broad exceptions that religious schools had under the Victorian Act.
Yeah, correct. So I was interested in two aspects. One is the premise that is an appropriate standard, which should be considered sacrosanct in drafting this bill, and then your views on the interplay.
No, I think the Victorian legislation is a deplorable piece of legislation. The problem lies in the fundamental way that we're looking at what is a positive right. So Article 18 of the ICCPR says the states parties present to this covenant undertake to respect the liberty of parents to ensure the religious and moral education of their children in conformity with their own convictions. And that is a fundamental right that is not to be derogated from except in the most extreme of circumstances where it's absolutely necessary. And the way that that's traditionally been reflected in law is by giving religious organisations exceptions from discrimination acts. So what you're doing is framing a very important and very extensive right as some sort of exception under an act which suggests that Christians are getting a free ride or religious schools are getting an exception and don't have to obey laws that others do. And so it's very easy for those to be removed, which they have in Victoria, and it completely ignores the fact that a school, a religious school, is not just about the imparting of brute facts together with the occasional small smidgen of religious training. They are religious communities in and of themselves, and everyone in that community is supposed to be able to uphold, believe, and teach as part of a joint community responsible for the formation of a child into the religious beliefs of their parents in accordance with international rights. The Victorian bill will only allow you to prefer someone of your religion for maybe members of the board, a principal, and maybe a chaplain, and even that's up for grabs. It is an attack on the fundamental raison d'etre of Christian schools. So no, I don't support that, and I do support the provisions in this bill that will put a much better standard in place, allowing religious schools to prefer employees of their same faith. It's minimal consistency with existing obligations under the ICCPR.
Thank you for that.
Senator Small, I believe you've got a question.
Thanks, Chair. Just coming off mute there. I guess I'm keen to ask you, Mr. Steinoff, for your view on whether the protections contemplated by the Religious Discrimination Act in front of us can be compared in any way with the Racial Discrimination Act. Because there seems to be a good deal, sorry, to just add to that, there seems to be a lot of concern from what we've heard today that in some way the Religious Discrimination Act would trump the Racial Discrimination Act.
Sorry, I haven't heard that evidence, and I'm not sure how to engage with it. I've not seen anything in this bill which gave me any concerns about this act trumping any of the other discrimination acts that are in the current federal suite of acts, that being the Sex Discrimination Act, the Disability Discrimination Act, the Age Discrimination Act, or the Race Discrimination Act. But I'd be interested in exploring, or if someone could unpack for me a bit more what the actual override might be, because I just don't see that that is an issue under this Act. It deals only with religious discrimination and not race discrimination.
Well, that's very useful, because I think that the concern is based on a misunderstanding of the bill. But effectively, we've had put to us, and I'll just sort of paraphrase loosely, that because the threshold for offend and insult under 18C of the Race Discrimination Act is a lower threshold than this contemplated by the Religious Discrimination Act, where statements have to be, as we know, made in good faith, sincerely held, in accordance with the doctrines, tenets and values and beliefs, etc., etc. Can't be intimidatory, inciting violence and all that sort of stuff. But somehow there was a gap there that would allow the Religious Discrimination Act to trump or supersede or overplay the Race Discrimination Act, the Sex Discrimination Act.
Sorry, Senator, I just don't think that is the case. I don't see how the two are going to interact in a way that the Religious Discrimination Bill trumps the Race Discrimination Act. In fact, I would say that the provisions that protect statements of belief are so narrow that it's impossible for them to affect the other federal bills, because it says these only apply in relation to a discrimination claim under these state and territory acts and one provision of the Tasmanian Act. And it only relates to religious discrimination, statements of religious beliefs. So I find it difficult to see how that could be the case. But it's not the first out there sort of scaremongering tactic or statement that I've seen in relation to this bill.
No, thank you for that clarification, because I think you're right, and there is a good deal of misinformation, misrepresentation, and otherwise sort of baseless concern. So I guess the obvious question that follows then, given the way that the bill is currently framed, how would people of faith be protected by the bill? Does it go far enough?
So at the moment, the bill is a good start, but it's rather unambitious in terms of implementing the international human rights obligations that Australia has signed up to. So it does provide some protection, but it is rather a boring cut and paste of the protections of the Sex Discrimination Act, rather than a genuinely bespoke protection of those religious belief from religious discrimination. So it's a good start, but it's not anything to get excited about. It's a rather unremarkable bill, and it's created an extensive furor. There are any number of ways, from a litigation practitioner's perspective, that this bill could be improved to make claims more efficient, to make the protections more in line with international obligations. And I could go through 5, 6, 7 of them now, but I have addressed many of those in my submission.
Yeah, you raised the ICCPR and our obligations under international law. So if I could just turn to that rather than rehashing what's in your submission, I think that's a useful point. And we've had some, I guess, widely differing views on the interaction between the bill and Article 18 in particular of the ICCPR. Do you have any comments that you want to make there in terms of that?
So one of the ways that we see a lot of discrimination rear its head against people of faith is not direct discrimination where they say, you're a Christian, I don't like you, get out of here, which is commonly known as direct discrimination. What we mainly see is that there is some rule in a code of conduct that is facially neutral. And that facially neutral rule disproportionately affects people of faith and is used against people of faith in a way it just wouldn't be used against anyone else with another political view or protected attribute. So that someone who, say, was talking about religion at work in a very sort of an unthreatening way would be treated differently than someone who's talking about the football at work. So that's indirect discrimination. Now, the bill provides that you have protection from indirect discrimination where someone imposes a condition. But if, say, it's an employer, they can show that the condition is reasonable, and there's a very low bar test for reasonableness, then your religious discrimination claim will fail. Now, that's really inconsistent with Article 18 of the ICCPR, which says that rights can only be infringed where it is absolutely necessary to protect public safety, order, health or morals, or the fundamental rights and freedoms of others. So the bar for a discriminator to jump over to be able to suppress religious freedom is lower in this bill than it is in the international covenants. And that is one of the major failings, where it does not reflect the ICCPR, and further does not reflect the Syracuse principles, which are the internationally respected principles that set out when rights can be derogated from or overridden, which was part of the recommendations of the Ruddock Review. The expert report into religious freedom said if you're going to pass laws about religious freedom, they should have regard to the Syracuse principles, and they are completely absent from this bill. That's just one area where it's going to provide incomplete protection and is rather unremarkable.
That's been really, really useful. So thank you for all of that, Mr. Steenhoff, and I'll pass back to you, Chair.
Thank you very much. Thank you both for appearing before the committee and for giving your time today. Before we finish off, I'm just going to Senator O'Neill.
Thank you. I just don't want to lose the opportunity, Mr. Steenhoff. I've got a number of questions I'll put on notice, but one of the things I think that is very interesting to people is what's actually going on with regard to Section 38.3 of the Sex Discrimination Act. You've spoken about, why these things should be separated in your view. But the fact is, on the 1st of December, it's been reported by multiple sources that the Morrison government struck a deal with moderate Liberal MPs in its ranks to support the discrimination bill by removing the relevant Section 38.3 from the Sex Discrimination Act. But since the 1st of December, that's been a suggestion that the Prime Minister's backflipped on that. And maybe he has, maybe he hasn't. No one seems to be really clear. In your most recent conversations with the government, Mr. Steenhoff, do you have any clarity about who's telling the truth? Is it the Prime Minister or his backbenchers?
I'm just a lowly discrimination solicitor who sits on my tools all day and gets very little access to government. I've tried to contact the Prime Minister. I've had no success. I've seen the news reports as you have, and I think the latest reports suggest that has not been a deal struck, and that any changes to Section 38.3 are going to go through the review by the Australian Law Reform Commission. I understand that's been the case always, and that I would expect some formal announcement if that was not going to be the case. And I've made very clear my own personal views about how it's inappropriate to try to join the two the two issues together of the Religious Discrimination Bill and changes to the Sex Discrimination Act. I mean, we've had plenty of attempts to try to do a quick and unaccountable change to the Sex Discrimination Act without a proper review. It needs a proper review because there are wider issues involved. And so I hope that the government will honour that commitment was given in 2019 to undertake that review.
But I guess we're at the point now where you are saying that you actually trust the Prime Minister, but we've got to discount the public statements then of Katie Allen, Mr Sharma, Ms Bell and Fiona Martin. All of them have to be telling lies for your current statement to stand up.
Senator, I would suggest
who's telling the truth?
I'm suggesting that that's not a question.
You don't know who's telling the
Mr.
truth. That's the
Steenhoff.
problem in the country.
Thank you.
We can't trust the man who's in charge.
We will go to the Deputy Chair.
Thank you.
Thanks, Mr. Steenhoff. And just to something Mr. Senator Small asked, that whether Section 12, subsection 1C can be used to prescribe Section 18C.
Yes.
I think there was, I think Senator Small had a slight misunderstanding. Do you want to just go back to that answer that you gave before? I just want to make sure we get the record right in terms of whether that could prescribe Section 18C.
You are right
That's all right. That'll do. We can leave it there, Deputy Chair. Chair, sorry.
Yeah, okay.
You are right. That provision does allow the government to prescribe other particular statutes which will be covered by the override for a statement of faith.
Thank you.
And so it's quite possible that it could override Section 18C, but there are certain protections that are built in there where you would have to proceed through government policy and get it through a disallowance in the Senate, which any override of the Racial Discrimination Act just simply wouldn't. I mean, you have a government majority that couldn't even make changes to the Racial Discrimination Act as one of their policies. They're not going to get it through on regulations.
Don't forget, you're a humble law firm, not a Christian lobby. Remember, you're different. Remember.
Thank you, Mr. Steenhoff.
Right.
The committee requests that answers to questions taken on notice are provided to the committee secretariat by the close of business, 7th of January 2022. And on that basis, thank you very much for attending.
Thank you.
I now seek the committee's approval whether to accept the documents submitted to the committee. I changed my tune. That concludes today's hearing. On behalf of the committee, I would like to thank all those who've made submissions to the inquiry and made representatives available today. I would also like to thank Broadcasting, Hansard and Secretariat staff for their assistance today. The committee stands adjourned.